Good morning, ladies and gentlemen. Welcome to our, what month is this? August?
August.
Regularly scheduled meeting of the Tennessee Real Estate Commission. Just a couple of things, and we'll have some other information for you during the day. Some of you may be expecting to be here for 2 days. Our formal hearing tomorrow has been canceled, so this is going to be a one-day event. If you've got hotel reservations or some reason to think that you want to get out of town today instead of tomorrow during the break, I hope you'll take care of that. With that said, you should have no expectation about leaving at any particular time this afternoon. You're here with us until this meeting's over, if you're here for credit or for some particular reason. We will take approximately an hour-and-a-half lunch break starting at around 11:30 Central Standard Time and be back here at 1 o'clock, and we'll have a couple of breaks in the morning, a couple of breaks in the afternoon. We appreciate your attention. We're a pretty casual group of people up here, but we don't want you interrupting our meeting by talking on the phone, playing words with friends, or checking your Facebook account. So bear with us. We think you'll learn something. It's good for us every time we come to these meetings, and I think it'll be good for you as well. During the breaks, if you have questions of us individually or want to introduce yourself to us, I hope you'll feel free to do that. All right, with that said, Ms. Maxwell, Eve Maxwell, who's the Executive Director of the Tennessee Real Estate Commission and has her back to you at this point, has a formal statement she needs to read into the record, and then we'll ask her to call the roll.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 9th of 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Thursday, July 31st, 2014. This meeting has also been noticed on the 10Gov website since Friday, August the 1st, 2014. Now I'll call the roll. Grease.
Present.
DeChara.
Here.
Alexander.
Here.
Bloom.
Here.
Collins.
Here.
Franks.
Here.
Hills.
Here.
McMullen.
All right, Chair rules, we have a quorum. So with that said, at this point, I want to ask Commissioner Grover Collins to lead us in the invocation.
Heavenly Father, we give thee our thanks for this day and all its many blessings. Thank you for this country in which we live and this state in which we live. We're thankful for the opportunity to sell real estate in this state, and we pray as commissioners that everything that we say and do will be according to thy will. In Christ's name, amen.
Thank you, Grover. If everyone will stand, we'll pledge allegiance to the flag. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, members of the commission have seen the proposed agenda. Are there any additions, corrections, amendments that anyone would like to suggest?
Motion to approve. Second.
Is there discussion? All right, let's vote. All in favor of adopting the agenda as proposed, please say aye.
Aye.
Those opposed, no. It is unanimous. Thank you. Next on the agenda is to approve the minutes of our last meeting. They were sent to members of the commission in advance. Is there a motion?
Motion to approve.
Second.
I've got a motion by Commissioner Collins, seconded by Commissioner DeCharo to approve the minutes of last month's meeting. Is there a discussion on the motion?
Mr. Chairman, I'd like to abstain from the vote since I wasn't here.
Thank you. Other discussion? Let's vote. All in favor say aye.
Aye.
Those opposed, no. It's unanimous, and the minutes of this month's meeting will reflect the fact that Commissioner Franks abstained. All right. At this time, I'm happy to introduce to the audience and to some members of staff and to some members of the commission our newest commissioner, recently appointed by Governor Haslam, Diane Hills. So Diane, you've got about 15 minutes to tell us about yourself at this point.
Won't need that. I'm from Kingsport, Tennessee. I've practiced for 24 years.
You have to talk in that microphone a little bit.
I've practiced for 24 years, and I'm just excited to be here.
That's it?
That's it.
This commission is made up of 7 licensees and 2 members of the public. Our 2 public members are not present at the moment. We expect one will be here fairly soon. But Janet, would you mind just quickly telling the audience where each of us is from and get as specific as you can?
Well, okay. Of course, Diane has just introduced herself to you. She's from Kingsport, Tennessee. Then we have Mr. Grover Collins, and Grover is from Cleveland?
I've been in
Lewisburg.
Lewisburg most of my life.
He just lives down south somewhere. And Marcia Franks lives out in Franklin, Tennessee. John Grease lives up in Knoxville. And Gary Bloom lives down in Memphis. And Wendell Alexander is in Dresden, Tennessee. And here comes Austin McMullen, who lives in Nashville, Tennessee, and he's our public member here in the Middle Tennessee area. And I'm from Jackson, Tennessee. So there's 3 from each division of the state, and we currently have a seat open in the East Tennessee area.
Mr. Chairman.
Yes, sir,
Two
Mr.
characters in the back of the room I don't recognize. Would you have me to sit down or leave?
That one character is not paying attention.
Hey,
And Bayard-
We'll wait, Steve. If you want to hold the meeting up, we can wait. Did I see Bear come in as well?
Yes, you
Is he?
did.
Where is he?
He's hiding back there.
To those of you who've been around this commission before or for a long time, Diane took Bear Stevenson's place on commission. Bear still shows up. We're not sure why, but stand up just for a minute, Bear.
He is standing up.
There, again, if you have questions or want to know what's going on during a break, Bear will be happy to answer those as well. He's a fountain of information.
And he'll check his email when he gets home.
And Steve McDonald formerly worked with the Real Estate Commission as Education Director. Now he's the Education Director at the Tennessee Association of Realtors. And Chris Sexton, who's sitting beside him, is the Governmental Affairs Director for the Tennessee Association of Realtors. Neither one are on our agenda that I know about, so I think they're just here to observe.
there was some reason I didn't know who they were.
Glad to have you fellas today.
All right, at this time, to the audience, we've got a series of individuals who would like to get a real estate license in Tennessee. However, they've got some history that they would like to explain and hope that we'll understand their explanation of that history and give them the right to go forward to get a real estate license. This is referred to as an informal appearance, and we've got 4 or 5 of those individuals today. So at this time, I'm going to turn this back over to Ms. Maxwell, who will start and give us who she's got first on the list, give us a little background. If the applicant or that person who wants to be a licensee and his broker or her broker will come up and take these 2 seats right here, Julie Kropp, who you all haven't met but is our counsel, will swear both in. Ms. Maxwell will give a little history on the situation. Then the commission is open to talk to the licensee and that broker to see whether or not we're sold on the idea of letting them become a licensee. Ms. Maxwell.
Yes, the first informal applicant appearance is Mark Andrew Atkinson and his principal broker, Fran Hooten. Are they here?
Mr. Atkinson's not arrived yet.
Hey, let's,
Okay.
He's on his way.
you've just become 5th in line, okay?
Well, no, unless the other person was, by the 9:45 person's here, do you want to
Let's
skip?
see if they're
Oh, let's
here.
see,
Only
okay,
4
let's
first.
go to 9:45 and see.
Okay, Brett Bernard and his PB John Stamps, are they here?
They're here.
Okay. Do you want to jump to them?
Yes, that's
Okay.
perfect. Right up here, gentlemen.
Up here.
Yes. And do us a favor and talk into those microphones. We've got people on this commission who can't hear well. Not you, Wendell.
He'll just turn his up. I wish I could turn mine up.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
We do.
Thank you.
And do us a favor. Who's Mr. Bernard?
I am.
Okay. And you're Mr. Stamps. You're the broker. You're the applicant. Okay.
Correct.
Got it.
Mr. Stamps, John E. Stamps, is the principal broker of the Stamps Real Estate Company, LLC, which is located in Collierville, Tennessee. Mr. Stamps was first licensed as an affiliate broker on 2/1 of 1995 and was first licensed as a broker and a PB on 3/8 of 2002. He has been a PB at several firms and became the PB of the Stamps Real Estate Company, LLC, as of 2/23/2012. The firm currently has 14 affiliate brokers and 2 brokers. Mr. Stamps has had 1 complaint filed against him by the commission, and it was closed with a letter of warning in 6 of 2005. The applicant is Mr. Brett A. Bernard, and he has completed an application for decision regarding prior criminal sanctions in order to seek the commission's approval to proceed with the licensure process in order to obtain an affiliate broker license. In his application, Mr. Bernard revealed the following. On 5/19 of 2005, Mr. Bernard pled guilty and was convicted in the United States District Court, the Middle District of Louisiana, of conspiracy to commit accessory after the fact of felony and accessory after the fact of felony. On the first and second count, Mr. Bernard was sentenced to 2 years of probation. The terms ran concurrently. He also received a fine of $500 and $200 in assessments, which were due and payable to the court upon sentencing. The court issued a partial satisfaction of judgment in regard to payment on 6/13 of 2005, and in June of 2007, Mr. Bernard was released from probation. As to the felony charges, Mr. Bernard stated that his younger brother was convicted of a felony charge and sentenced to 7 years in prison in 2002, but he failed to surrender for service of his sentence at the appointed time for his incarceration. At that time, Mr. Bernard's father had told him that the younger brother had fled to Canada. The federal authorities questioned Mr. Bernard as to the whereabouts of his younger brother, and he did not disclose that he had been told that he had fled to Canada. Earlier, because of his failure to cooperate, Mr. Bernard's father was arrested and confined in the East Baton Rouge Parish Jail. In order to get his father, who had suffered a stroke, released, Mr. Bernard stated that he disclosed his brother was in Canada and agreed to plead guilty to the conspiracy to commit accessory after the fact and accessory after the fact. The facts alleged and to which Mr. Bernard pled guilty were that Mr. Bernard conspired with his father to assist and did assist his younger brother in order to hinder and prevent his younger brother's apprehension and punishment. Mr. Bernard has not had any communication with his younger brother since 2005. Mr. Bernard has worked in the real estate loss mitigation with attorney Leonard Van Eaton for the past 6 years and with Real Estate Mediation Consultants, Inc., and has references which I had sent to the commission earlier from his principal broker and Mr. Van Eaton and someone who was affiliated with Real Estate Mediation Consultants, Inc. And
All
I'll
right,
let-
Mr. Bernard, would you like to fill in any blanks, or?
No, I actually think you did a much better job than I could have done. Thank you. You covered it quite well. That pretty much sums up the story. It was a situation that I was in a family matter with, and my father was in had a stroke, was locked up because he refused to disclose the location of my brother. I found out the location, I did disclose it, and he was apprehended. I've become an outsider with my brother because of that situation, but it was something I did to end the ordeal for my father, who was 70 years old, did not need to be sitting in jail when he could barely walk. But they refused to release him until they identified where my brother was, so that's why I pled guilty to it and turned my brother in, and that's where the charges came from.
Thank you. Questions, commissioners, for Mr. Bernard?
I'd like to ask, what do you do with the real estate mediation consultants?
I basically deal with loss mitigation, short sales, help investors liquidate real estate and deal with the deficiency side of those investments. Once they're sold for less than current market value or at current market value, there's usually a deficiency created. So I deal with negotiating away those deficiencies.
The questions?
Side that you guys don't want to deal with.
You are
All right, Mr. Stamps.
Yes, sir.
So what's the attraction? Why do you want this guy on your team?
Well, we've been working together for the last year, and really, this short sales are a big part of our business, and we've been working together, and I found him to be he's helped me out in our business in short sales, he and his partner, Glenn Green, who's here as well. And I've been encouraging them to get their license. Mr. Green's gotten his license. He's been with me for a few months. And Brett has been trying to get his license. We've been talking about it for a while, and I think that we'd make a good team. We have been making a good team, I should say.
Have you been practicing real estate, or what have you been doing?
No, I was in real estate development in Louisiana, and I bought and sold a lot of real estate personally for myself. And then Katrina happened. I relocated to Memphis, which then I was hired by attorney Leonard Van Eaton, Title Assurance and Escrow, to help in the escrow business, as well as developing a short sale business and dealing with a lot of folks that were in distress with their commercial and investment real estate. That's how I got into doing this back in 2007.
Questions? Chair will entertain a motion.
I'd like to move for the approval of Mr. Bernard's request.
I'll second that.
A motion by Commissioner Bloom, seconded by Commissioner DeChara, that this applicant be allowed to move forward in the licensing process. Is there discussion on the motion? Let's vote. All in favor, say aye.
Aye.
Those opposed, no. It's unanimous.
I would like to thank the commission for your time. Thank you very much.
Good luck to you.
Thank you very much. Thank you.
Let's go back and just see, did Mark Atkinson ever make it here? Okay. How about Margaret Honeycutt? Are you here? Pete Gertz?
Okay, do you want to do the, I can start the education
We're gonna
report if
do
you'd like to do that.
I
until
do. I
Mr.
just wanted to see if anybody's here early. Let me check. Just Deidre McGill
They're here.
and Sue Ace, is there? AC, excuse me. Would you all come up? We'll go ahead and, since you were nice enough to get here early, we'll try to get you out early. This is the 10:30 applicant. Deidre McGill is on the far, okay, and Sue AC is right there. Julie?
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. McGill has taken and passed the timeshare salesperson exam, and she's applied for licensure as a timeshare salesperson. Her principal broker is here today with her, and that's Miss Aki, is that right?
AC?
AC, who is the principal broker at Wyndham Vacation Resorts, Inc., Smoky Mountain. She took Pam Johnson's place. Pam retired. Did she finally retire? She retired about a month ago, and so Sue AC has taken her spot. As I say, she's the principal broker of Wyndham Vacation Resorts. She was Miss AC was first licensed as a timeshare salesperson in 2002 and was licensed in Tennessee as an affiliate broker in 2011 and as a broker in Tennessee in 2014. She was licensed as an affiliate broker and a broker in Alabama prior to becoming licensed in Tennessee. That's not right.
Georgia?
In Georgia. Prior to coming to Tennessee. She became the PB of Wyndham Vacation Resorts, Inc., Smoky Mountain as of 7/1 of 2014 upon the retirement of the former PB, Pam Johnson. The track records reflect that the firm currently has 7 affiliate brokers, 2 brokers, and 104 timeshare salespersons. Ms. AC has 0 complaints filed against her by the Commission for events which have occurred since she became the PB on 7/1 of 2014. Ms. McGill, on her application for licensure, disclosed that on 6/7 of 2004, she was convicted in the Circuit Court of Escambia County, Florida, of 4 counts of fraud. They included offense against computer users, modify without authority computer support, impersonation, use, possession of ID of another person to harass, stalking harassment, and they were all felony convictions. On each of the counts 1 and 2, Ms. McGill was sentenced to 3 years, 6 months supervised probation to run concurrently, 50 hours of community service, no access or possession to a computer connected to the internet, and no contact with the victim or the victim's family, and to attend and complete anger management counseling. For counts 3 and 4, Ms. McGill was sentenced for each to 1 year supervised probation, with each sentence running concurrently with the sentences of count 1 and 2. Ms. McGill petitioned the court for early termination of her probation, and the court granted her motion terminating her probation on 2/16 of 2006. As to the felony charges, Ms. McGill stated that without permission or authorization, she read the email of another individual who had been releasing certain information about her and then writing about it apparently in the email, and Ms. McGill went in to see what was being written and said in this person's email. Since the convictions, Ms. McGill has been a nanny for 2 children and has been involved in sales, and she has a recommendation from her principal broker, the former principal broker, and 3 other individuals.
And for the audience's benefit, we get those letters of recommendation. They won't be read into the record today, but we've got those for review. All right, Ms. McGill, I saw you shaking your head on one part of that. Was there?
Oh, I was just saying there was 2 felony convictions and I believe 2 misdemeanor convictions.
Oh, anyhow, you want to, this story is a little more complicated than the last one. If you'd like to give us a little detail or what you want to share.
It literally was, like she said, I mean, I went in and read an email and confronted the girl on the email. And by going in her email, they said that was assuming her identity. And so we just ignore people that bother us now. So that won't happen again.
Did you hack into her email account, or were y'all such close friends you knew what her
I knew her password,
was?
but she did not give me permission to go into it.
How did you know her password?
It was her, she had said it before, and it was the same password for different things. It was her pet's name and her favorite number, and I mean, this was we were early 20s when this happened. Over 11 years
ago, and she hasn't had anything or any problems. This was over 11 years ago, and she hasn't had any problems since, and didn't have anything before that.
Before we get to you, Ms. Acey.
I have...
Wait, before we get to you, let me see if there are any other questions
Okay.
from the commissioners for Ms. McGill. Mr. McMullen?
Ms. McGill, do you still have any relationship with Kelly Russell?
No.
Okay. Does she live in Florida?
No, she's in Indiana.
Okay.
Ms. Hills?
Say you've been involved in sales. What sales have you been involved in?
I have done jewelry sales, car sales, and then I worked with my father's company for a long time. It's a Scamby Electric Motor Service and Sales, and it's like power tools and green egg grills.
Why are you wanting to be a realtor?
I was actually I was wanting to get into the timeshare business. I had worked at a salon for about 2 years, and several of the girls come in that work with Wyndham, and they just had talked about how great the company was and how much they enjoyed working there. And due to a recent divorce, I just decided to go ahead and start a career instead of having a job.
Other questions for Ms. McGill? All right, Ms. Acey, you were about to say something. I interrupted you.
That's fine. I've known Deidre myself for over 2 years, and I've had a lot of dealings with her. And I think she would be a real good asset for Wyndham. She has a lot of enthusiasm. I think this was done a long time ago when she was young. And I think that Wyndham and myself think that this would be a grave injustice for her not to be able to do this.
Questions for Ms. Acey? Ms. McMullen?
Ms. Acey, how do you know Ms. McGill?
I've been going to that salon for 2 years.
Gotcha. Okay, thank you.
But I know the people that know her that recommended her. She came recommended by about 5 or 6 people, which is very unusual for the people that come to work for us.
You know, I've been trying to figure out over the years timeshare business. And
Yes, sir.
there are different positions inside your firm, right?
Oh, yes, sir.
Where will you visualize, or where do you visualize Ms. McGill?
She's going to be working on the front line, which is new ownership, where they come in and talk to Wyndham, people that have never owned timeshare before. And Ms. McGill is very enthusiastic. She's very enthusiastic about Wyndham. It's just a real good fit.
What have you been doing since I see you left Alabama and got your license in 2011? and your broker's license in 2014. When in 2014 did you get your broker's license?
It was in February.
Okay.
I've been, and I got my license, my real estate license in Georgia, and I practiced for 4 years in Georgia before I came up here, and I've had my timeshare license for the whole time I've been up here for about 8 or 9 years. And then I got my real estate license up here. And I've met some of you when I came up here with Pam. I've been here a couple of meetings. And I know I'm new, but we all have to start somewhere.
Will the training program still be the same as what Ms. Johnson has described to us in
Yes.
the past, and supervision? I mean, has anything changed as far as the way you do things compared to the way she did?
I learned a lot from Pam, and we do have the same training and the same supervision. We watch things that come in. We walk the floors. We have several people doing that all at once. So, yes, we do have the same supervision, and we do have a lot of the same training.
All right, the chair heard a motion from Commissioner Alexander, and the motion was to approve this applicant's request. Is there a second to that motion?
Second the motion.
Seconded by Commissioner McMullen. Is there discussion now on the motion? All right, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. It is unanimous. Congratulations. Good luck.
Thank you.
Thanks for driving down
Thank you
this
very
morning.
much, and thank you for your time.
Hey, turn that thing around.
All right, I'm told Mark Atkinson has made it to the building. And so at this point, if Mark and his principal broker, Fran Houghton, will come up. All right, I'm pretty sure I can tell the difference between the principal broker and the applicant on this one.
This one's a little easier, isn't it?
All right, Ms. Crop?
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Maxwell?
This is applicant Mark Andrew Atkinson, and he has taken and passed the national and state exams and applied for licensure as an affiliate broker. He is here today with his principal broker, Fran Houghton. She is the principal broker of Keller Williams Realty, Mount Juliet, Tennessee. She was first licensed as an affiliate broker in 1989 and licensed as a broker on 7/1 of 1997. She became the PB of Keller Williams Realty, Mount Juliet as of 6/10 of 2013. The firm currently has 59 affiliate brokers and 5 brokers. Ms. Houghton has had no complaints filed against her by the commission. Mr. Atkinson, on his application for licensure as an affiliate broker, disclosed that on 9/9 of 1994, he pled guilty and was convicted in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, of obtaining property by a worthless check, which was a felony. For this felony count, Mr. Atkinson was sentenced to 1 year supervised probation, 25 hours of community service, pay the cost of extradition, and attend a check writing or money management seminar. He completed all requirements set forth by the court. As to the felony charge, Mr. Atkinson stated that he wrote a check to Home Depot while living in Florida sometime in 1992, but moved to Colorado before he realized that the check had been returned. When he became aware of the outstanding charge, he went to Florida and made restitution, appeared in court, and completed the court requirements. He had other incidents which appeared on his report, but those did not result in felony convictions or convictions for misdemeanors which involve the theft of money, services, or property. The other charges were dismissed, expunged, or involved traffic incidences. In August of 2008, Mr. Atkinson received a Master of Science degree in psychology from TSU and has worked for the State Department of Disabilities for 12 years with individuals there with developmental and intellectual disabilities. I'll let you add to
All right, Mr. Atkinson, how'd she do? How was that narrative? Was it accurate? Would you like to fill some blanks in?
I
Give us
believe that was accurate.
You
anything,
need to move closer to the
Sorry.
microphone, please.
Yes, sir, that was accurate.
anything you'd like to add?
Well, those charges primarily happened a long time ago when I was a much younger man, about 20 years ago for the most part. And I'd like to think that I'm a better man now than that when that happened.
Collins, you have a question?
You still working for the state of Tennessee?
Other questions?
Atkinson, which team you gonna be on?
Won't be on this team,
Pardon?
on the real estate team. I don't understand the question, I guess.
Did Ms. Hooten's firm have teams?
Oh,
Not everyone has to be on a team. He will be an individual agent.
Were you not recruited by one of the teams?
no, I sought them out.
Would he be assigned to a team?
He would not. We have a mentor program, and we have required classes for all new affiliates that he would be going through those courses and with a mentor.
Mentor program is what really attracted me to our company because it's very close to where I live and it really works into my current schedule.
I'm trying to find out, get myself educated a little bit too. How's he gonna climb through the ladder and get some of that bonus money from the rest of them if he's not on a team?
Again, we do have several teams within our office, but he does not have to be assigned to a team. He has the choice of going with the team if they have an opening on one, but he's assigned to an agent, a licensed agent, that everything he does, they come in and meet with them and go through a program, if you will, that we have set up for new affiliates.
Are you on probation now?
The Johnson County in Illinois, when I met with them to get that charge to work through, they put me on what they call court supervision, which I guess is kind of like a probation, but basically they said, as long as you don't get into any more trouble, then you'll be fine.
Okay, and that was as of 6/18/2014? Okay, why did that charge in 94 on the possession of cannabis, why did that just, what happened from 94 that nothing happened until this year? I'm not understanding that. In your letter you wrote.
I contacted a lawyer once I found out about it, and this was when Pam had. Let me go back a little bit. I ran a background
Please
check.
speak into the mic, sir.
Sorry, I ran a background check on myself, and it came back with nothing on there. And then Pam had run a background check on me, and this charge had come up. So at that time, I contacted a lawyer, and with his help, that was dismissed.
And why did that charge still exist? I guess is my question.
I honestly don't know.
Did you appear in court in 94 for that charge?
No.
Why did you not appear?
I can't remember. It was
In his letter, in the
years
third
ago.
paragraph.
Right. The charge on, one of the charges was expunged.
It says, I was ordered to pay a fine in court supervision for 6 months as of 6/18/14.
Right, but that's not a that's a misdemeanor. That's not a charge that would
Oh, okay.
prevent him from licensure.
Okay.
Or that would trigger that probation.
Okay.
That particular rule that you're thinking about. So that's why that's really what he has is the felony that he had. That's the felony that he had, and then everything else he had was either expunged, dismissed, or it involved a misdemeanor traffic accident that wouldn't
Okay, so he really wrote that in there and we didn't need to know that.
Well, right, so he wrote everything and he addressed things
Okay.
in here that were like either dismissed or
Okay.
expunged. I mean, I have the expungement
Okay.
papers and all those. But it is kind of confusing what triggers that and what doesn't trigger that.
Okay, are there other questions for Mr. Atkinson? Ms. Hills?
I'll wait for
Okay.
Parker, excuse me.
All right, let's go to Ms. Hooten. Would you like to tell us why you think you'd like to have him?
When Mark came in to interview for us, he first interviewed with our team leader, and then I was asked if I would discuss his history with him and would be willing to take on the responsibility of Mr. Atkinson. After reviewing his recommendations and looking at the time frame of all of these charges on him, I felt like for the last 12 years working with the state of Tennessee that would be good enough for me. I think he'll be a good asset to our office.
All right, Ms. Hills, did you have a question?
Yes. How, when, and who will determine if he goes to a team, and if he does go to a team, who still supervises and who still looks over?
Even if an agent is assigned to a team, I'm still the principal broker and responsible for that individual agent. Again, not everyone in my office is on a team. I'm not on a team. I sell real estate. But, so he wouldn't be assigned to a team unless someone had an opening that said, Mark, would you like to join our team? And that would be up to him.
That can happen anytime.
Anytime. But as an individual agent, they're required to go through all of our contract classes, all of our new agent orientation that we have that is probably an 8-week course. We have classes at nighttime for agents who work during the day. So we have plenty of opportunity for him to be monitored. And I'm always there to answer any questions, and I review all of their paperwork on their first 2 to 3 transactions.
Mr. Chara?
Ms. Hooten, you said that he would be assigned a mentor. How's it determined who will be his mentor? How long have they been in the business? What qualifies them? Give me a little insight into that.
Our mentor program is basically, we try to match up personality styles that will work, and he would be given what they call that DISC profile, and then all agents in the office have an opportunity to say they would be glad to be a mentor, and at that time we would match him with the one we felt like they would work best together.
Ms. Franks, did you have another question?
No, I do not.
Mr. Collins?
Mr. Chairman, I'd like to make a motion that we approve it.
Is there a second to Commissioner Collins' motion to approve this applicant's?
Second.
Seconded by Commissioner Bloom.
Mr. Chairman,
Mr. Alexander?
since the motion is on the floor, it's time, I wasn't through questioning.
That's fine,
the
we have
principal
discussion
joker,
now.
So,
so
and I
you-
believe we can discuss it.
Absolutely.
Ms. Hooten, do you ever make a commission check to a team captain and it get redispersed to other members of that team?
You know, I guess that would be individually, however the teams have that set up with their buyer's agents or listing agents.
Question was, ma'am, have you ever written a check to a team captain or the chairman of that team, and then that money be redispersed to other members of that?
have not. I
Do
have
you
not.
write the checks, escrow
I
checks?
do not write the checks.
Do you have knowledge of it?
I could request the records of that.
My question is simply, do you have knowledge of it today?
I do not today.
But you think it might happen? No further questions.
I'm sorry.
Is there a follow-up question from any commissioner? Because I'd like to follow up with that. So, we're asking these questions, Commissioner Alexander's asking these questions because we hear these stories of teams where members of the team do the work, but the production and the check when it's turned in is turned in by the team leader. And we've heard these stories about the team leader then getting the commission check and then taking that check and giving it on some pro rata basis to members of his or her team. And we would really like to document that because we'd like to bust that company bad.
Yeah.
Because only the broker can pay a licensee. So your hesitation gives me concern that maybe it is happening, and if you don't leave with anything else today, I hope you make sure
we'll
that's
check
not
on that.
happening. Don't check on it, make sure it's not
I'll be
happening.
sure it's not.
It's just not, I think if we could ever document that, if we've been tough on other issues, we could really be tough on that one. So that's where Commissioner Alexander's
Okay.
coming from. It's based,
And you're the principal broker.
Yes, sir.
And you're responsible if it's happening, even though you don't write the checks. Buck stops with you.
Wendell, I'm appalled that she didn't know. I made the motion, but I'm appalled that a broker didn't have a clue of how the commission's dispersed. I can't believe that.
Well,
You're the principal broker.
it's true.
I know it's true.
It's true.
I know it's true. And I think you're holding back on us for not, if you don't know.
No, Keller Williams has their whole system
We're
set
talking
up,
about the
and I
state of
haven't looked
Tennessee
at it.
rules.
I agree. I
We're
see.
not talking about Keller Williams.
Okay.
and this is off topic for why Mr. Atkinson is here. But since we got a door to open, and we opened it a little bit, we're going to keep working this issue. So, again, if there's...
I have another motion when you go ahead. Let's finish this.
Okay, let's handle what we're here for first, and then while you're here and we've got your attention, if you'll stay a little bit longer, we might appreciate that. All right, the motion on the floor is to approve the applicant's request to be able to proceed on to get his real estate license in the state of Tennessee.
Mr. Chairman, I'd like to withdraw my motion until she can clear up this question that's been asked.
The second will have to agree to do that as well.
I agree.
Okay, so we don't have a motion on the floor for a minute. All right. Do you have another question or a comment?
That's it.
Or motion.
No, I don't have enough.
Ms. Hills?
I have a question. Will you continue, Mr. Atkinson, to work for the state of Tennessee?
Well, at this time, yes, but it's my, I guess you could say it's kind of my dream and passion to transition into a real estate business.
Mr. Chairman,
Mullen?
I'd like to make a motion that we postpone consideration of this to our next regularly scheduled meeting.
Second.
Let's have some discussion on the motion.
Oh, I just have a comment to Mr. Atkinson. I don't have a problem with you or giving you your license whatsoever. My problem is this issue with how commission checks are written and the principal broker not knowing it. So please understand, from my position, this is not a question about you. This is a question for Ms. Hooten. Who writes the checks in your office?
Amy Hamilton is the one who writes the checks in the office. She was the prior broker.
Prior broker?
Yes.
And who signs those checks?
Amy Hamilton signs the checks.
And so you have nothing to do with the commission checks
I do
as
not.
the principal broker?
As far as writing them or dispersing them, no.
Do you approve them?
I approve their contracts and their information that they fill out and turn in for their commission checks. And it's my understanding it's paid to the realtor who is the listing agent, and then a check written to the team member.
Mr. Chairman,
Alexander?
I move that
We have a motion on the floor. You might want to make a substitute motion, but the
What was
motion
the-
at this
what was the
point is
motion?
to defer for 30 days.
call for the question.
Wait, can I just, for clarification, are you deferring a decision on Mr. Atkinson for 30 days, or is that?
I mean, that's the chair's opinion of the motion at this point, and it's, there ought to be some room to work in this if,
And that was my comment. I don't have a problem with Mr. Atkinson. I have a problem with him proceeding in this.
I think what you're
Avenue.
trying to say, ma'am, is you have a problem that this broker who does not know what's going on in her office can supervise him or see that he's supervised.
Absolutely.
Let me go back to the maker of the motion, Commissioner McMullen.
I thought that the delay would give us time to check into this matter more because the principal broker didn't have knowledge of some issues, and I thought that in the intervening period, we could get some more information on that to clarify those questions.
Call for the
Well,
question.
can I make a substitute motion that we approve Mr.
Let's just stick in order. There's a motion by Commissioner Alexander, which is discussable, arguable. He's made a call for the question. We're going to vote on the call, so if you've got more you want to say, you'll vote no to the call question.
We're voting on whether to call the question.
Yes, that's the vote at this point.
Okay, let's do it.
We'll do it by voice first and see how that goes. The motion is to call the question and stop discussion. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed to it, please vote no.
No.
Let's roll call it, please.
This is a motion just to whether to call for the question, correct?
Stop discussion and
Okay.
go to the vote.
Franks,
Yes.
in favor of the motion? Okay. Alexander?
Favor of the motion?
McMullen?
No.
Did you say no?
I said no.
Okay, thank you.
Yes, I said no.
Bloom?
Yes.
Hills?
Yes.
Collins?
No.
Grease?
No.
DeChara?
No.
So there's, it's a tie.
4-4, the motion fails. All right, the floor's back open. Mr. Chacharo, you indicated you want to make a substitute motion?
I would like to make a motion that Mr. Atkinson be approved for his license as long as he goes to a different firm with those license.
That's not what's before us today, though.
What you're all determining today is under 6213-303, and that says licenses shall be granted only to persons who bear a good reputation for honesty, trustworthiness, integrity, and competence to transact the business of broker, affiliate broker, or timeshare salesperson in a manner to safeguard the interest of the public, and only after satisfactory proof of such qualifications has been presented to the Commission. No license shall be denied any person because of race, color, religion, sex, or national origin. Basically, what you're deciding, the reason that Mr. Atkinson is here today is because of the felony that's in his past. He does not fall within the rule barring him from licensure for 2 years because it has been well outside that period. The question before you is, has Mr. Atkinson given you satisfactory proof that he has a good reputation for honesty, trustworthiness, integrity, and competence to transact the business of an affiliate broker? And that's what's before you to decide today.
So what's happened here, I think, is that two issues have emerged from one. One is Mr. Atkinson's permission to go forward. I think the consensus is that's probably acceptable. We can divide this question up. We really don't have anything on the agenda to discuss beyond what Ms. Hooten has told us, and she may say she'll come back next month with the answers to those questions.
Do we have a second to your motion?
Well, there's
No.
the chair rules. Mr. Charles' motion died for lack of a second. We're still talking about Commissioner McMullen's discussion or motion to defer for 30 days. I think we're getting some advice from our counsel that we're mixing topics, and the question in front of us today by agenda is, should this man be allowed to continue on with his license, the application for his license?
And I think that's exactly what it is. I think if the commissioners want to investigate the principal broker, that's a different subject. So I make a motion that we approve the applicant.
Now, this is a substitute motion. If it passes, then we've finished this agenda item. We may want to ask Ms. Hooten to agree to do something like come back next month. If it fails, then we're back to Commissioner McMullen's motion to defer for 30 days. So the motion made by Commissioner Frank, seconded by Commissioner Alexander, is to approve this request. Is there further discussion? Let's vote. Let's roll call it to you again, Ms. Maxwell, just so we're clear.
Is this, this is a substitute motion?
It's a substitute motion
Okay,
to
for the one
approve.
that was made by Commissioner
McMullin.
McMullen.
Correct.
All right. And that's to approve the applicant for licensure.
Correct.
For, move forward in the licensure process.
That's the intent of the motion.
Franks,
Yes.
Alexander,
Yes.
McMullen? Yes. Bloom,
Yes.
Collins,
We're going to defer.
did you say you would
He
defer?
he passes.
Okay. Hills,
Yes.
DeChara,
Yes.
Grease?
Yes.
Motion passes 7 with 1 pass, 7 yes and 1 pass.
Thank you. Congratulations. I don't know if that's the right word to use, but we wish you well as you go forward in your real estate career.
Thank you.
Mr. Chairman,
Mr. Alexander,
I'd like to make a motion.
you're on the floor.
I move that this Keller Williams firm and the principal broker be audited as soon as possible, and especially the escrow account where they can prove where the checks are being issued. That's my motion.
Commission account.
Commission escrow account,
Both.
which comes out of an escrow, commission account.
You've heard
And
them.
and any other account where the commission money goes. If it goes into somewhere else, if it goes into the team, captain, wherever, a complete and thorough audit.
I'll second that.
Ms. Hooten, before I want to open it up to discussion, but would you like to comment, or do you have any statement at this point before we open it up to commission? I mean, it's not an agenda item, and I know you didn't come prepared to talk about this, but if you'd like, as a courtesy, you can say anything at this point.
No, I think that's fine.
He's speaking to the microphone, so it's on the record.
I think she indicated that she's willing to cooperate with this motion. Now, commissioners, do you have discussion on the motion?
I have a question of her.
Mr. Collins?
You said you didn't write the checks, but the person that owns the company, do they write the checks?
No, sir. Amy Hamilton writes the checks.
She's not the owner or part owner or any part of it?
She's just an employee.
No, she's previous principal
She
broker.
was the previous principal broker.
I don't understand the chain of command there.
I don't think that's very unusual. I think that happens in a lot of real estate companies. Especially if you get a little bit bigger where the owner doesn't write the checks.
Okay.
Any of the principal brokers licensed?
Sir?
Are any of the principal, or not principal brokers, but are any of the licensees or the owners licensed?
Yes.
What kind of license is that?
Pam Teller's the owner, and she has a broker's license.
All right, further discussion on the motion. That motion made by Commissioner Alexander and seconded by Commissioner DeCharo asks for a full audit of this firm, especially as it relates to commission disbursements. Further,
Is this going to be like the audits that we send out the paperwork, or will we have someone go to the office?
Ask Ms. Maxwell, do we have a person hired now to handle that?
We're doing interviews this week for a person to do that. So the audit form can go out to the person, but it'll be, probably a week or probably 2 weeks if one of these candidates proves to be someone who's interested in the job once they come and chat about it.
I wish we'd wait.
I think we need a person.
Yeah.
well, we can pass the motion. You're not putting any time frame on it. All right, further discussion. Let's vote. Those in favor say aye.
Aye.
Those opposed, no. Motion passes unanimously. Thank you both for coming. Best of luck to both of you. Good luck. All right, let's take about a 10-minute break.
And so you get credit for today.
I'm here, Mr. Chairman. I'm just back here looking.
I understand. All right, Kimberly, are you ready for us? Thank you. Let's take a chance and see if Margaret Honeycutt and Pete Gertz are here. Are you present? I don't see him.
They were.
They were?
Mhm.
Okay.
Do you want me to step out? I reckon.
Let's go to the education report. If they're not in here, let's,
They're here, I think.
They're
I
here.
think they're just.
They came from
most people like to get back to East Tennessee.
I know, they do. I figured they drove down this morning. I don't know if they did or not.
Do you want me to check?
You're new, go ahead.
That's part of the initiation.
She didn't know she'd go out that door, did you?
All right, we're back in session, and we would like Miss Margaret Honeycutt and Pete Gertz, if you're now present, to come up into these two chairs. We'll have a seat. Ms. Kropp, will you swear these two individuals in, please?
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. Ms. Maxwell.
Yes, Margaret Honeycutt is here today with her principal broker, Elgin Pete Gertz. Ms. Honeycutt has completed an application for decision regarding prior criminal sanctions in order to seek the Commission's approval to proceed with the licensure process to obtain affiliate broker license. As I say, her prospective principal broker is Elgin Pete Gertz. He is the PB of Team Success DBA Realty Executives Kingsport, which is located in Kingsport, Tennessee. Mr. Gertz was first licensed as an affiliate broker in 1986 and was licensed as a broker and PB in 1991. He became the PB of Team Success on 8/6 of 1999. The track records reflect that currently the firm has 2 affiliate brokers and no brokers other than the principal broker. Mr. Gertz has had no complaints filed against him by the Commission. Ms. Honeycutt, in her application for decision, disclosed that on 10/27 of 2005, she was convicted in the Court of General Sessions, County of Horry, South Carolina, of grand larceny, 1,000 to 5,000, which is a felony, and possession of methamphetamine first, which is a felony. On the first count, Ms. Honeycutt was sentenced to 5 years in jail, provided that upon the service of 140 days, the balance of the sentence would be suspended with 5 years of probation, which ended on 10/26 of 2000, would have ended on 10/26 of 2010. Ms. Honeycutt had to pay restitution in the amount of $9,500. The order provided that her probation period would terminate upon the payment of all financial obligations. On the second count, which ran concurrently with the sentence in the first count, Ms. Honeycutt was sentenced to 3 years in jail, provided that upon the service of 140 days, the balance was suspended with probation. There was no restitution involved in the second case. A letter from the South Carolina Department of Probation, Parole, and Pardon Services states that Ms. Honeycutt fulfilled all financial obligations as ordered by the court and was released from probation, and her case closed on 10/1 of 2009. As to the felony charges, Ms. Honeycutt stated that she moved from a small town hoping to find a job and started working in nightclubs where she was first introduced to cocaine and then to methamphetamine. A fellow drug addict filed the charges with the police, which resulted in the grand larceny conviction. The charges involved the theft of the belongings of another. Ms. Honeycutt states that even though she was innocent, after several months in jail, she pled guilty to the 2 felony charges listed above. She states that she usually had 2 jobs during this time period so she could pay the restitution and her living expenses as well. And as noted earlier, she paid the restitution and fees in full early and that was resulted in an early termination of her probation. Since Ms. Honeycutt's release from probation on 10/1 of 2009, she has worked as the manager of a storage facility and as a receptionist at a credit union and a law firm.
Thank you, Ms. Maxwell. Ms. Honeycutt, would you like to fill in any blanks or give us the same story in your words? Or
That's pretty much the story.
If you'll speak into the microphone, we have to record this.
Okay, well, it's pretty much what she said, except for, I was probably guilty of the drug charges, just not the theft charges. But they run them all concurrent, and so I pled guilty to everything together. And that's about it. So I've worked nonstop since then, and that's about it.
All right, Commissioners, questions for Ms. Honeycutt? Mr. Chara?
Are you drug-free now? For how long?
Since I was arrested January, I think 2005.
Other questions? All right, no other question. Mr. Gertz, tell us why you think this might be a good candidate for your firm.
She's employed with a person that I've done a lot of business with over the years.
I need for you to speak clear.
I'm sorry.
We're trying to pick this up.
Is that better?
Yes, thank you.
I'm sorry. She has been employed with a person that I've known for many years. His name is Gary Alexander. He's a developer in the Kingsport area. He develops commercial properties as well as real estate subdivisions, and done a lot of business with him. He's an honest person, and I've never had anything other than a good business arrangement with him. This lady here, Maggie, has worked with him for in excess, I think, of 4 years. I don't know her real well personally, but I know Gary well enough to know that he would not recommend it, as he has recommended, that she would be a good real estate agent. We've spent considerable time discussing her past as well as what she would like to do in the future, and I also believe that she will be a good member of our organization.
Thank you. Are there questions for Mr. Gertz? Ms. Hills?
What is your capacity with Mr. Alexander? What's been her role?
She has been responsible for renting. He probably has in excess of 100 rental units from homes to storage facilities and that kind of thing, and she has been responsible for collecting the monies as well as renting those facilities and keeping them rented. She handles large sums of money, and Gary said that he has never ever had even a penny missing in the years that she has been there, and has done an excellent job in keeping units rented and involved in all the transactions in that facility.
And I'm sorry, you may have said 4 years with Mr.
Yes.
Alexander?
Yes, ma'am.
Mr. Gertz, does it require a real estate license to rent property for other people?
Not if they're employees, as I understand it. She was employed by him.
What I rent out is just the storage units. That's
Other questions?
Motion to approve.
Motion by Commissioner Collins to approve this application. Is there a second? Is there a second?
I'll second.
Thank you. Mr. Bloom?
Mr. Chairman,
Yes, Mr. Alexander.
just a minute, please.
In the meantime, Ms. Honeycutt, did you go through any type of rehabilitation or any?
well, several months in jail is
to get
rehab. Yeah.
Well, it either works or it doesn't.
Mr. Chairman, I'm sorry to hold you up.
You're fine.
Just trying to clarify something.
I got you. Other questions while Mr. Alexander does his research? Stand by just for a second then.
Verifying the name, the team success is not in the license. That's was the
It
question
is.
I was having. Huh?
It is.
Is it? I didn't see it.
Right before the DBA.
Excuse me. Sir, were you in here a while ago when we had the other applicant in?
Only for a minute, and I went back up to find my glasses. Sorry.
I rather suspect by your DBA and your name that you have some teams. Is that correct?
I have some what, sir?
Do you have teams in your firm?
No, we do not.
Have any
My wife and
license?
I work together. We're the principal people involved in selling of real estate.
Just two people in your company?
Three, right.
There are 3 licensees, my wife and I and one other person.
I've got a team, if you will, your wife.
No other question. All right, to remind the commission, the motion on the floor is to approve this application. It was made by Commissioner Collins and seconded by Commissioner Bloom. Is there further discussion on the motion? I hear none. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The vote is unanimous. Congratulations. Best of luck. And that's a long drive down here, isn't it? We don't need you back here for any reason, either one of you for that matter. Because of
Thank you very much.
Thanks. All right, Ms. Maxwell, let's do the education report. What do you think? Or do you want to get Ms.
Robin Ryan has something that she was going to present with the legal report, but if the commission would like, she can go ahead and present hers and get that particular.
Listen, we might get a quorum. Let's see on this one.
I don't know. Let's see. What's it worth to you?
As many times as
I
she's
move
kept
we let
us
her
here
hear
all day
move
on
on
these
out of the way.
trials, maybe we need to make her sit around and wait for a while.
All right, by common consent, the agenda is modified to allow Ms. Ryan to make a presentation.
I'm not sure I want to go forward at this point.
Well, we can, by common consent, take you off the agenda real quick, too.
I'm here today on a matter that was originally scheduled for a hearing for tomorrow. And we have continued indefinitely, subject to an approval of a proposed order that has been signed. It will then be dismissed. In this particular matter, the respondent has an attorney, and the respondent has agreed to a 6-month suspension and a payment of civil penalties of $5,000 payable in a payment plan, and not to work. She's not working now, and she won't work for the entire 6 months in her suspension. And she will pay, and she will take and she requested, this is her attorney, 60 hours of continuing educations with a proposed at least 4 hours in ethics, 16 in contracts, and 10 hours in agency. These are the number of hours that I spoke with Eve about the maximum amount you could get, and she will do that within a year period. If she doesn't complete any term of this agreed order, her license will be automatically revoked. In this particular case, I do think this is an appropriate remedy in the case that's before you. I will tell you, just like in all cases, there are circumstances that would come up. There's no question that there were violations of the law, specifically that she agrees that what she has done is that she had a purchase and sale agreement without a termination date, and that there was no executed confirmation of agency. And there are questions about whether or not there was a property that was sold and renters living in it. The problem we would have is I can't prove everything that we've alleged. It can hang there. It could turn either way. We don't know. In this particular case, though, this is a respondent who is intent on trying to cure issues that she has in her life. And quite honestly, if she doesn't get this resolved in the next 6 months, she's not going to be a licensee. Either she's going to do what she says she's going to do, and then she's done what she needs to do, and she's going to go forward and be a good person in society and in this particular instance, or she is not. Therefore, I'm asking that you all to approve this agreed order. It has been signed. Once I get your approval, I will have your chair sign an order dismissing it. It will then be filed with the court. And again, it is in a period that if she violates any of the terms, that means the dates that are supposed to be paid, that means getting all 60 hours in within a year, and that means if she is somehow not practicing for the 6-month period, if she violates any of them, her license will be automatically revoked.
Mr. Chairman?
How long?
I'm sorry?
How long was the suspension of the license?
6 months.
6 months. How long is the pay period?
The pay period, before that, the pay period, she is going to be paying $5,000 immediately upon, $2,500 on or before September 1st, and the other payment due on or before October 1st.
Mr. McMullen.
Motion to approve.
Second.
I've got a motion by Commissioner Mullen, and I'm saying Commissioner Collins be Commissioner Char to the second. Is there? Oh, I'm sorry.
Franks. I didn't get mine in quick enough either.
He beat you too then.
Yeah.
Is there discussion on the motion?
Could I just hear those terms again, please?
Yes. The terms are $5,000 civil penalty, first payment due in September, second payment due in October, 60 hours of continuing education in a year's period, because she cannot get that done in any less than a year's period, 6 months suspension upon signing this, although she's not been practicing since her attorney and I have been discussing. And one more thing, sorry, before I go any, I think I even put in here she had to come and sit here. Oh, sorry. Let's see, did I put that in there? Yes, she also has to attend the 2-day meeting before.
Why do you make a face like that, Robin, when
I
you
don't
say
know.
that?
Is she wanting to continue in real estate?
Yes, whether or not she's going to be able to, the time will tell on that.
I'd like to commend you for working it out.
Here, here.
So
Thank you for letting me.
So just as, does this set a precedent, or have we done this before where you've brought us a deal?
Yeah, I've brought you deals before.
Okay. Mr. Alexander, you had something?
Question was, tell me, you indicated something about a contract wasn't filled out right?
There were little minor things, that's why she's going to do continuing education. I don't know if I could approve that, but it appears from the documents that I have that she didn't have a termination date on the contract, and that the confirmation of agency wasn't included. Whether or not those documents are there, I don't know. That would be something we'd find out in a hearing.
There were other issues, I think.
Yeah, there were other issues. Those
There
were the
other-
only issues.
Those were
but-
not the only issues. That, I think.
Okay, other questions? Motion by Commissioner McMullen,
This afternoon.
seconded by Commissioner Collins, is to approve this agreement. Let's vote. Those in favor, vote aye.
Aye.
Those opposed, no. It is unanimous. Thank you, Ms. Ryan.
Have you signed this for me?
Please approach the bench, yes.
And y'all, next month,
He
there
loves
will
saying
be a
that.
hearing. Sorry.
There will be a hearing?
Yes, because
Okay.
it was continued from another
Chattanooga.
time. There's an attorney involved in that one as well, but there will be a hearing.
September, is that what you were saying?
Yes.
Okay.
So pack her lunch.
Back it up. In October, you guys are in Timbuktu.
Chattanooga.
And thus far, I haven't got anybody who wants.
You can't make it to Chattanooga? I
I would
mean,
love to make the Chattanooga. It's one of my favorite places to go with you guys.
I can't
But
believe you can't come up with a hearing for
You gotta
October.
have cooperation all around. Thank you very much.
Thank you. All right, let's try the education report now. You all have a copy handed out to you this morning of the report. It seems to be much more organized than it used to be.
The first part of the education report is a discussion on the 1-hour course duration, or would you just like to go ahead and deal with the courses themselves first and get that?
Let's go by the agenda.
Okay, so the first item under the education report is a discussion of the 1-hour course duration. And I'd sent some information to each commissioner that set forth the Rule 1260-5-.03 requirements for courses. And 1C states the applicant shall demonstrate to the satisfaction of the commission that each course submitted for approval will consist of no fewer than 2 classroom hours. And then 2 of that same rule says each hour of classroom instruction required by TCA 6213-303, which is the statute that requires continuing education, shall consist of 50 minutes of actual instruction. It appears that this section was made a part of the rule 1260-5-.03 from its initial effective date of 12/15 of 1980. And according to Orello information, 17 states approve 1-hour courses for CE, and I will leave the rest to Commissioner Bloom to discuss.
Well, this was, the genesis of this was a discussion from the TER convention and conferences, which offers 1-hour courses, and it would appear that there's a great benefit to the members of the real estate community to offer that as CE. Right now, it has to be 2, but in their scheduling, 1 hour is more convenient.
So for this to occur, if the commission chose for it to occur, we'd have to have a rule change, is that correct?
That is correct.
We have some rule changes in progress. This would be maybe the third.
How it would work would be you have one clump of rules. It's a larger, massive rules that is actually has been sent up, received back, and has been sent up to the Secretary of State's website as of Monday. As of today, they have not posted yet, but they should be posting at any time, and we should be having a rulemaking hearing in November at our meeting for those rules. There is a second proposed rule that we did through a different path by itself because it relates to a requirement of a rule change as a result of some legislation from the 2014 session. And that may or may not require a rulemaking. It depends on, for that one, if we have a petition from, I believe it's 25 affected individuals, we would have to have a rulemaking hearing on that one. This rule, yes, would have to go through the rulemaking process because it would be a change to an existing rule. We would then have to start a third process. It's too late to put it on with either one of the others. And, what I would ask, if you decide that that's the route you want to go, it's perfectly fine. We can move forward with that. But in light of the time and expense of rulemaking hearings, we might want to, make sure there's no other rules we want to consider at the same time as this rule, just to avoid you all having, rulemaking hearings every other month if we start taking these up one at a time. But it's, of course, up to you. You may have some other ideas already of some things, and I mean, there's certainly nothing preventing you from starting another one, but it would be your third rulemaking process that's currently active at this time.
Why not operate under a policy until we go through the rule process?
A policy doesn't overrule your rule. I mean, you have a rule specifically stating no less than 2 hours. A policy would not override your rule.
About a year and a half.
Well, it appears we
Perhaps.
need to get started then.
Could legislation preempt this rule?
Legislation would override a rule, but, we obviously can't.
No, we can't.
Legislation, a statute conflicting with a rule would override it, but a policy would not override our rules. So,
Based on how long this rulemaking process takes, it's clear to me that getting something passed statutorily seems to be quicker than the steps we have to go through. Sure, you go right ahead, Mr. Commissioner Bloom.
Yes, I just wanted to see if we could ask Chris to respond to that.
Chris, if you'll give us your name and address for the record, past criminal history.
Chris Sexton with the Tennessee Association of Realtors. Thank you, Commissioners, and thank you, Commissioner Bloom, for bringing this forward. I really do appreciate it. Our members really appreciate it. If it can be done statutorily, we can definitely take a look at that and bring it to our Government Affairs Committee to see how we can get this moving forward. And then I'll bring it to our leadership following that, just kind of our standard practice that we do. And if legal opinion says we can do it that way, then we can look at doing that if that can make it happen faster.
well, I'm not giving you the opinion you can. I'm just telling you if you do it, overrides our rule.
That's why I have to consult with our attorney as well.
Don't quote Julie.
I mean, I'm not sure. I'm just telling them procedurally, if a statute were to be changed, it would override their rules. So,
And about how long would that take, Chris, to get some kind of an indication? If we put this off till next month, would that hurt anything?
I could probably have a better answer for you.
Yeah.
But, just knowing how most laws are usually done, if it happened next session and was passed in the House and Senate and signed by the governor, it'd probably have, as in most rules, a July 1st, 2015 date attached to it, I'd guess.
That would be a better route.
Probably tag it on to something else you're going to do.
Well, I mean, it'll be a brand new session, so we could introduce a bill specifically for this if we're able to.
Commissioner Bloom, do you have a suggestion how we should proceed?
Yes, if that's quicker, I would suggest that we follow Chris' tracking of this through the legislature.
Instead of suggestion, why don't you make it?
And can I change that suggestion to a motion?
I'm not sure. You might make a motion that states that it's your opinion that statutorily this will get done quicker than through a rulemaking
Trying to
process.
satisfy the gentleman to my left.
Good luck.
Yeah, I know.
So, Chris, what if we do this? Could you come back next month and say you've talked to the powers that be and you guys are anxious to go forward with it statutorily, or would prefer that we try it through a rulemaking process?
If I cannot personally be here, I'll make sure somebody from our organization is. Representing our.
Sure, that'd be
Get it
great.
out and you can let Steve bring it.
And for the record, I had nothing to do with Steve being taken away. I just want to put that out there. It wasn't me.
No one claims responsibility, I can tell you.
Steve, I think you are getting thrown under the bus quite regularly today. How's it feel, honey?
How you expect us to treat him when he leaves us?
Yeah, that's right. All right, thank you, Chris. Thank you, Commissioner Bloom.
Deserted us, didn't he?
Thank you, Julie.
Mr. Chairman?
Yes, sir, Mr. Collins.
What's wrong with us making a motion to put that in the rules at this time?
We could do that and have the dual track but one track's going to move quicker than the other.
Well, I conferred with my counsel over here, and he thought it wouldn't hurt anything.
Why don't you make a motion?
I make a motion, we make the change.
Get up there where we can hear you.
I make a motion, we make the change.
He's
I'm going to
making,
just wait until next month to see what he says, and then we can move forward. Because, I mean, once we start the ball rolling on this rulemaking process, if they get this done ahead of time, I'm not sure how that might work. I mean,
Rulemaking is, I mean, every rulemaking, the department says costs $5,000 to $7,500. So you sort of have to keep that in mind as you kind of.
I was just thinking maybe wait to hear his report next month, and then, we could, of course, do this at that time, but just not knowing exactly what the route may be at this point.
I think Commissioner Collins' motion is that, his motion is for this commission to express its intent that it will institute a rulemaking process on this issue if we don't get a satisfactory answer back from TAR.
That's exactly what I was going to say.
That's what I thought it was. I just want to make sure I had it correct.
Yeah, that's it.
So
Second, man.
Second.
Seconded by Commissioner Bloom. So the intent of the motion is to put on record this commission's intent to pursue this concept, and we may take action as early as next month, depending on what we hear back from TAR. And that's not exactly what council said over here on the corner, but.
Up for the question.
Let's vote. All in favor of that motion, say aye.
Aye.
Those opposed, no. It's unanimous. Thank you. Update on course renewals, Ms. Maxwell.
Right. Just a brief update. The course renewal information went out to all the schools, and it basically included, for each course that they have currently approved, a sheet of paper, and they could write that they wanted to renew their course, or they wanted to write void on it, and they did not want to renew the course. We sent out for renewal to 176 schools, and the renewals covered 1,400 courses. We've had a few come back thus far, so just is really a brief update to let you know that those have gone out. And
When
we'll
did
see
they
if there's
go out,
business.
Eve? Because I have not received mine.
You haven't? They went out about 2 or 3 weeks ago. We've already started getting them back.
No, I haven't received one.
That may tell you something.
They went out to the
Maybe.
sponsors, so you're listed as a sponsor, right? Okay, I'll check and I'll check and see what happened to yours.
Any questions or comments regarding that report? All right, course and instructor approval.
The commission, I sent each commissioner a copy of the courses that had been submitted for this month. I've reviewed all of the courses and all of the instructors who had not been previously approved. There's only one course that I just put back on the consider list just to requiring discussion, and that was the one last month that was called basically it was branding for women, and they changed the name and sort of repackaged it and changed it to Branding Matters to Everyone. And that's, you'll see, is course A20. But A1 through A19 All those courses appeared to have information that would cover the number of hours that were stated, and the individuals who were submitted to teach them appeared to be qualified to teach those courses, and they covered topics that were covered in the rule setting forth the 17 topics that CE courses could cover.
Thank you. Is there a motion to approve courses A1 through A19?
I have a question.
Can I get a motion, and then we'll discuss it? A1 through A19.
I make a motion.
Second the motion.
You're out again, Commissioner DeChara.
That's okay.
Motion by Commissioner Collins, seconded by Commissioner McMullen. Commissioner Franks.
Eve, since I'm kind of new, not the newest girl on the block now, but how do, like this first one, the American Society of Farm Managers and Rural Appraisers, obviously they have come to the commission and they're wanting approval for this class. So, I mean, what do we know about them? What do we know about the instructors? How does this work?
So the American Society of Farm Managers and Rural Appraisers has submitted this is really basically for a seminar, and they've submitted the entire course information, which was sounded pretty interesting, actually, and it actually contained a lot of detail that they submitted along with it, which described the course and each one of as I say, it's actually a seminar of sorts, and so it describes each one of the topics, and so it as if it would be the workbook for the course. You would see that they submit with an outline that shows basically how the time would go. And then for each of the instructors fill out an application, and along with their application, they then put in their resume and any other credentials that they might have that would support their request to teach, and that they are qualified to teach these courses. A number of these individuals that are listed here, they teach nationally. Some of them are attorneys. Some of them have been CEOs of corporations that deal with the specific topics here. And it's, as I say, and I have a copy of the information that they sent. I have a copy of all of these with me if you'd like to look at those as well. But that's what the schools do, is we have an application form, an application packet, and they fill out the application, which is just sort of a brief questionnaire, and then they send this timed outline, and they send a course outline and/or the course. Sometimes the course outline is not very informative, nor is the PowerPoint. And so then I'll ask them to send backup information, additional information about the course, so I can actually see what is going to be taught, because sometimes you can't tell from an outline nor from the PowerPoint what they're really going to talk about.
So this actually, it should be going through the education director, but because we don't have one right now, you're looking through all this information, or is someone else?
No, I'm looking through all the information.
Okay.
Betsy puts it on this little piece of paper that you see.
Okay.
But I read through every one of these courses and every one of these instructors that you see here. I had done it before when we didn't have an education director. So really, it's a matter of reading through the information that's submitted, and you're making a determination whether or not you think that those hours are appropriate for the amount of information that's included in the course. Just from what you can tell, and whether or not you think the information would be beneficial to our licensees, and something that they would need to know, and that fits in one of the 17 topics that's found in Rule 1260-05-.03.
Ms. Franks, having been a member in the past of this organization, having attended one of those classes, this class be taught in Knoxville?
It's in Memphis.
Or Memphis?
Mm-hmm.
Most time it's in Knoxville. They're next when the Tennessee, and they must be playing Memphis this year. But anyway, it's a good course. I would recommend it.
So the bottom line is, you've looked at it, and this is your recommendation, that we approve these people and these courses.
That is correct. But
Okay.
if ever there is a question about, a course or something that you would like to see more information on, you can let me know, and I'm happy to, I have it with me today, but I'm also happy to send it to you ahead of time if you would like to look at it and see what, if there's some course that you think sounds interesting, or doesn't sound like it's worth the number of hours, because sometimes we do get courses turned in that maybe they want 6 hours and it doesn't look like it's 6 hours worth of material, and we ask them for additional information and, and then wait to hear feedback if it's not appropriate.
So,
Other questions?
let me just, how much time is taken up talking about the major tree nuts?
It's the whole outline, it starts out with a discussion
I'm sorry, I
of
didn't mean that. I
DuPont
didn't
and what
mean to ask that
DuPont has
question.
done.
Yeah,
And
I'm sorry, I didn't mean to ask a
It's
question.
really, it sounds like a pretty interesting.
I've had the call for the question. Is there an objection to the call? I hear no objection. Let's vote on the motion, which is to approve A1 through A19. All in favor, vote aye. Those opposed, no. It is unanimous. Now we're on to A20, which is on the last page of the handout distributed to commissioners this morning. We had this last month, is that right?
We had it last month, and it was the course that I described that was a marketing course that you should market to females because they make all the important decisions in life and in a family and about, particularly, I guess, about housing, but it was really sort of more broad-based than that. And so after it was not approved by the commission, they renamed it and repackaged it after a fashion so that instead of just saying that women do those things, now that says that marketing should be geared towards everyone, men, women alike. And anyway, so it's really a marketing course. So I think the question for the commission is whether or not a marketing and branding course is something that the commission believes is beneficial to the licensees, and that's why I put it on discussion.
I've taken many of these Home Builder Association courses and find them very beneficial. They're always really good courses. And marketing and branding is a part of real estate.
Director Maxwell, you had some hesitation about this course because it doesn't fit neatly into what we can approve?
Well, it just, it is really purely a marketing and branding course, but, Commissioner Franks, if she's taken, and the Home Builder certainly is a recognized, association. It's just that I just wanted the commission to discuss it and see if the commission felt like branding and marketing, if that is something that the commission would like to approve courses on. As I say, that's why it's up for discussion. And I'm happy to let any, if any of the commissioners want to look at the information, it's PowerPoint information. So if anyone would like to look at it, I'd be more than glad for you all to look at it and, see what you think when you look at the information.
Well, last month, the commission denied this course.
That's right, they didn't approve it. Now, as I say, it's now more broad-based than it was before. Before, it really was very much a niche situation, and it is much more broad-based now. It's really the commission's decision, whatever the commission determines.
Mr. Franks, would you like to make a motion?
I'd like to make a motion that we approve this course.
Is there a second?
Second.
Second by Commissioner McMullen. The topic is now on the floor for further discussion, if anyone would like to. Commissioner Bloom.
Well, yeah, I just want to know if courses involved with marketing are outside the purview of the commission.
In one of your rules, Rule 1260-05-.03, subsection 5A of that rule states, effective January 1st, 1993, the content of all courses approved by the Commission for continuing education shall be directly related to the following topics. There's a list. I don't know if you all have your books rather than me reading them aloud to you, or I can. There's 17 of them.
What page is it?
I have a printout.
It's on page 77. It's at the bottom, it's 5A. Starts at 5A.
I don't see anything in there that includes marketing.
And I don't really have an aversion to that, but we just approved A14, which is how to get your listing sold in today's market, which is actually a marketing course.
I think some of these topics could be construed, I mean, it would be up to you all if you think it could tie to one of these topics. I mean, this is pretty open-ended,
I also believe what Commissioner Frank said, that marketing is very much a part of what we do.
Is there further discussion? The motion is to approve course A20, made by Commissioner Frank, seconded by Commissioner Bloom. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, Julie.
There were no, so that takes care of everything on the education report. And so,
Could I ask a question?
Absolutely.
I don't know if this comes under education. I'm just thinking that maybe when we do have an education director, that maybe something this might be part of that duty. But it has come to my attention that I spoke at a real estate company this past week, and I don't think we're doing a very good job of getting of communicating what laws we make, what we change. I know everybody can go and watch 8 hours of video at all these meetings, but there seems to be a need for some way of us communicating these things, whether it be an email, a newsletter, something electronic. I'm not saying spend a lot of money on something, but
Well, we do the road show every year where the commission goes to different parts of the state where they go around and discuss the new rules and the law changes and all that.
But I've only been here since January, and I've been a principal broker for many years. And there's lots of stuff that I think people don't know, don't understand. There's the big issue about signs and advertising and what's a novelty, what's a promotional item. I just feel a need because I see it and I'm asked all the time and get calls from people, what does this mean and what does this cover? And I would like to throw that out there that maybe there be some way. I could see the education director might be the person who could get that out. I know at the Williamson County Association of Realtors, when there's any news, I mean, we get something 2 or 3 times a week from them, and I always look at that, and I always look at anything that comes from the commission, but I think there's so many people in the dark about what are the rules, and one of the things is this is a very confusing. It's hard for people to get their mind around these books, and this is 2008 edition. I know we're going to talk about that coming up, but I just feel like we need to have some other form of communication with the licensees.
right, and we do a newsletter quarterly, or probably more like 3 times a year.
Mm-hmm.
But I don't know that I don't know that conveys as a regular information as you're talking about. We don't have an email list. The state does not have an email list that would allow us to email every licensee, which would obviously be the best way to communicate about fun and exciting things that are happening and things that have might have an impact on them. And that's unfortunate because that, I think, really would be the most effective way for us to communicate that sort of information. We try to put things on the website, but I don't think people really, quite frankly, I don't think people use the website. They, C&I, Commerce and Insurance, is in the process of restructuring the website. We met, Kimberly and I met with the person yesterday who's working on that, but it'll be April of next year at least before that occurs, a redesign of that, which might make it more user-friendly. But if you can't get people there, it's not going to that's not going to make a difference. And I don't really know the best way to reach out to the licensees. I mean, I think email would be the best way, and that's not an option that we have currently. We have something called notify.gov, that we've encouraged individuals to sign up for, but right now that is used for, like, announce a public rulemaking hearing or to announce legislation. So it's not used for just things that you might want to say, hey, guys, look out for this. We really can't do guidelines or opinions, and so that I think
And it's
probably-
not even that. I'm just thinking, if we change a rule.
Right.
Like I missed the meeting last month, and it's a very important thing. It goes to marketing, it goes to money in realtors' pockets as to how they advertise. There's been a question about what is advertising and the rules that are with that, so.
Well, right, but that rule, but what they talked about last month, they made a change to the rules that are pending that haven't had the public hearing
Right,
yet.
and those are, as I kind of mentioned when we were talking about the rules, those are getting ready to be posted. The draft, the proposed rules are getting ready to be posted on the Secretary of State's website. They've been filed. I don't have control over when they actually go up, but they should be available for anybody to look at in their entirety as soon as the Secretary of State posts them. A Notify app email will be sent out to anyone who's signed up for that, notifying them that these rules are posted. Also, it will be posted on the website. It will be posted on the tn.gov website. I'm sure that Deanna Fankhauser with Farron Bates, she has been asking about them a lot, as has corporate counsel for one of the larger firms in Memphis is called. The word is, we're going to try to spread the word about those any way we can as soon as they're posted, just because up until now they have been drafts that we couldn't distribute to anyone because they've been in a constant state of flux. Once they're posted, that's what will be considered at the rulemaking hearing in November. Notice will be sent out in every way that we can using the Notify app for anybody that's involved, posting to the website, things like that. At that point, people can come into the public hearing and make comments and discuss that, ask questions of the commission if they want to. That's the forum for that. Then again, they will be posted after that once the Attorney General has reviewed them again for constitutionality. They'll be posted again at the Secretary of State's website for 90 days before they're effective, and the Notify app will then again go out and say, hey, here's the rules that will be effective in 90 days. So there is some sort of method for notification for this set of rules, because right now they are still just proposed rules. There's nothing in effect.
But even what you've just said was confusing. I just, if there's some way that, I don't know what it is, I'm just kind of putting that out here for the commissioners. If there's some way that we could be, to get the word out more than, going to the Attorney General's site, and maybe it's the 90-day, or those kind of things. I think they're going to go to TREC site, and that's probably as far as they're going to go.
Well, it will be. Once that's up, we will post a link on our website that will be in all caps, proposed rulemaking for November 5th. Click here, and it will take them directly to it. Also, the Notify app will have a link directly in it where if somebody gets that email, they can click on it, see the full text of the rules. There should be no searching if anybody either goes to the real estate site or signs up for the emails.
So maybe we should, number one, go back to our associations that we represent across the state and let them know about those things and how people can find out. It's cumbersome, and not knowing what to do is a big problem.
But until the rules, well, as Julie said, they were in a draft state up until this point, so they really weren't out there for the public to see. They have to go through the process of, the initial stages of rulemaking. Then once the public hearing, then they'll be posted for the public hearing so that individuals will be able to read them and go, oh, gosh, I hate that. I'm going to go in and comment about that. I'm going to write a comment about that. And certainly I think the commissioners themselves want as many comments as they can get from individuals. And then after that, they'll have to go back up to the AG's office and be posted again at Secretary of State. So they won't become effective again until maybe 6 months or 90
days
depending on how
after the
long
second
they are.
posting. So,
Right, but they have to go to the AG's office after the public hearing.
After the
hearing. There's a delay again after
But at each
that.
stage, both before the rulemaking hearing and then at the time that they're posted, just to notice that they're going to be effective in 90 days, we've always created a bolded link right on the TREC homepage where someone can see new TREC rules effective date ABC. you can click on that and it will immediately take you to the full text. And like I said, the Notify app is been encouraged, mentioned, and we mentioned them in the last seminars we did. There's information on the website for that as well, and that's really helpful for anybody that signs up for that, because again, you get a direct email with with a summary of the notification and a link directly to
That's what our boards need to know is about that.
But that does
Thank
only
you.
get you to rules or statutory changes that we, right now,
It's
can't
helpful
use
'cause
that.
it's a
It is
push
helpful for
email.
that. And I mean, if there are any ways that anyone has suggestions to reach the licensees in more frequently than we can, certainly we're welcome, to hear them, because we get a lot of emails that we might be able to avoid getting if we could answer some of those questions that people have on the front end, because a lot of people do have the same sorts of questions that they ask. I mean, certainly I get a lot of emails that are about the same, basically the same thing. But we can't give a legal opinion or advice, and really guidelines we can't do. So that does sort of limit us a little bit in giving generalized information that's just not the statute or the rules.
Commissioner Hills.
On the Trek One, it asked, and it's a very small area, but it asked for email addresses. And I understand that's for people transferring or whatever they're doing. Is there a way to start collecting a database without making us
sign up for notify.gov?
Yes.
Notify, this is my understanding, and Julie may know more about this, but we did discuss that with the web person yesterday. The notify.gov has the privacy release information contained in it, and the ones that we get, just that you put on your Trek One or you put on your application, that does not have any privacy protection, and so the state doesn't, they want the notify.gov because it does have those protections built in. That's my understanding. And so that makes that's why the notify.gov is important, and hopefully we hope someday that there's a list created from that. But right now, the last time I checked, we have about 33,000 licensees that are firms or affiliate brokers or timeshare people. And of those, only about 1,600 have signed up for notify.gov. And probably 15 of them are sitting right here and in the back. So that's not, that at least would be one way to reach people. And I think people are kind of hesitant. I think they think it's sort of, they're a little hesitant to sign up for it, but it is very, very beneficial.
Thank you.
So in general, it's been real frustrating to me for brokers and people, other licensees calling and going, when are you going to do something about this? And we're trying to do something about it, but we can't tell them what it is because it hadn't been posted on the AG's website yet.
It's Secretary of State, but you're generally right,
Yeah.
yes.
Well, thank you.
Most often.
Just so we don't have people going to the AG's website
Yeah.
looking for
The
it, I wanted
Secretary
to.
of State's website. So for the first time over the next 60 to 90 days, we can say this is what we're trying to do. Now, the real problem I see is that some people are going to assume it's the rule. It's done. That's what has to happen.
Well, it does say in big bold letters at the top, notice of rulemaking hearing, and have the date on it, but
I know,
you're
but-
right, people won't read all of that, but unfortunately, that's,
Personally, I don't think it's this commission's responsibility to educate licensees about the law. It's the licensee's responsibility to understand the law. And so we're here to protect the public. And we're making a good step in that direction, but I think we still have another 90 days where there's going to be all kinds of confusion about what is or what isn't legal.
it's not quite 90 days. The hearing will be scheduled for November, but it's pretty close, so there should be a good length of time for people to review these and get their comments together if they do want to come address the commission in the November meeting.
Will you let us know when it's posted?
Yeah, I've been watching for it today. It's just not up yet.
Okay,
so.
thank you.
Mr. Chairman,
Collins?
we have an auctioneer commission letter that comes out periodically, quite frequently, and updates on the rules, possible changes, non-changes, kind of like the real estate commission used to send out, and that was very helpful. I just want to pass that along.
But we do have one that goes online, like.
Oh, this one is
It's more,
snail
shorter and more
mail.
frequent, huh?
This one is snail mail.
Oh, they actually mail it.
I think it's Nashville Auction School that sends that.
No.
Is it, Ressa puts it together, so I believe Ressa or Hanson puts that together for them.
Ressa puts it together.
I don't know what you're talking about. I just get a letter from the auctioneer commission.
You get a letter from somebody, don't you?
Yeah.
I'm pretty sure that Nashville Auction School puts that together, works with the staff to put that together, and RESA with Nashville Auction School puts it together and mails it out.
All right, other discussion on this topic that Commissioner Franks has correctly brought forward? If not, then let's, is there a request for a break or anything at this point? Okay, we got about half an hour before we'll break for lunch. Ms. Crop? Yes, sir.
Maxwell, I thought sometime the last 9 years, we had decided to quit sending out those pink cards for renewal and was going to send out a more business-like matter.
I thought we decided that last year.
We have one of those, the old type. We have one of those available, and you can call we have one available online. You have one, you can call the IVR line and get one.
Got the pink card myself. My license due, and I expected a nice little letter.
Invoice?
License were due.
The invoice costs a little more money than the pink card. I looked into it in November, December. If you would like me to look at that again and see about sending that out, I can.
Thought it was a motion made and passed that would happen.
I'll look and see. I did look into that when we ran out of the pink cards the last time, and we had to print additional. I mean,
I thought that's the reason we're still getting them, because you're trying to use them all, and you've had another batch.
Well, we got to use the rest of them right now, but we order I've forgotten how many we ordered, 25,000 or something. But
I got that, but I was,
well, good. I'm glad you got
I was a little
it.
surprised that we were still getting them.
Well, I'll look into that again and see the cost difference. I figured up the cost differential the last time to see whether, I wish we could just quit sending renewal cards, renewal notices, period, because we don't have to. We're not obligated by statute or rule to send any notification at all. Or if we could do it by email, which would be great, but we can't do that right now by
Wendell, are
email.
you wanting blue cards instead of pink cards? No, we're wanting something official looking.
All right, any other small talk there, Commissioner Alexander?
Nobody's told us we've got a new commissioner.
You step forward. I didn't hear it.
I'm talking about not a commissioner. I'm talking about a,
Giannini's position.
Maybe he'll stop by. Yep. All right, Eve,
on almost everything I needed yesterday.
is your report?
I hesitate to start in at this point and then
Right.
stop it. If you all would rather do some of the items from the complaint report, that way I could just begin it after our appearance after lunch
Let's
and not
do that.
interrupt it. It's up to you all. I can start it now. I'm prepared if you want to.
Without objection. Ms. Maxwell, it's up to you.
I'll go ahead and get through what I can get through in my report. That way Julie can do all hers at once. It's probably easier for everyone if hers is all done and sort of in a continuous motion there. The first thing on the director's report is the complaint statistics, and they sort of are a little bit different than they used to look before when Connell was here, just because this is the information I had at hand. But right now, we have 162 open complaints. That's as of 7/31/2014. And from 7/1/2014 to 7/31/2014, 21 complaints were closed, at least from the last meeting. And in the year 7/1/2013 to 6/30/2014, there were 340 complaints that were closed during that time frame. And then the monies that were collected from the complaints for the month ending July 31st, 2014, from consent orders, there was $10,750, reinstatement fees, $36,890, E&O, $1,200, for a total of $48,840 that were collected in the month of July. And if you look at the penalty monies collected chart, which is the longer chart. It shows the civil penalties that were collected throughout the fiscal year, beginning July the 1st of 2013 and ending on June the 30th of 2014. And the total of civil penalties collected during that 12-month period was $323,441. And are there any questions about any of that?
I struggle with this every month. So the staff handles some complaints internally.
Well, some are not complaints.
Right,
Well,
so-
violations. Let's just say somebody sends a picture of a sign in. You guys handle that internally?
But the reinstatement is the, like the bigger number that you see here. That's people whose licenses have expired.
I'm just trying.
Right.
There are people, they'll send you an envelope with a picture, not
Right.
on this picture, okay? And the staff look at it and go, that's a violation of our rules or statute, and you call that person and say, if you'll send us $250, we're done.
We would have to send an official citation. We couldn't just like ring them on the phone and say, hey, listen, if you'll send us that money, we'll be letting this go.
I think that's called extortion.
We send them a consent, we either send them a consent order, which is opened as a complaint, but it doesn't always go all the way to Julie because they may pay from the citation stage. Other people don't pay from the citation stage. During this last 6 weeks, everything has been opened as a true complaint and gone to Julie. Like opened and there have been no citations, everything's gone out as a true complaint.
So Julie gets to work harder.
We got 3 boxes over here for this afternoon.
Yes, so we'll start sending out citations again now, but for the last 6 weeks, everything's gone out as a complaint with no citations.
In the disciplinary action report, no, that's not what I'm looking for. When you have total number of complaints, are citations included in that total, or are they separate?
We would spin those out. You all had asked us to spin those out. So if we had citations, like a citation that you all changed the penalties for in the May meeting, then those would be spun out separately from the consent orders. The consent orders are the actions that are taken in here during the reading of the legal report. But they're all lumped together on the big sheet. Like on the long sheet, they're all lumped together. We've broken them down on the short sheet so that you could see the way that they were broken down. And then the E&O obviously is the penalty fee. But if we'd had some citations this month, they'd be listed out there.
So what she's saying, I think, is a short answer. The long one that you're seeing, that's including reinstatement fees paid, consent order, civil penalties paid, any citations, and E&O penalties. Did I say E&O? E&O and reinstatement, consent orders, and agreed citations. Those amounts cover all of those. It's not just from the consent orders you've authorized.
Are there any other questions about that? If not, the licensing statistics are the next item on the agenda, and those you can. Right now we have 24,795 active licensees, and that's up 235 from last month. Our inactive licensees are up 58 from last month. We have 1,185. Our retired individuals continue to go down. We have 7,663. That's 67 less than last month. That number's continued to go down each month. The broker release, we have 352 people in broker release, and that's up from last month. And of those 352, we have 145 affiliate brokers in broker release. We have 7 brokers in broker release and 202 timeshare people, or 201 timeshare people in broker release. That actually comes to 353. That was our number that we ran on 8/4. So that's how our broker release number breaks down. We have a grand total of active licensees, individual, 33,994, which is 272 more than we had last month. Our firms, we have 3,886, that's up 1. Our retired firms are down 8, we have 207, and our total number of firms is 4,093, which is down 7 from last month. Our number of licenses issued for the month of July was 382, and the firms retired and closed was 15. If you go to the additional statistics, which Kimberly put these great little pictures on that you can see with the little people in the house, the comparison between the number of licensees that we have, 7/31 of 2014. Our total number of licensees right now is 34,051. And in 13, this time in 13, we had 33,857. So we are up from last year, and each month we've gone up just a little bit from the month, that same month last year. Our firms are up a little bit from last year. We have 4,093, and last year we had 4,071. Then if you look at the, go several pages in and you look at the exams that were taken, in July there were 360 exams taken. Year-to-date, we've had 2,035 exams taken, which is less than we had last year. So we've had a decrease in the number of exams taken, which hopefully will end, and we'll back up and having people take exams again. The next page is just a breakdown of the types of exams that have been given this past month. And then our renewal, our percentage of people who have not renewed their license after the 60-day period passes. So it's individuals who have had passed the, their license expired, and then they had 60 days in which to renew their license. Those people who have not renewed at the end of that time are 24%. So that's our non-renewal rate, which, as you can see, if you look at the chart, and this is close to the second to last page of the information, it's gone up. This percentage number of licenses not renewed has gone up just really over the last year. It's the last 2 months have gone up quite a bit. And a lot of the people whose licenses are not renewed are individuals who are in a retired status. So I don't really know if this is just a group of people who are aging out and would have let their licenses expire, or there are other reasons that the individuals have allowed their licenses to expire. And some of those individuals may end up reinstating, as a number of these people in the room have done in the last, wanted to do. So once that 60 days is over, and the 61st day you enter the reinstatement period. And those individuals, I say, who didn't renew during the first 60 days of the renewal period, they may, in fact, then reinstate at a later point in time. Are there any questions about any of that?
So we revoked a boatload of licenses last month.
We did indeed.
And how does that show up in the statistics here? Where does that show up?
Well, it's not listed in those statistics, because the revoked number, well, if you run our numbers and you look at the revoked number, it's a cumulative number. So we have broken down ourselves the people that we revoke. So we have a running list of the individuals who were initially suspended for E&O on 7/1 of 2013. And then once their year passed, at 7/1/2014, the statute requires us to revoke those licenses. And so at this point in time, we have revoked 503 licenses. And those 503 people were all in suspension for at least a year prior to having their licenses revoked. And this is for E&O, not for other reasons. This is for E&O. So you can see that from the individuals who've revoked, there have been 222 affiliate brokers, 15 brokers, 25 principal brokers, and 241 timeshare individuals. Surprisingly enough, we have had a number of calls from individuals who've now realized their licenses are revoked, who want to come back, and they want to know what they have to do to come back. Well, if the commission will recall, there was a statute that was passed by the legislature that became effective in July of last year. And then there were rules that that the commission adopted and became effective in May of this year. Those rules in the statute state that if you want to come back after your license has been revoked, that you can request a formal hearing in writing, and that's a true formal hearing before an ALJ. And once that formal hearing is held, the commission does not have the discretion to waive the penalty fees. The commission can decide whether they want to waive any or all of any additional education that the person might have due, or any of the testing that the person would have due. Anyone that retests and reapplies has to meet the current educational and testing qualifications and application qualifications. But the commission, as I say, cannot waive the penalty fee. That's what people don't like, and that's what people, because the fee right now, and will remain for those individuals who are revoked, it's $1,200. And a lot of people, I think, thought that maybe they could let their license expire and then they could just retest and reapply and it would all be good. But the $1,200, once it attached. So that's going to be, that has to be paid regardless of if the person retests and reapply, or if they request a formal hearing that would be before an ALJ and the commission, if the commission chose to hear it as well. And then a determination, as I say, could be made about either the testing or the educational provisions. So you all may get calls from people who ask that question. A lot of individuals who've called our office aren't really all that happy about the answer that they have to pay the $1,200. And I mean, I understand that. A lot of them obviously are already expired and now they're revoked. But that is, that's what the statute says. And hopefully everyone will get E&O when it's due on 1/1 of 2015, and we won't have this issue. But we will continue to revoke licenses as the year goes on. So we have some others that were suspended last August. And so as those dates roll, Betsy will suspend those, revoke those people. And if people don't have E&O, licensees don't have E&O right now, they're being placed in suspension. And if they don't show proof of it within 30 days or deal with it otherwise, in the months following, at the 12th month, they likewise will be revoked. So it's an ongoing process with us as the people, as individuals, don't have E&O, don't show proof of E&O, and get suspended and then ultimately revoked. Are there any questions about?
I'm a little confused about, so does it mean since the first of this year, 43 principal brokers have been suspended or revoked?
Since 7/1 of 2013, which is when the law became effective, statute became effective, are you looking at the update on E&O? Is that what you're, okay. The principal brokers, there were originally 74 that we suspended. That was like originally on 7/1. And then 31 of those actually showed proof of E&O, and that's of the initial ones that we suspended. And so then on 12/30/13, 20 remained, so that some of those that we had suspended throughout the year also showed proof of E&O. And then there were 18, some of them paid, some of them rolled off the suspension. And so then when it came time to revoke, there were 20, on 7/1 through 7/31, there were 25 principal brokers whose licenses were in fact revoked.
So do we know that those principal brokers have been replaced?
A lot of those principal brokers had been expired. They were all in problem status or their firms had been expired. So when they're put in suspension, their firm is put in problem status. So they're, they shouldn't be practicing, which doesn't mean, quite frankly, that they might be practicing or not. So that's sort of, so there are a lot of principal brokers, and those principal brokers have they've been just the same principal brokers. That list has not, after the first few months passed, that list has not varied much at all. They've usually been fewer in Tennessee than there have been out of state. A lot of the mail that we've sent to those principal brokers has come back, so they may not even be in the same location that they were when we originally started out with them. So it's a pretty big number of people that were revoked, quite frankly. And as I say, hopefully it does leave an impression and people will get their insurance when it's due. Those that have state insurance when it's due on 1/1, get it before 1/1 so it's in place. Are there any other questions about the E&O? I mean, it's a little bit, I know it's a little bit confusing because it is we just have a running list of people that we suspend them and then we revoke them. And so it's kind of an ongoing list, but we have a master list that we can see, and we can see who paid and who showed proof of E&O. So if there are no more questions about that, then the next thing is the E&O second quarter results, which Rice sent. And I had Cindy write quite informative, I thought, little explanation of what the boxes on the printout mean so that the sheet makes a little more sense now that looking at it with that information that Cindy sent. And I know I sent this to you. Do you see it?
What is it?
It's the E&O second quarter results.
I'm finding that. On the iPads?
It should be on the iPads.
Which number?
I don't have my iPad open. It might not have gotten on there. I can make a copy of it and we can talk about it after lunch. I had sent you all a copy of it before with, it's this little box chart.
We don't have that.
I can make a copy of it at lunch and put it, and then you can look at it. It's the information that Rice has to send every quarter to us, just under the contract they're required to send it. So it shows the total amount for claims and the total amount that they've reserved for losses. And as I say, she wrote a cover letter this time so that we would have an explanation of exactly what the numbers on here mean. But I can run that and we can talk about that after lunch if you'd like. The next piece of information on the report is the discussion of the manuals. I don't know if I sent some information about the manuals. I got some updated information on Monday that was basically the same as what I had gotten on Friday, that the administration has decided that there was an RFP that was going to be needed in order to get manuals, and really it will be an online resource that the RFP, which is not let yet, it won't be let till mid to late August. It won't be released for bid until mid to late August, but it will include, as I say, an online resource that will be able to be updated within a short period of time of any changes. It will have, I understand, a print function that will allow it to be printed if an individual so desires to print that manual. And it hopefully will be up. It is the focus of the RFP, so there's not a lot of other things I understand that are in the RFP. This is the focus of the RFP. So that should be the RFP, the bid should actually be let and the contract signed sometime by mid-October, and hopefully sometime before the end of the year, this resource will be available. I don't know whether that's, the time frame right now, they're not exactly sure of what the time frame will be, but the contract, the RFP is to be set for bid in the next couple of weeks, and then we'll know a little bit more. And then once the bid is let, then obviously we'll know exactly what's going to be out there. But it will be, as I say, an online resource that'll be available with the rules and with the statutory information in it, and it'll be an official version of that.
How frequent would they anticipate updating that information? How current will that be after it goes on?
Since the RFP hasn't been put out for bid, obviously I don't know what it says. I'll be able to read it once it's out, because I'll go online for a bid, so you'll have the specs in it. But Rachel Power is she's sort of head of that program, and she's thought that it was about a 15-day window that they would have to update information on there. Now, with legislation, when it becomes a public chapter, there's a period of time where sometimes the statute has to be written, so that might take a little period of time. And if you remember from the memorandum that I wrote, LexisNexis Michies, who publishes our statutes now for the state, has the state contract. They actually, anything that's passed in the legislative session in the spring is not usually published by them until October, November, or December of that same year. So there's a 6 or 7 month lag. I got the impression that this would be a turnaround more quickly for the statutory material, and that was the concern all along, and that would be part of the equation, that would be faster. But certainly rules would be, the rules, as soon as they were effective, you could get those up easily in 15 days. And they would be integrated into the book so that it wouldn't be like a pocket part, which is what Julie, say, for instance, has in her hard book, or like we had now that was just adjunct to the information that we had. It would actually be integrated so that you would know that what you were reading on there was the up-to-date, real, live information. And so that would be a better resource for the licensees than trying to go back and forth. And it would be free to the licensees, as it were. Obviously, the reg boards will pay for it and will be charged accordingly, not by how many people look at it, but just whatever the chargeback will be. But it will be free to the licensees, which is better than the cost of the book, which they would have had to pay for the update even after they paid for the initial book. But if you would like either Deputy Commissioner Giannini or Rachel to come and talk next month after the bid, which, as I say, is supposed to be be released to the website for bid this month, I can get one of them to come and chat about it a little further if you would like that next month. Would you like that?
I would.
Okay.
I'd like for them to be aware of the concerns we have.
And I've told them that you're aware.
Commissioner Franks has expressed.
And I've made them aware, but I told them that that you all might want them to come and update them and give you a little more information, since it's being handled out of the administrative offices. That will be, they will have a lot more firsthand information about it and be able to give you a lot more information. So I'll ask one of them if they'll come and update you next month on that.
Just out of curiosity, is Commissioner Giannini here? Thanks. All right, I think this is a good time to take a break. Before we do that, Ms. Betsy, do these attendees need to do anything on the way out? All right, we'll be back at 1 o'clock. Will they sign back in when they come in, or just? No, they only sign in once, in the morning and then once at night, not for lunch hour. All right, we'll see you back at 1.
I gotta run the rest.
Good to go. Robert McHugh, Daniel Lane, are you in the building? If you two gentlemen will come up and take these 2 chairs at the end of this desk right here. Oh, I'm sorry, gentlemen up here. My fault. And before you sit down, Ms. Kropp will swear you in.
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Thank you, gentlemen. If you'll sit down, we'll ask that you speak into that microphone. And which is Mr. McEwen? Okay. So, Lane is with the white shirt.
I had it on, okay.
That's all right. Just listen for a second. Ms. Maxwell's going to read into the record, and you guys pay attention to what she says and see what you think about it.
Robert Byron McEwen has applied to be an affiliate broker, and he has passed the affiliate broker exams and is here today with his principal broker, Daniel D. Lane. Mr. Lane is the principal broker of ABL Realty Services located in Nashville, Tennessee. Mr. Lane was first licensed as an affiliate broker in Tennessee in 1985 and licensed as a broker on 11/18/1988 and became the principal broker of ABL Realty Services on 9/2000 when the firm was first licensed. The track records reflect that the firm currently has no affiliates and no brokers except for Mr. Lane, the principal broker. Mr. Lane has had no disciplinary action taken against him by TREC. Mr. McEwen revealed to us the following on his application. On 9/3/1997, Mr. McEwen pled guilty and was convicted in the General Sessions Court, Criminal Division of Davidson County, of one count, simple possession of marijuana, third offense, which was a misdemeanor. For this conviction, Mr. McEwen was given a sentence of 11 months and 29 days, which was suspended for supervised probation. Mr. McEwen completed all portions of this sentence. On 11/19/1998, Mr. McEwen was convicted in the General Sessions Criminal Court, Davidson County, Tennessee, of one count of sale of controlled substance, which was a felony, one count unlawful possession of a weapon, which was a misdemeanor, and one count violation of probation of the 1997 conviction and sentence, which was a misdemeanor. For the violation of probation, Mr. McEwen served 90 days in jail. For the felony conviction, Mr. McEwen was given a sentence of 1 year, which was suspended for supervised probation. For the misdemeanor weapon conviction, Mr. McEwen was given a sentence of 11 months and 29 days, which was suspended for supervised probation. Mr. McEwen completed all portions of this sentence. 10/18/1999, Mr. McEwen was convicted in the General Sessions Criminal Court of Davidson County on 4 counts of the sale of a controlled substance, marijuana, 4,536 grams to 31,696 grams, which is approximately a range of 10 to 70 pounds. That was all felonies. Each of these felony convictions carried a sentence of 3 years in jail. However, the court ordered Mr. McEwen to serve 5 months in jail and suspended the remainder of his time for 4 years of supervised probation. The sentences for 3 of the felony convictions ran concurrently, and the sentence for the 4th ran consecutively. On 12/18/2003, Mr. McEwen was convicted in the General Sessions Criminal Court, Davidson County, of one count of assault, domestic fear of bodily harm, bodily injury, which is a misdemeanor. Mr. McEwen pled guilty and was sentenced to 11 months and 29 days at 50%, so he was on supervised probation for 6 months. He completed all portions of the sentence. On 7/17/2013, Mr. McEwen entered into a plea agreement for one count of casual exchange controlled substance, which was a misdemeanor, and he was sentenced to 10 hours of community service. Mr. McEwen states generally that all of the convictions listed resulted from bad choices which he began making shortly after turning 18. At that time, Mr. McEwen states that he became a father and a felon and surrounded himself with individuals who were involved in drugs and other criminal activities. After his multiple felony charges and convictions and time in jail described above, Mr. McEwen decided to focus on changing his life and leave the criminal elements behind. Except for his incident in 2003 and one in 2013, Mr. McEwen states that he's successfully overcome his past troubles. Mr. McEwen has put himself through Nashville State and Tennessee State University. He has 36 hours remaining in order to receive a bachelor's in business administration. He obtained his master barber license. He mentors at-risk teenagers and adults and actively participates in food and toy drives.
All right, Mr. McEwen, would you like to fill in any blanks, to give us as much history as you'd like?
She was pretty accurate with how my record rolls out, but all of this was a long time ago for the most part, and it wasn't easy to not end up in a lot worse of a situation. I was a first-time felon at 18, and not trying to make an excuse for what I done or justify anything I done after I turned 18. The choices I made were just really bad. And you know, once I decided to look in another direction and to change my life, that was the hardest thing I had to do. And even as far as obtaining this license, this hasn't been easy. So what she said was very accurate, and I'm not trying to justify or play the victim or anything like that. I just really want you to believe that I changed, and I'm trying to continue to change. That's it.
What about the charge in 2013?
Yes, ma'am. It wasn't my car. It was. Okay, I'm just going to be 100%.
Tell us what happened.
I'm going to tell you exactly what happened. In 2013, it wasn't my car. It was outside of my barbershop where I worked. And so I had went to take the car to run to the hair store. And the task force, this wasn't regular police, or it wasn't I was breaking any kind of law. This was an 8-man task force swarmed the car. And they were, you know, what's in it? We know something's in it. We know something's in it. We know something's in it. And I knew that it was something in the car before I even got in the car. So when I told them what it was, they were like, oh, this little stuff, and, you know, pretty much just gave me a citation and let me go. But it wasn't a case of me out driving recklessly, or everything happened 10 feet from the barbershop door. So that was pretty much that.
What was your thought process as you're getting in a car and you know it has controlled substance in it?
I actually didn't think about it until, because everything happened so fast, because I was just driving across the street. And it was, well, across the street and down, maybe a quarter of a mile away. So I really wasn't thinking about anything until everything happened.
Was this your car?
No, sir, it wasn't. It was a client's car.
Well, how did you know it was in that car?
Because I know my client, and I knew I knew she had, because I know she smoked little bits of marijuana, and so I knew it wasn't anything. I was thinking more so of a joint or something like that, and it was a little more than a joint. So that's how.
So were these people observing her? Why did 8 people swarm a car?
Because of the kind of car it was. It was a Nissan Murano, and it had nice rims on it. I mean, she's a dentist, so she I mean, she's a professional woman, so it was just like, I mean, it was just insane how it happened. And basically all it was, in my opinion, was just a shakedown of, because at this time in Antioch, they were really trying to clean it up. So the task force was grabbing anybody they could to try to find out information about what was going on in Antioch. And I didn't know anything, so that's how I really ended up with the citation. Because it was more so, if you know something, then we'll let you go. And I mean, I didn't know anything.
But you agree that you used bad judgment getting in that car knowing that there was something in that car?
That was the worst judgment I've used in 10 years easy.
Other questions for Mr. McEwen? I have one question.
Yes, sir.
The range was between 10 and 70 pounds of marijuana back in 1999. Can you tell me about what that really means?
Well, it actually wasn't anywhere close to 10 pounds. It was more so a quarter a pound, 5 times. It's just how they word the charge. It makes it seem like it's 10 pounds to 70 pounds when actually it was just a quarter of a pound. And how the case ended up being, I was selling an informer a quarter of a pound, and I did it 5 times. So each time I sold him the marijuana, it was another charge, another case altogether. But there was never any 10 pounds or 7. Altogether, we're talking, I a pound and a quarter maybe. So it was never a 10 to 70.
So why real estate? What's got your interest in that?
I'm really good at talking to people and meeting people. Being a barber and stylist, I'm constantly interacting with the public, and one of the questions that I get asked the most is pertaining to real estate. Secondly, it's more so of a thing where it can work alongside me barbering. It's not a strict schedule. Like after I get my bachelor's, me trying to barber and work a quote unquote 9 to 5 is gonna clash a lot. But me doing real estate and being a barber, it'll work. It'll mesh better. I'm actually only getting my I'm actually only getting my bachelor's degree just because that's something I want. I don't even plan to go into the field because I'm so happy and I'm so successful being a stylist. So that's the main reason that I'm pursuing my real estate license.
Questions for the applicant? You think you can make more money in styling than you can in real estate? Is money an issue in this?
It's not about money. It's more so about being happy. I would be happier doing real estate and styling versus styling and anything else.
So how much time do you think that so you're going to be a part-time realtor then? Is that correct? Not full-time?
I'm going to be full-time.
And you're going to have 2 full-time jobs?
Well, I style mostly on Fridays and Saturdays. I moved all my clients to Fridays and Saturdays because one thing that I don't believe I got a chance to tell Mrs. Maxwell was before I was barbering, I also did home improvement, recording studio, lawn care, because there was no I couldn't get a job that would support me and 3 kids. So I learned how to be sort of a jack of all trades. So even now I still just barber for 2 days, 3 days tops, and the rest of the week I'm either doing lawn care, I'm doing home improvement, and then also I mentor a lot. So it's just about being happy more so than the money.
This man gonna pay you
step up there.
Gonna pay you a salary?
No, sir. It's more so commission based, but Mr. Lane.
Most profitable job you ever had was selling that marijuana, though, wasn't it?
It actually wasn't. It wasn't even the easiest job to do.
I've been easy, but it's pretty profitable, though, wasn't it?
It's when you run in the time that you spend, it's really not as profitable as one may think.
Okay, can we move on?
I'll just give Mr. Alexander his turn at the mic. All right, Mr. Lane, you don't have any agents and you're about to take one on. Is that your story?
At this time, I don't have any, but I've had some in the past.
What intrigued you about this candidate?
I've met with him and we've talked on 2 occasions, and I've asked many of the questions that you've asked. And he convinced me after talking that he want to and have shown that he can turn his life around. I'm very familiar with many young men, particularly black young men, who get a felony on the record when they're very, very young, and they have a very, very difficult time trying to overcome that. And if I meet a young man that I think has shown he can turn it around, even though he had the incident in 2013, I feel that I can hopefully have some influence to make him sure that he doesn't go back to that. And I love the real estate business. I'm happy with the business. I do property management. And I think we need very good young people coming into the business.
Questions for Mr. Lane?
What kind of real estate do you see him doing property management?
No, at this time, I talk with him as a residential agent.
What kind of
Now,
training?
primarily, my practice for myself is both residential and commercial. I've had agents on both sides, and I've had agents who have basically came and worked with me as property manager. I had one gentleman who just wanted to learn that business, and so I set him up to work with me as property management. I want to work with Robert to help teach him the basis of the residential real estate. I think he didn't say it, but he had some interest in learning the investment side of the real estate business, which I plan to work with him on also, and also teach him the commercial side of the business.
So could you tell us a little bit about what training you'll provide for this new agent?
Well, one of the first things is I have a notebook I'm going to give him for beginners in residential sales that I've obtained and put together from my involvement with the National Association of Realtors. I will be meeting with him on a weekly basis. I'm full-time and I'm in the office every day, generally from 8 to 6 every day. One of the things that I'm going to be pushing and pursuing, and he indicates that he has an interest in, that's education. I'm going to make sure that he continue his real estate education. I probably have over 500 hours myself in additional educational courses, commercial courses, and it's one of the things that I request of my agents, that they continue to take all the courses that is available to them, because I truly believe that the more you educate yourself, the better person you become.
So could you tell us, are you grandfathered as a broker?
Well, I got my license, when was it, 80, I can't tell, 86, 87, and I've maintained it since that time.
And so give us an example of like what education you might have taken in the last year for yourself.
Well, in the last year, I've taken the required course, I think, for, to maintain the membership in the National Association of Realtors. But I've completed 3 of the CCIM courses. I've taken computer courses at Nashville Tech when I first got my license, and I've taken several other financial real estate courses that was offered. And I even teach through the National Association of Real Estate Brokers. Many people are not aware of them, but it's predominantly a black group that got started, Association 1947. And I do teach a real estate development course. I probably read 2 real estate books 2 or 3 times a year.
Mr. Bloom.
I just have a question for Mr. McEwen. Can you explain to us your relationship with Jeremy Wilson?
Jeremy Wilson, he works at Metro Parks, and I've given free haircuts at Metro Parks. I've been knowing Jerry a while, over 8 years.
Free haircuts are to underprivileged young men?
Yes, and females.
I'd like to make a recommendation that we approve Mr. Robert McEwen's application.
There's a motion made by Commissioner Bloom that this applicant's journey towards getting a real estate license be approved, seconded by Commissioner Collins. Is there discussion on the motion? All right, let's vote. All in favor of the motion, say aye.
Aye.
Those opposed, no. It is unanimous. So here's the difference, guys. When I read this stuff, I don't think I can vote for this. And after hearing both of you, you are a people person, and you are taking on a challenge, I think, we wish you both the best of luck as you get going on it.
Thank you.
Because you need to remember, and this is very, very, very important, that this man has come in here and put his real estate license on the line for you. And likewise, you need to do the same for him, because if something happens, if you get in any trouble at all, he's going to probably be in more trouble than you.
I
So
understand.
don't do that to him, okay?
I wouldn't.
All right, good luck to y'all.
Yeah, Mr. McEwen, I was troubled by what happened in 2013. I hear what you're saying. That was a bad decision. You know, you had been clean for 10 years. Don't make that kind of decision again. Really, it was Mr. Lane's statements that really won me over. And so I have a lot of respect for him, and I have respect for you too. But don't make that kind of mistake again, because it could put you in a bad situation and certainly put him in an even worse position. And like Commissioner said, he's really gone out and put himself on the line for you. So,
Mr. Lane was, he's my third broker. I've had two other brokers to wait till the last minute before they backed out. And Mr. Lane was, you know, he it's just, it's so much deeper than real estate when it comes to Mr. Lane. It's not about the money. He teaches me so much, not just about being a real estate agent, but about being a man. So I definitely appreciate you all giving me a chance.
One more thing, it's fairly rare when the audience starts applauding after we do something up here, but I think most of them think we made the right decision on this one. Good luck, guys.
Thank you.
Good luck. Thank you.
All right, Ms. Maxwell, we're back to your report, and I think we're on the training program.
Right, do you want me to finish mine, or would you like Ms. Crop to go ahead with the?
Get yours done.
Okay. The training program, I had sent each of you some information about the training program. If you recall, there was legislation passed this past legislative session that requires that every program come up with a apprentice-type training program, or if you already have one in place, then there's just some statistical and historical information that needs to be presented to the governor and the Speaker of the House and the Speaker of the Senate and various other individuals. And so in looking at the affiliate broker program, the legal department suggested perhaps that it was actually implemented to be an apprentice-type program. And so I went through the history of the Real Estate Commission and the various and sundry books that we have there that have different actions that have been taken through the years. And it appears that there is indication that this could perhaps be the case, that the affiliate program was set up to be an apprentice program with the sponsoring broker acting as the mentor to the affiliate broker. And the course for new affiliates was to teach some of the skills that would be needed to actually go into the practice of real estate. And, you know, it started out a year, you had to take the course for new affiliates within a year after licensure, and then it was 6 months after licensure, and then it became a pre-license course. So there are a number of there are a number of things, like actions that have been taken through the years like that, that would indicate that this was set up to be, the affiliate broker was set up to be an apprentice program. And in the memo that you all have on the iPads, it sort of sets forth some of the rules that show that the sponsoring or principal broker is in charge of being, you know, of looking after and supervising the affiliate broker. And I'll list the rules and the fact that the statute in 6213-303, the principal broker certifies and affirms that an affiliate license applicant is honest and trustworthy, and he will actively supervise and train the applicant during the period the license remains in effect. That particular statement is on every one of our applications, and the principal broker, actually, where they sign that application, they sign underneath that particular statement. So anyway, I wanted to see what the commission thought, and if in fact the commission believes this to be the case, then Ms. Croppa and I can answer and address the questions that are asked about an existing apprentice program, and then bring those back to the commission for review.
Ms. Maxwell,
Yes.
the last sentence before you get to rules such as you need to take the bidding out.
I got that out of a, that's That's a quote from from that case. That's from that case, that Court of Appeals for the 2000 Court of Appeals case. That's actually a quote from that case. It was just kind of like to show that the courts had likewise recognized that. So that's the only reason why I left it in. Yeah, I would not normally have left that in there, but that was a direct quote from the. No, it was a direct quote from the Court of
It's interesting to
Appeals.
say that the courts, read that the courts say that the principal broker is.
Right, and it was really to show that that's what the Court of Appeals had said in this particular case from 2000. That's all it was there to do, just to show
Right,
that.
So here's what's in front of the commission at this point. So the legislature this year passed a rather strange bill asking for different commissions to come up with an apprentice program. The research that our executive director and Julie have done indicates that we might have that in place already just by benefit of the affiliate broker license. So the question in front of the commission is, are you okay with that? And if so, we can turn the staff loose to refine it a little bit. If you're not okay with it, then they'd like direction on how we should proceed.
Do you need a motion to turn them loose?
Well, I mean, here's the.
Or just discussion?
If the commission would like to take a different tact and go, we really need to develop a separate apprentice program to satisfy the state, then that's what the commission should say. If, on the other hand, you think this apprentice program equals an affiliate broker's training, then we can just go with that. So it's up to the commission.
Mr. Chairman?
Mr. McMullen?
Make a motion that we direct the staff to respond to the legislature's inquiry with information about the affiliate broker program and how that fulfills the apprenticeship requirements.
Second.
Sorry, Marcia, you have to be quicker. So the motion's by Commissioner McMullen, seconded by Commissioner DeChara, that we ask the staff to notify the state that we do have an apprentice program in place, captioned affiliate broker. Is there discussion on the motion? Commissioner Collins.
Oh, thank you. Before I left, I got an email from Columbia State, and a lot of the community colleges through the state's insistence are beginning to offer an intern program that they help fund all these courses. And if we could happen to change the name of this from apprentice to an intern program, I think it would carry more merit to the populace, especially where a lot of us have talked about it being apprentice a long time ago, and now it be a new program, and might get some state help in educating people. I just want to bring that point up.
Thank you. I think we're kind of, as far as the caption goes, apprentice is what the legislation calls it. So I think that's where we have to go. But that's a good point. Thank you, Commissioner. Okay, the motion's on the floor. You've heard the discussion. Is there further discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. It is unanimous. Thank you. Under miscellaneous, what does that mean?
I just had that in there in case there was anyone wanted to amend the agenda at the beginning just to cover that.
Smart.
So,
That was smart.
thank you. So
You're welcome.
we'll-
Fingerprint information.
Fingerprinting, it was just an update on the fingerprinting information. We've had 2,499 individuals have been fingerprinted. 20% have come back with an indication, and that's been consistent since the very start of the fingerprinting on 1/1 of 2014. And that we've had, this month we had 361 individuals that got fingerprinted. Are there any questions about that?
That 20% are people who there was a match. Is that how to
They're,
describe?
right, so 20%, 501 people have come back with a match that shows that they have something, and it could just be a charge. I mean, it doesn't necessarily mean that they have a conviction. It just means they have something shows up on their record. So those are the individuals then that we have to look at each one of those reports. But it's interesting, it has stayed at 20% since the inception.
Questions for Ms. Maxwell about fingerprinting?
Were there any questions about the budget? I sent that earlier. If not, then I just wanted to know, we have to sign a contract with an attrition clause in it for the Chattanooga meeting, which is which is October the 9th and 10th, which is a Thursday and Friday. I just wanted to know if anyone knows right now that they will not be there. I think that Commissioner Franks wasn't going to be there.
I'm going to be back on the 3rd. I was thinking it
Okay.
was the first week in October, but I'll
Okay.
be back, I'll be back on the 4th, so I'll be
Okay.
able to be there.
Is there anyone who knows that they won't be there right now? Okay, that's fine. I just wanted to make sure, since our attrition is going to allow for about a half a person to fall out, so just wanted to make sure of that. And then Arello, the only thing I had to say is that we did get approved to go to Arello, so Commissioner DeChara and Ms. Crop and I will be going to the Arello conference. It's the annual conference, and it'll be held in Philadelphia in September, mid-September. And that's all I have, if there are no questions.
Thank you, Ms. Maxwell. All right. Julie, you want to get started?
That's fine, I'm ready.
Okay. Okay, so let's thank you, Commissioner Franks. So to the audience, here's what's going to happen next. Complaints have been filed against different individuals against principal brokers, and the staff has processed those complaints. And today you'll hear narratives about these various complaints, and they've been any kind of indication of who the person or company or location is has been taken out. So you'll hear this commission discuss a recommendation made by the legal department after you hear the narrative of what happened. And sometimes it gets confusing. The commission has been provided with this narrative in advance. The legal department will make a recommendation. It's not unusual for this commission to question that recommendation, either accept it, reject it, or modify it in some form or fashion. So we've got several of these to go through today, and we will break sometime in there, but please understand, this group up here at this head table has no idea who the complaints are about. Is that correct?
Right. At this point, it's a probable cause determination, and everything's anonymous. The identities would become apparent if they were to be elevated to a formal hearing, which we're not having this month. But
let's just follow up with that for a second. So we'll make a decision. If we decide to fine or impose some penalty, that doesn't mean the respondent has to accept it. It's going to be offered to the respondent. The respondent can say, okay, I'll do it. Or they can say, that's crazy, I won't do it, at which point that respondent will have a chance to come to a formal hearing with an administrative law judge, court reporters, which is what we thought we were going to have tomorrow. However, that was settled. So this is just a step along the way, one of the early steps. That's where we're headed.
first, I'll read this statement at the beginning of all the reports. Any consent order authorized by the Commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. The first matter is 2014001031. Complainant is an investor of real estate who states that respondent, principal broker, told complainant that respondent could assist complainant and complainant's investors and clients in acquiring, rehabbing, managing, and selling property. Complainant states that respondent has been dishonest and has failed to account to complainant and complainant's clients. Complainant alleges that respondent has kept cash receipts, not kept proper books, wrongly evicted tenants, failed to maintain homes, made misrepresentations of the condition of homes in order to lease them, and has contracts to include non-refundable deposits. Complainant further alleges that respondent has charged complainant for services not rendered and has refused to account for escrow monies regarding complainant's properties and properties owned by several other entities, which complainant refers to as complainant's client entities. Complainant also states that respondent has refused to provide invoices for work respondent charged for and alleges that respondent admitted that invoices are missing. Finally, complainant states that respondent has not returned complainant's calls while they are in business together. Complainant provided a transcribed statement from one of respondent's former employees, copies of receipts for different properties, and handwritten notes regarding rent monies and deposits. The former employee stated that when a security deposit was received, the employee was instructed to write non-refundable on the receipt and that it had to be in the form of cash or a money order, and that money was given given to respondent. The employee further stated that there were several occasions where the rental property was not available to tenants who had already given respondent a security deposit. The employee also stated that rent money was collected by another employee and given to respondent in envelopes, but not all rent money was posted in the company's program or deposited in the bank for remittance to the owners. The employee further states that complainant bought properties, that respondent gave estimates on rehabbing the properties, and that complainant would give money up front to respondent, which was deposited into a separate company's account and used to pay contractors. The employee stated that respondent went over budget multiple times. Further, the employee stated that respondent would not authorize repairs such as lock replacements in order to prepare homes for new tenants to move in. The employee stated that appliances were taken from complainant's homes and delivered to another property that respondent managed outside of the property management firm. The employee also stated that an accounting student reconciles checks for respondent's property management company. The employee further stated that one of the tenants paid their rent directly to respondent and never made it on the company's system, which led to a faulty eviction. Further, the employee stated that the copies of receipts provided are of money that never made it to the bank or to the company's software program. It appears from the statement and documents provided by complainant that the former employee was instructed to gather receipts and other documentation while working for respondent and then quit. Respondent states that complainant formed an LLC, which invests in rental and investment properties on behalf of complainant and other investors in complainant's company. Respondent states that complainant selected respondent's company to source and buy properties with the intention of renovating and selling them to investors, and respondent was supposed to get a percentage of profit on sales. Respondent states that open books and reconciliations were provided regularly to complainant. Respondent states that approximately 40 houses were acquired by complainant's company and at least half were sold, but respondent never received any profit as originally agreed. Respondent states that complainant began forming other LLCs to buy property with other investors, and complainant negotiated a fee with a bookkeeper in the office to help with the books. Respondent states that the former employee who gave the statement with the complaint was an assistant who had no real estate experience and did not handle or balance the books. Respondent states that additional purchases were stopped and complainant refused to pay respondent profits because the homes were over budget. Respondent states that complainant fired respondent's property management company and hired a new company. Respondent states that respondent's former employee was hired by one of the complainant's LLCs, and complainant requested that the employee bring files, information from emails, and bank accounts, and other items. Respondent states that respondent made every effort to do what complainant hired respondent to do, and respondent states that the statement made by the former employee is misleading and contains no specific information. Further, respondent states that a complaint was filed in a civil court against complainant's company and respondent's property management company. Respondent further states that the former employee removed documents from respondent's office, and respondent has very limited access to any information to show books and records. Respondent states that the documents complainant provided show that receipts were written and that deposits to the appropriate accounts can confirm monies were deposited on time. Respondent states that this is a dispute over profits from the investment in the properties. Complainant submitted additional information stating that no agreement in writing was made regarding profit sharing, and they were just negotiations. Complainant states that respondent was paid in buyer's commissions once the properties were sold. Complainant further states that many move-in deadlines were missed and deposit money was not returned to tenants due to respondent's mismanagement of the property. Complainant states that it was discovered that rent was not held in an escrow account, and complainant set up an escrow account for respondent and told respondent not to disperse the money without landlord permission. Complainant states that respondent has still not accounted for rents, and most investors have yet to receive money in accounting for rents. Complainant states that another property management company is now managing the properties. An investigation was requested in order to attempt to obtain additional information. Respondent reported to the investigator that respondent was providing all records in respondent's possession pertaining to the request, but the former employee took files and financial information when leaving to work for complainant, and respondent filed a police report. A copy was provided. Further, the investigator forwarded information from complainant stating that an employee was paid a large amount of money for property and an income statement showing that a large amount of money was spent on repairs. Also from complainant, the investigator obtained reports from the company performing the rehabs, which outlined the deposits and payments relating to the rehabs, as well as reports relating to the operating and escrow accounts of respondent's property management company and a general ledger of income and expenses. The investigator also obtained documentation from respondent, including a listing of approximately 55 properties owned by complainant and the dates sold to other entities, most of which appear to be within the time that the properties were managed by respondent, and property management agreements between complainant's company and respondent, which laid out each party's obligations and duties and compensation. Also provided by respondent were files on each of the properties, some of which contained lease agreements. Respondent states that those which are without lease agreements were taken by the former employee, and the files included general ledgers outlining income and expenses. Additionally, accounting documents were provided. It appears that there were a number of properties involved, and the parties had a very involved relationship with regard to the properties. Additionally, the properties appear to have been transferred to new owners sometime within the management period. The documentation provided and obtained with regard to this complaint does not appear at this time to evidence a violation of track statutes and/or rules by respondent, and therefore the recommendation is to close.
Motion to accept council's recommendation.
Second.
A motion by Commissioner Collins, seconded by Commissioner Franks, that council's recommendation be accepted. Is there discussion? Hearing none, let's vote. All in favor of the motion, please vote aye.
Aye.
Those opposed, no. Motion passes. Number 2.
2014-002871. Complainant alleges that respondent, principal broker, same respondent as in complainant 2014-001031 above, operated a property management firm that managed complainant's investment properties. Complainant states that several attempts were made to contact respondent who failed to respond or provide services, including the fact that there was no management contract between the property management firm and complainant's company. Complainant states that complainant transitioned the properties to a different property management firm, and a request was made to respondent to settle the account. Complainant states that respondent did not show all appropriate income and expenses, and there was a shortfall of rental income on top of unaccounted expenses. It appears, based on the email correspondence between complainant and respondent, that complainant bought the investment properties from the investor complainant in the previous complaint 2014-001031, and it appears that the management of the properties continued as part of the terms of that sale. Respondent submitted a response stating that the property management contract was never entered that a property management contract was never entered with complainant. Respondent states that complainant purchased 4 properties from the complainant in complaint 2014-001031 above, which were managed by respondent pursuant to a contract with the previous owner. Respondent states that when complainant purchased the properties from the previous owner, there were third-party agreements of which respondent was not aware, which did not affect respondent managing the properties.
I'd like to make a motion.
Be my guest.
I recommend that we take the council's recommendation on this and close this one.
Second the motion.
Motion by Commissioner Frank, seconded by Commissioner McMullen, that the council's recommendation be accepted. Discussion on the motion. Let's vote. All in favor, say aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 3, please.
2014-006231. 2014-006232. Complainant is one of 2 owners of a property. Respondent 1 is a principal broker, and Respondent 2 is an affiliate broker. Complainant states that Respondent's firm was hired to sell the property. Complainant states that Complainant discovered that the property was occupied by unknown tenants, and Complainant contacted the co-owner, who stated that Respondents contacted the co-owner about possibly renting the property, but no documents were ever signed. Complainant states that Complainant contacted Respondent 1, who confirmed that the property was occupied and stated that Respondent 1 had done some repairs on the property. With regard to rent money collected, Complainant states that Respondent 1 stated that Respondent 1 was paying the rent proceeds to a bank toward the co-owner's bankruptcy, but Complainant states that the co-owner was paying on the bankruptcy by auto draft from paychecks, and Respondent 1 was lying because the bank denied receiving any payments. Complainant states that Complainant requested the money collected for rent and states that Respondent 2 refused. Complainant states that neither Complainant nor the co-owner knew that anyone was in the home because neither had signed documents giving Respondents permission to lease. Complainant provided a copy of the executed lease agreement, which lists Respondent's firm as landlord, agent, and owner, and the landlord agent's signature on the lease contains the signature of an unknown individual who appears to be unlicensed. Respondent 1 submitted a response stating that Complainant called the firm with a concern that tenant was occupying Complainant's property without Complainant's acknowledgement. Respondent 1 states that a meeting was set up with the parties, and Respondent 2 provided Complainant with the lease and invoices of work done to the property. Respondent 1 states that the seriousness of the matter was discussed with Respondent 2, and Respondent 2 apologized to Complainant. Respondent 1 states that Complainant has not demanded anything from the firm, and the firm strives to accommodate all clients and keep them satisfied. Respondent 2 submitted a response stating that the co-owner contacted the firm to sell the property, and the co-owner advised that the mortgage was behind and the property was co-owned by complainant, who may be hard to work with because they had a messy breakup. Respondent 2 states that respondents met with complainant and discussed the short sale process and complainant's filing bankruptcy filing. Respondent 2 states that complainant agreed to list the property with the firm but requested that the co-owner should handle the sale. Respondent 2 states that after several months of working to sell the property, the co-owner filed bankruptcy without notifying Respondent 2 or the lender, and the lender had to close the short sale file. Respondent 2 states that Respondent 2 suggested and the co-owner agreed to place a tenant in the home, and Respondent 2 found a tenant and did repairs to the property, and Respondent 2 and the co-owner agreed that the firm would be reimbursed through rental payments. Respondent 2 states the complainant called and was angry upon notification that tenants were in the home. Respondent 2 states that Respondent 2 accommodated complainant's schedule and met with complainant to give invoices regarding the home's upkeep, but complainant disputed the invoice amounts. Respondents provided documentation including an exclusive right to sell listing agreement signed by both owners. It appears that neither respondent accounted for money alleged to be owed by complainant. Further, it appears that respondent's failure to secure a written agreement with the owners to rent the subject property constitutes a failure to be loyal, and a failure to consult with complainant at all regarding tenants appears to be improper. Finally, the lease's statement that the firm was the landlord agent and the owner of the property appears to be a misrepresentation. Also, it is recommended that the Commission discuss the issue of the apparent unlicensed individual signing the lease agreement on behalf of the firm. The recommendation is for each respondent a consent order in the amount of $2,000 for violation of Tennessee Code Annotated Sections 6213, 312, 1, 5, 14, and 20, and 6213, 4042, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of consent order.
Motion. Other questions before somebody would like to make a motion?
I'll make a motion that we approve council's recommendation.
Second.
All right, we have a motion on the floor properly made by Commissioner Franks and seconded by Commissioner McMullen. Now, is there discussion?
Does anybody have any thoughts particularly? I'm sorry.
I think I'll separate that out.
Okay, all right.
And then we'll have that discussion. All right, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Ayes. Got one no? Okay, thank you. So the motion passes on a 7-aye, 1 no vote. Now, staff has asked for thoughts on this notion that perhaps an unlicensed individual signed for the company.
Well, and the reason I'd asked that was to see, I know it's not technically a failure to supervise the activities of licensed affiliates because this person does not appear to be a licensed affiliate, but my question was, and you may also see this as a violation of an existing matter that's already referenced in this consent order for this principal broker, but the idea of an unlicensed person, being allowed to sign on behalf of the firm, I didn't know if you all would see that as a supervision issue. It's not really under the way the statute is worded of failure to supervise the activities of licensed affiliates, but it's another issue that I saw that kind of triggered me thinking that there was something at issue with it. But it was more with regard to what all you thought with respect to the principal broker, who was one of these respondents already, so.
So neither of the licensees signed the lease on behalf of the company?
Oh, it appears to, and sometimes you can't read the signatures, but in this case, you can read the signature. It's legible, and it's clearly not the name of either one of these people. And I tried doing a search of our licensing system to see if the person was licensed. I could not find a person by the name. That doesn't mean the person couldn't have married or something in the interim, but I would have thought it would have been typical for the principal broker to have signed on behalf of the firm, or at least maybe the agent that had the agreement with them, which in this case there was no property management agreement, but at least that was the designated agent on the listing agreement or something of that nature.
Is that an anonymous complaint?
No, it's not. It's a named individual. It was one of the co-owners of the property.
So the question before the commission is,
Well, it was,
D-
it was more of a, did you see any kind of issue with
Right.
regard to the principal broker? Because I know that's something that typically comes up, and I was just trying to flag that issue because I didn't see that it really fit into the B15 failure to supervise licensed affiliates, but I thought it was worth mentioning to you all. And you may not, it may already fit into one of the existing violations, but it's just something I wanted to note.
Oh, if a principal broker allows someone to sign for the company. yeah,
And that happens a lot, probably.
Okay. And I'm just not familiar with some of the, it was just something that seemed odd.
I don't think it's a question about, the question is because it was an unlicensed person. This person was not licensed. Is that right, Judy?
Right, and it was more with regard, like I said, from the realm of the principal broker, who is this, why is this person being authorized by the principal broker to do it? But,
It's an administrative person, and that's part of their job description and part of their duties, and it's common practice. I don't guess we can.
Mr. Chairman, get this off the floor. I move that we not open the complaint.
okay, I just wanted to.
A second.
Well, let's just do it this way. Is there any objection to the concept? We're done talking about this and moving on to the next one. All right, without objection, Julius, we're done
Okay.
with that.
2014-006241. Complainant's firm was the listing firm for a property where respondent, principal broker, was the buyer's agent. The transaction did not close. Complainant states that buyer is in agreement regarding settling the earnest money situation, but alleges that respondent has stated that even if a mutual release is executed, respondent intends to pursue complainant and the seller anyway. Complainant states that respondent has been advised that complainant intends to have the funds interpleaded if a resolution is not reached, but complainant states that respondent is not acting in the best interest of respondent's client. Complainant also states that respondent is stalking complainant and others at the office and has notified the local police and sheriff and wrote a cease and desist letter to respondent. Respondent states that complainant is not being truthful and states that respondent and buyer refused to sign the addendum to the earnest money disbursement form, but respondent signed the disbursement form itself and sent it to the parties more than once. Respondent states that the addendum to the disbursement form removed any opportunity to file any complaints with TREC or any associations. Respondent further states that the buyer's earnest money has not been released and the seller or complainant will not release it until the addendum is received. Respondent further states that respondent has made many efforts to resolve the matter and have the buyer's earnest money refunded. Respondent further denies stalking or threatening complainant and or complainant's firm. Both parties attached documentation and correspondence. A counteroffer addendum to the purchase and sale agreement provides for an earnest money payment of $1,500 to be paid to a title insurance company. And according to an amendment to the agreement, the buyer agreed to pay an additional $1,000 under the conditions that it would be credited to the buyer at closing and shall be forfeited and made non-refundable upon a failed sales transaction, with the original earnest money to be credited at closing and contingent upon financing. An attorney for buyer requested the earnest money, and correspondence from respondent and the buyer states that the buyer will agree to $2,000 earnest money disbursement to buyer and $500 disbursement to the seller without additional addendums and clauses. Further correspondence from complainant states that the funds would be interpleaded. It appears that the earnest money disbursement and mutual releases were submitted by each side to the other. An email from complainant's affiliate broker states that an attorney was hired to settle the issue. It does not appear that there's a violation by respondent. Therefore, the recommendation is to dismiss.
So this has been interpleaded?
I believe, yes, it was interpleaded, but for one, this respondent's firm was not the firm that was the holder of the earnest money, and in fact, neither firm was the holder of the earnest money. It was made payable and sent to a title insurance company, which was the holder of the escrow of the earnest money. But I do believe I did receive, I think all the complaints were filed before it was interpleaded. I do believe it was interpleaded, and I did get a copy of a settlement agreement. There's some subsequent complaints that the parties have filed against each other, and it does appear that the money was dispersed based on that later received agreement.
I make a motion to dismiss.
Second.
Motion by Commissioner Frank, seconded by Commissioner Collins. Motion is to dismiss per council recommendation. Is there discussion? Let's vote. All in favor of the motion, vote aye. Aye. Those opposed, no. It's unanimous. All right, I think we're going to take about a 10-minute break right now. Is Travis Fuller here? Where's Travis? Okay, thank you.
I think a letter ought to be sent to that people.
So
Ms. Julie?
Oh, okay. 2014007321, 2014007322. Complainant in this matter is the respondent licensee in the previous matter, 2014006241, and Respondent 1, principal broker, was the complainant in that matter. Respondent 2 is an affiliate broker. This complaint appears to arise from the same transaction as the previous matter. Complainant states that Respondent 1 did not work within the scope of a licensed broker during the transaction. Complainant states that Respondent 1 failed to disclose that an unlicensed assistant had an ownership to the property. Complainant states that unlicensed assistant acted in the capacity as agent and received confidential information regarding the buyer's financial information. Complainant further alleges that false information was given which misled the buyer, and states that Respondent 1 sent an extension to the contract with no intention to honor it. Complainant states that Respondent 1 failed to supervise. Complainant further alleges that Respondent 1 failed to provide services to each party in the transaction with honesty and in good faith, failed to disclose to the party adverse facts, threatened to take adverse action to the client's interest, counsel complainant's client on how to terminate or amend a contract, and failed to work with complainant because of race and gender. Complainant states that the buyer entered into an agreement and had to extend the agreement due to delays in loan processing. Complainant states that the closing date amendment was sent to the listing agent, but the form was never signed by the seller, though an amendment with an extension was returned. Complainant outlined and provided correspondence regarding discussion of extending the closing. Complainant states that respondents later accepted another offer stating that they could not reach complainant to get an extension signed. Complainant also states that respondents uploaded content in MLS stating buyer's financing fell through, which complainant states is untrue, and further outlines correspondence discussing possible extensions. Complainant further states that a seller did not give buyer a 48-hour right of refusal to release the contingency, but instead terminated and breached the agreement. Complainant states that buyer should not lose the earnest money since seller terminated the contract. Complainant further states that both respondents were unethical in the transaction and complainant was discriminated against. Finally, complainant states that Respondent 1 failed to interpolate the earnest money in a timely fashion, even though a title company is the holder of the money. Respondent 1 submitted a response stating that the deal involved earnest money which was non-refundable, and the buyer retained an attorney who later withdrew. Respondent 1 states that an agreement was reached in which the seller was to receive $500 and the buyer was to receive $2,000, and the earnest money release was not executed due to discussions regarding filing complaints and other matters. Respondent states that an amendment was prepared to clarify the release's terms, but complainant contacted Respondent 2, attempting to receive money outside the contract in the agreement. Complainant states that an interpleader action was filed via an attorney. Respondent 1 denies other allegations, stating that Respondent 1's participation began when the earnest money dispute commenced, at which time Respondent 1 began to investigate the matter. Respondent 1 further denies allegations of discrimination based on race and gender, and states that the buyer was never mistreated in any way. Respondent 2 submitted a response stating that the other agent referenced in the complaint is not a licensee but an assistant who was involved in the transaction by forwarding and following up with communications, making copies and sending documents to lenders, title companies, and complainant for closing, following up on loan commitments and communicating loan progress to Respondent 2 and other owners, and secretarial duties such as delivering documents, ordering repairs requested by inspection, and making MLS updates. Respondent 2 states that the assistant did not perform activities requiring licensure. Respondent 2 states that the first extension expired 2 weeks before the MLS status was changed to active, and sellers exercised their right to market their own property. Respondent 2 states that the sellers were not willing to extend the contract because buyer was unable to obtain financing with lender 1, and lender 2 was unable to get the loan done during the extended time frame. Respondent 2 states that complainant's allegations are unfounded and the discrimination claims are untrue. Complainant submitted additional reply in response, stating that the buyer's attorney did not withdraw but put his representation on hold. Complainant further asserts that buyer acted in good faith and seller failed to provide adequate notice regarding a time frame of stipulations and performance contingencies regarding the extension. Complainant further states that respondents were dishonest and used an unlicensed assistant to act in the capacity of an agent with personal ownership rights to the property. Complainant further states that respondents did not provide records of their attempts to reach complainant and of their conversation with buyer without complainant's knowledge. Complainant further states that the property was marketed in a dishonest way. Complainant also states that Respondent 1 as principal broker should have been more involved with the matter. Complainant states that respondents slandered complainant. It appears that this was a contentious transaction. However, it does not appear that there is a violation of TREC statutes and or rules. With regard to the earnest money situation, it appears that the transaction documents show that the earnest money was being held by a title company, thus relieving the broker of responsibility for the funds pursuant to Rule 1260-02-.09 subsection 5. Therefore, the recommendation is to dismiss.
Do I hear a motion?
So move.
Second. Motion made by Commissioner McMullen and seconded by Commissioner Franks. Any discussion?
Yes, I think we need to be thankful and really rely on Julie, because it's bad enough when you have a complainant and a respondent, but we just switched roles. The complainant was
I'm
the
sorry, I hope
respondent
that was
previous.
clear. Yes.
It was clear, but unclear, so I agree.
Any other discussion? All those in favor?
Aye.
Opposed? Motion carries.
892014010161, 2014010162. Complainant is the buyer in the transaction referenced in the previous matter. Respondent 1, principal broker, and Respondent 2, affiliate broker, are the same respondents as the previous matter. Complainant asserts the same allegations as above, but states that the property was shown while complainant had a contract on the home. Complainant further states that the home was being shopped by Respondent 2 and Respondent 2's assistant in contract extension, and that Respondent 2 would not return calls. Complainant asserts that the assistant was acting as a realtor and replied to emails and participated in calls. Complainant states that this assistant was an investor in the property mentioned, and this fact was not revealed to complainant. Complainant states that Respondent 1 said the escrow money would be interpleaded in the fall, but had not as of the date complainant filed the complaint. Respondent 1 responded on behalf of the respondent, stating that the earnest money based on the extension was non-refundable, and this issue was discussed by phone and emails with complainant's agent. Respondent state that initially complainant hired an attorney and later that attorney withdrew, and that Respondent 2 attempted to work an agreement concerning the earnest money, but that complainant's agent would not agree. Respondent state that this...
Excuse me.
I'm sorry.
I'd like to move to dismiss this.
Second.
I have a motion by Commissioner Franks and seconded by Commissioner McMullen to dismiss. Do I have any discussion?
In the next 2-3 complaints, same thing?
No, this is the final one on this relationship. I'm sorry.
Well, I want to address this. If you've never had a complaint filed against you like I have, you would understand that you'd want to hear every word of it read. And if I was the person who filed this complaint, and you didn't read it, and you didn't give me fair warning, even though you recommended to dismiss it, I'd be on your case with my lawyer.
I always read the legal reports that were given last week
Oh, I did
before I
too.
come to the meetings.
That's not the target. Some of these folks never looked at it. Second of all, it's not getting on the record.
Well, the entire text
record.
of my legal report is included as part of the minutes.
I just think
So-
that's my opinion. Throw me out. I think it's unfair when you don't read the report. I've had a complaint filed against me, so I know how much damn trouble it is to get one of them filled out and answered.
Okay, so we have a motion on the floor
Second.
and seconded. All those in favor? Aye. Opposed? Okay, Julie.
Okay, 2014006311. Complainant states that complainant hired respondent's firm. Respondent is a principal broker, and a tenant was secured soon after a 12-month lease with an option to purchase. Complainant addresses a number of alleged problems with respondent's representation, including that animals were discovered on the premises without written permission, and an additional security deposit was requested but not collected, and rent was increased. Complainant alleges that the security deposit and last month's rent were not collected by the date required in the lease agreement. Complainant states that tenants paid rent intermittently and late. Complainant states that respondent's attorney gave notice of delinquency but no action was taken. Complainant states that complainant's attorney obtained a judgment in possession against tenants, and complainant is working towards securing liens against tenants. Complainant alleges that an additional agreement was signed to purchase certain personal items, but these items were not paid for and some items were taken by tenants. Complainant states that substantial damage was done to the property. Complainant states that respondent did not pre-qualify the tenants or do a credit or history check. Complainant also states that respondent was acting as dual agent. Complainant further states that the tenants worked next door to respondent's firm, and respondent was listed as a reference on the tenant's application. Complainant states that 2 additional adult children lived on the property, and contrary to the lease, tenants attempted to put horses on the property, and tenant operated a business out of the property's garage. Complainant further states that one of the tenants was on workers' compensation leave, which was not disclosed to complainant properly. Complainant states that respondent did not perform lawn maintenance or inspect the property, and states that the bookkeeper made accounting errors. Complainant further states that respondent allowed an unlicensed unlicensed person to engage in management services such as overseeing the move-in and move-out of tenants, and that person allowed tenants to remain in possession after the writ of eviction causing damages. Respondent submitted a response to an attorney denying the alleged violations and stating that upon discovery of a dog, rent was increased along with an additional security deposit. Respondent states that the tenants were periodically late with rent, and upon instruction of complainant, eviction proceedings commenced, but complainant chose to hire a different lawyer to take over the eviction process. Respondent denies that the property was destroyed or items stolen by tenants and denies that substantial damage was sustained. Respondent denies the allegation that respondent did not properly screen tenants and asserts that tenants were pre-qualified as required by the property management agreement. Respondent states that employers and prior landlords were contacted and respondent received verbal and written references. Respondent denies that respondent was acting as a dual agent and provided a confirmation of agency status executed by all parties. Respondent states that tenants' violations of the lease were in no way authorized by respondent, and every known breach and every complaint of breach was brought to respondent's attention was promptly addressed and remedied. Respondent states that the property was inspected on a regular basis and respondent managed the property in accordance with the property management agreement. Respondent also states that the adult children living on the property was not in violation of the lease and further states that complainant knew about the children. Respondent states the complainant participated in negotiations on delinquent rent and all extensions and or forbearances were approved by complainant. Respondent denies allowing an unlicensed person to act as an agent. Respondent states that respondent returned to the property with the unlicensed person after tenants vacated for final inspection. Respondent denies the allegation of accounting mistakes that the unlicensed partner performed real estate services and that the tenants were allowed to remain in possession of the property contrary to the writ of eviction. Respondent states that to the extent the tenants stayed in the property beyond any legal date of eviction, a law enforcement officer would have to enforce the writ. Respondent states that upon discovery of horses on the property, the tenants were promptly notified and immediately removed the horses. Respondent states that the complainant sued respondent in court and litigation is ongoing. Complainant submitted an additional response stating that respondent's response is untrue and reasserting the issues previously mentioned within the complaint in detail, including issues of alleged misrepresentation and accounting errors. The response indicated that complainant had sued respondent's firm for alleged violations of the Broker Act and litigation was underway. Upon review of this matter, Office of Legal Counsel confirmed with respondent's attorney that there is a lawsuit pending between complainant and respondent's firm. Due to the number of alleged issues, it is likely that more information will be discovered through the course of civil litigation which could be pertinent to the Commission's determination. And therefore, the recommendation is a consent order for litigation monitoring.
Anybody got any questions for Julie on this one?
I don't know if you've ever tried to get a tenant out of a piece of property and, you can't make them get out. I'd make a motion to dismiss this complaint.
You'll hear a second. Motion dies for lack of a second. There's ongoing litigation right now, right?
There is. Jenica here spoke with the attorney who submitted the response and confirmed that another attorney within the firm is handling the civil litigation matter. And right now, it's our understanding that the trial date has been put on hold, but the litigation is still ongoing. It has not been settled. It is still an open case, if you will. I don't know if at this time there's action going on, but it is an open case. And, frequently in matters of this type, for Commissioner Hill's benefit, when we have something like this that is in active litigation over the same type issues, sometimes the commission votes to place this in a litigation monitoring status by the person signing a consent order, which basically means that they would agree to keep us updated on the status of the litigation, let us know when it concludes, and then the commission would take whatever action it deems appropriate, whether it's dismissal or disciplinary action at the conclusion of the litigation. So,
Because sometimes things come up in the litigation process that we're not aware of.
Madam Chairman, I'll move to accept council's recommendation.
Do I have a second? Have a motion by Commissioner Grease and a second by Commissioner Franks to accept council's recommendation. Do I hear any more discussion? All those in favor?
Aye.
Aye. Opposed? Motion carries.
2014-006331, 2014-006332. This is the same complainant as the previous matter and concerns the same property, but is a separate complaint against different respondents. Respondent 1 is a principal broker. Respondent 2 is an affiliate broker. Complainant states that Respondent 2 listed complainant's home after parties discussed the property and items which needed cleaning and repairing. Complainant Complainant alleges that Respondent 2 assured complainant and that Respondent 2 would video record evidence of damage done by previous tenants, ensure that repair, maintenance, and cleaning was done, and would appear as an expert witness in the lawsuit discussed in Complaint 2014006311. Complainant states that an invoice for repairs was paid by complainant, but the repairs promised were not made and the property was not prepared correctly for listing. Complainant alleges that Respondent 2 promised to forward a listing agreement for the property, but this was never received. Complainant states that the property was listed on MLS by Respondent's firm, and complainant alleges that Respondent stated there was interest in the home and the property was being shown. Complainant alleges that in lieu of a listing agreement for sale of the property, Respondent 2 forwarded a proposal to become property manager, listing agent, and purchase the property with early occupancy. Complainant states that Respondent 2 sent a proposed lease agreement for monthly payments for a period not to exceed 3 years, with a balloon payment for the balance of the purchase price. Complainant alleges that soon after the MLS was canceled. Complainant states that Respondent 2 moved into the property with small children without authority prior to the period in the agreement. Complainant further alleges that damage was incurred and Respondent 2 refused to meet with a new agent to turn over the keys after failing to provide monthly installments per the contract. Complainant alleges Respondent 2 later abandoned the home and left it in awful condition. Respondent 2 submitted no response. Respondent 1 submitted a response through an attorney stating that actions taken, correspondence, signed documentation, and contracts with complainant were conducted by Respondent 2, and Respondent 1 was never contacted and did not learn of the complaint until it was received by TREC. Respondent 1 states that all documents referenced are in the file or from the file held by Respondent's firm. Respondent 1 states that a referral agreement was received and signed by Respondent 2, and Respondent 2 prepared and signed confirmation of agency status form for complainants, as well as a listing agreement and disclosure forms. Respondent 1 admits that the posting appeared on the website without Respondent 1's approval and a listing agreement was requested. Respondent 1 states that Respondent 2 assured that there was a fully executed listing agreement, though one was not provided to Respondent 1. Further, Respondent 1 states that the lease installment and sales contract provided by complainant states that no commission was to be paid, but Respondent 1 would not have allowed an agreement if made aware of one. Respondent states that Respondent 2 failed to disclose to Respondent 1 and the firm the true status and intention of Respondent 2's activities with regard to the complainant's property, and alleges that Respondent 2 purposefully misrepresented to Respondent 1 that there was an executed listing agreement. Respondent 1 states that affiliate brokers are not allowed to recommend anybody for the repair work and has no knowledge of work performed by a third-party company as alleged. Respondent 1 states that there was no knowledge of negotiations or lease proposals or an installment purchase lease agreement. Respondent 1 states that the MLS listing was pulled by Respondent 1 when contacted by another agency stating they were listing the property. Respondent 1 states that corrective measures have been put in place at the firm to be sure that no advertising is done without a listing agreement. Both complainant and respondent sent additional responses further setting out their positions. Respondent 1 states that Respondent 1 has no knowledge of Respondent 2's location and states that Respondent 2's license was sent back to TREC. Respondent 1's failure to insist upon receiving the unsigned listing agreement, which Respondent 2 states existed, appears to constitute a failure to supervise. With regard to Respondent 2, it appears that there are issues of failing to disclose Respondent 2's true position, Section 6213 312B18, and improper, fraudulent, or dishonest dealings, 6213 312B20. Also, there appears to be a failure to disclose a personal interest, 6213-4037A and Rule 1260-02-.11. The failure to secure the signed listing agreement appears to be a failure to diligently exercise reasonable skill and care, Section 6213-4031. And the MLS listing stating that Respondent is the listing agent appears to be a misleading or untruthful advertising, 6213-312B4. Finally, Respondent 2 failed to respond to the complaint, 6213-313A2, and has not taken administrative measures for the transfer or retirement of Respondent 2's license, Section 6213-312B16 and Rule 1260-02-.02, subsection 2. It is recommended that the Commission discuss any further violations that they may see by Respondent 2. The recommendation is to Respondent 1 is a consent order for $1,000 for failure to supervise the activities of a licensed affiliate in violation of Tennessee Code Annotated Section 6213-312B15, plus attendance by Respondent 1 at one entire regularly scheduled meeting of the Commission within 180 days of Respondent 1's execution of consent order. As to Respondent 2, consent order for $4,000 for violations of Tennessee Code Annotated Sections 6213-312B4, 14, 16, 18, and 20, 6213-313A2, 6213-4031 and 7A, and Rules 1260-02-.02, subsection 2, and 1260-02-.11, subsection 1, plus attendance by respondent 2 at one entire regularly scheduled meeting of the commission within 180 days of respondent 2's execution of the consent order.
Julie?
Mm-hmm.
Is that the maximum you can find this principal broker?
For the principal broker, if there's one violation, which is just failure to supervise, $1,000 is the maximum for each violation, and it appears it was only one property, one affiliate. So I don't see.
Is for per day, per diem, or?
There is, you can do per day, but I'm not exactly sure how many days. I don't have the proof in there of how many days this MLS listing was up without the listing agreement being in place. I just have one, day printed copy, so I don't have proof of exactly how many days it was with regard to that, so.
And for respondent 2, is that the max? They never responded to you.
There was no response. Now, it appears that this person was broker released, and we did have some issues trying to find where they were, but the complainant had contacted with additional information stating that, giving an address that they thought where the person was working. We sent it there. It was signed for, and we still got no response. So I don't believe there was a response. With regard to the maximum penalty for B4 is 1,000, 14 is 1,000, 16 is 1,000, 18 is 1,000, 20 is 1,000, 313, 403, and the rules have 1,000 apiece too. So
It's a total of $8,000. I'd like to make that as a recommendation for respondent 2.
Do I have a second?
Yes, you do. Yes.
Okay, Commissioner Bloom has made the motion. We adjust the penalty to be $8,000, and Commissioner Alexander has seconded that. I'm assuming, Commissioner Bloom, you want everything else to stay in place as far as education and?
Oh, yes, ma'am.
Commissioner Alexander, I do have one thing that I might mention. As far as the principal broker, because there is an issue of the advertising having been listed on the MLS without a listing agreement. The advertising rule, I'm having trouble finding it right now. Okay, 1260-02-.12 has a specific provision stating all advertising shall be under the direct supervision of the principal broker, and it says, and shall list the firm name and telephone number. Some of the information in that rule also states, listing information must be kept current and accurate. No licensee shall advertise in a false, misleading, or deceptive manner. If you all were to determine that you thought that this respondent to placing this listing on the MLS without a listing agreement stating was listing agent was a violation of the advertising rule as well, then that could maybe be added to the principal broker as well as this person. If you'd asked if that was the maximum you could do. This is also a supervision issue under this rule. The maximum for a violation of any rule is $1,000.
But you got 2 infractions or 1 additional?
No, I was just speaking with regard to each respondent. This rule wasn't specifically listed in the laundry list, and it's not specifically listed, but it does involve advertising with the MLS being implicated and not having a listing agreement, and the person stating they were the listing agent on it. So it's just another potential thing that, since you asked, kind of.
Can we increase the fine?
If you cite this rule as well, it's an additional $1,000.
$1,000. I'd like to amend, we have a motion.
We do have a motion. Would you like to make a friendly amendment?
Not sure if it's friendly, but.
How friendly do you want to be, Mr. Alexander?
Put another 1,000 to him, to the principal broker.
And what about to the respondent too?
I don't think he's gonna ever muster up enough money to say that. We'll just see what he does. If it don't, we'll take his license.
Hey, do I have a second to Commissioner Alexander's friendly amendment?
Second.
Okay, so we have friendly amendment that respondent 1 will have a $2,000 penalty. Education on that?
And respondent 2.
On 1. Respondent 2's $8,000.
Are we adding the 1,000? I think you did.
No, he said he wasn't never going to pay it that. No way.
Okay.
So So we have respondent 1 with $2,000 and respondent 2 with $8,000.
Call for the question on the amendment.
All in favor of the amendment to add, for respondent 1 to have a $2,000 civil penalty?
Aye.
Aye. Passed unanimously, I think.
Do I have any noes on that?
Call for vote. I voted for aye.
I voted for an aye, okay. All right, so now we're going to vote on the motion that the respondent 2's penalty be increased to $8,000 with everything else staying the same as far as the education. All in favor?
Aye.
Opposed? Motion passes. Julie, did you get all that?
Got it. 2014006351. Complainants were buyers of a home listed by respondent, affiliate broker. Complainants state that respondent pressured them into making a quick offer. Complainants state that a few days after entering into a purchase and sale agreement, respondent notified complainants of a purchase offer from TDOT to buy part of the property to widen a highway. Complainants state that the plan to widen the road was approved several months prior to the contract and allege that sellers and respondent knew about it but did not disclose this to complainants. Complainants further state that respondent instructed complainants not to disclose this information to the lender, but complainants did so. Complainants state that complainants already paid for appraisals and prepared for the closing. Complainants attached documentation, including but not limited to email conversations and transaction documents, as well as a Tennessee residential property condition disclosure form, which was executed by seller and buyers, which states, "Are you, seller, aware of any of the following? Any authorized changes in roads, drainage, or utilities affecting the property or contiguous to the property," which was marked unknown. Respondent submitted a response denying that information was withheld. Respondent states that after complainant's offer was written, respondent received a call from another agent who had interested buyers, and respondent notified complainants to ensure that the offer was signed and sent to the seller. Respondent states that when the property was listed, there was only hearsay that an expansion might happen someday. Respondent states that the seller was unaware of any authorized changes affecting the property until after the contract had been executed, when the seller received a letter from TDOT. Respondent states that it was conveyed that complainants could sit in on the meeting, but dealings would be with the current owner. Respondent states that complainants were notified and stated that they would handle it after closing on the property. Respondent states the complainants stated that the lender would have to resurvey and reappraise the property, and respondents asked why the mortgage company needed to be involved if complainants were going to handle the matter with TDOT after closing, which respondent states was merely a question and in no way advice to withhold information from the lender. Respondent states that complainants accused respondent of knowing about the road expansion, but respondent only knew what the community knew, that it might happen someday, and apologized to complainants. Respondent states that the parties agreed to postpone the offer from TDOT, giving complainants a chance to close and deal with TDOT directly. Respondent states the complainant did not provide the information needed from the lender and defaulted on the contract. Respondent further states that respondent's broker was closely involved in the transaction, and respondent closely followed the broker's instruction. Respondent submitted correspondence between the parties and attorneys regarding the issue, as well as seller statements and transaction documents. It appears, based on the information submitted, that respondent did not have actual notice of the expansion until after the contract was entered into between the parties, and therefore the recommendation is to dismiss.
To accept your recommendation.
I have Commissioner Alexander trying to ask a question down here.
Got a second to the motion?
We have a second, so you can
Yes.
discuss now.
Okay. Judy, I don't guess there's any way of knowing where this agent, was he from the same town? Did he live in that area? Was his office there, or was he out of town?
I can check the mailing address on the complaint. You want me to?
My question is if you've ever been through it and had any dealings with TDOT, it takes about 10 years to get a road built unless it's something it comes up, it needs, well, if it was a complete road, then you had to have public hearings, you had to have all those notices, and that's why I question this.
It looks like from the copy of the complaint that was sent to the respondent that the respondent's firm is located in another city than where the property is located.
He is unfamiliar with his, and he may have not done his due diligence.
Commissioner Grease.
Julie, do you know how significant this proposed taking by TDOT was
It references in the complaint that it was 1/8 of the property. I'll see if I have exact amounts. Might be. Trying to see if I can tell how big the entire lot is. All right, there's a lot of letters in here. I'm trying to find the actual TDOT letter to see if it has the amount in there. The total size of the property, and I'll get to how much it was, but the size of the property appears to have been, according to the listing, 2.19 acres. And let me see if the letter tells me how much of it would have been removed.
Quarter of an acre, roughly.
I feel like it was, but I don't want to say the wrong amount. Okay. The TDOT letter does not have an exact amount in it. It just says that TDOT is currently in the process of obtaining the rights of way in order to construct the above referenced project. Records show you're the owner. This project will improve this specified highway. Please call me in order to determine the best way we can get together. For some reason, I'm thinking it was around 1/4 acre, but I'm not positive.
The date of that letter was after the house went under contract?
The date of the contract. Now, let go of the letter. The date of the letter is March 5th. It states that it was sent certified mail and that it was received the 10th of March by the seller because that's who it was mailed to. The date of the contract. The offer was submitted March 6th and it was accepted on March 6th. So the day after the date on that the letter was drafted. Again, like I said, it looks like there's a note a handwritten note from the seller on the actual letter that says that the seller received it on the 10th.
So it's plausible that neither the seller nor the listing agent at the time the contract was signed knew about this proposed taking.
It's quite possible that the letter wasn't received until after that time.
Any other questions for Julie?
How could you go out there and not see the flags?
I'm not arguing that point, but I can make it.
Okay, we have a motion on the floor. Commissioner Collins made a motion to dismiss, and Commissioner Frank seconded that. Is there any other discussion on the motion?
Roll call, please, ma'am.
Roll call, Ms. Maxwell.
This is a motion to accept council's recommendation to dismiss. Franks?
Yes.
Alexander?
No.
McMullen?
Yes.
Bloom?
No.
Collins?
Yes.
Grease?
No.
Hills?
No.
DeChara?
No.
Motion fails. Motion fails. 5 to 3, 5 no, 5 against, and 3 in favor.
So what's your pleasure?
One more question now. The listing date. I'm sorry.
You don't get to put it away yet, Julie.
No, it's fine, I got it right here.
The date the property was listed.
I'm sorry, what?
The date the property was listed would be interesting to me.
I know I have that because I just slipped past it.
I'll have to get you a flow chart or something, Julie.
When it's this many, I can't always remember. Looks like there's a listing agreement right here that is dated October 30th, 2013.
Oh, they had it listed at least 4 months before that offer came in.
Approximately, because the offer was the beginning of March.
Okay, so what's your pleasure?
So if you don't want to dismiss it, what do you want to do?
That's my
Yeah.
question.
Madam Chairman,
Yes, sir.
I move that we have a consent order with a fine of $1,000 and a ethics course and a course here at the commission.
And have you got to have a rule?
Need to have a statute that you want as the violation is.
Supervisor
This,
himself.
this person's an affiliate. Nice try.
I know that. I'm gonna see what.
Failure to be supervised.
Before we move on to that, you had the consent order for $1,000, the TREC meeting, and then how many hours in ethics?
4.
4 hours ethics. Okay, so now yes, I would need the citation of the rule, failure to disclose, is that what you're, okay.
In the normal 2-day class,
Right, maybe.
Okay,
standard on everybody.
so, let me find this and make sure I've got. Okay. Under 6213-403, which is titled "The Duty to All Parties," subsection 2, which I think this is what you're probably, disclose to each party to the transaction any adverse facts of which the licensee has actual notice or knowledge. Okay.
Do you have in the file the actual knowledge then? Just the, can you, is that provable?
My thought was that the letter came afterward, but I don't have the benefit of ever having been a broker, and so maybe it appears that 4 of you disagree with me. I thought that it appeared that the letter came after the contracts were in, but, I'm not intimately aware of the process of the road widening, what may or may not have been there, so, I'm
I think
not.
the offer is irrelevant about it. I think it's public notice if you're going to sell property, and you know that if TDOT is making an offer, they've already been to town. They've had a public hearing. It's been noticed in the paper.
Okay, so we have a motion on the floor by Commissioner Alexander for a $1,000 civil penalty in violation of 6213-302.
It'd be 403 subsection 2, and then the statute would the consent order would by reference need to also reference 6213-312B14, which is just violation of any provision herein, because that's the subsection that has the civil penalty range specifically attached to it. But it would still just be referencing 403 subsection 2, the one that Commissioner Alexander said he was referring to.
Okay, with a 4-hour ethics course and a TREC meeting in its entirety. Do I have a second to
Second.
his? Commissioner Bloom has seconded it. Do I have any other discussion on this motion?
Let me just say I'm going to vote for the motion, and it's a little bit of a gray vote for me, but I'm going to base my vote yes on this because I do believe an event such as an expansion of a state highway is not done in a dark room. It takes forever, and there are all kinds of public comments and periods to comment. And so at least the principal broker who's
Following complaint.
hopefully in touch with the marketplace would be able to guide an affiliate to, hey, you might want to look out for this. And so I think the motion is appropriate. I'll support it.
Any other discussion?
Call for the question.
All right. All in favor, say aye.
Aye.
Opposed?
No.
Okay, roll call.
That's 3 noes.
5-3.
3 noes, the three of us.
Same as before.
Just the three
Flip it.
here? Okay, 5-3.
Three of us said no. It's a no
Just-
corner.
Just so when I'm drafting this consent order, I do have to lay out the facts specifically. With regard to the notice or knowledge, I did take notes on what you just said of, an expansion like this doesn't occur overnight. Is the thought that there must have been events prior to the date of that letter which would have given notice? Is that what you're, okay, I just want to make sure I understand because I do have to draft it rather specifically with regard to the facts.
Well, and Julie, just for your information, they're going to be out there with spray paint cans, marking off yards. They're going to be putting flags out and doing all sorts of activities that indicate something's going on.
It looks like they would have offered that, though, in their testimony, if there were.
Absolutely.
I think there were more meetings afterward, but I'm not aware of the timeline. So I just wanted to be sure that I was aware of the facts that you all wanted me to put in here with regard to the consent order. So I'm good. I understand what you're saying now.
Julie, do you need a break?
I'm all right. Thank you, though. You ready? Okay. 2014006371. A complaint was opened against respondent, principal broker, on a potential failure to supervise issue regarding the previous respondent affiliate broker in complaint 2014006351. Hereinafter called affiliate broker. Respondent states that discussions were held with the affiliate broker numerous times throughout the transaction, and the affiliate broker had no prior knowledge regarding TDOT obtaining a right-of-way. Respondent states that the affiliate broker would have disclosed any knowledge of the project, and the affiliate broker did not tell the buyers to withhold information from the lender. Respondent states that the seller may have known that an expansion was a possibility from news reports and unofficial communications, but that the affiliate broker did not know of the expansion until after the contract was signed and the official notice from TDOT was provided several days after the contract was accepted. Respondent states that the affiliate broker disclosed this information to the buyers as soon as information was received. Respondent further states that respondent spoke with the buyers who were interested in moving forward with the contract and wanted to attend all meetings with TDOT. Respondent further states that the buyers asked the sellers not to sell the property to TDOT so that the buyers could sign an offer after closing on the property, and respondent advised that the seller should contact an attorney to discuss these options. Respondent further states that after an attorney was contacted, a letter was received from the buyer's attorney asking for damages, and communications were handled through the attorneys. Respondent states that the respondent supervised the affiliate broker who had no knowledge of the TDOT project until it was received after the contract was accepted. Respondent submitted the transaction documents, attorney correspondence, and statements from the seller and seller's family. It does not appear there was a failure to supervise, and therefore the recommendation was to dismiss, but I have a feeling that's changed, so.
What's your pleasure?
5-3 sounds like.
Motion to dismiss.
Second.
Discussion?
Call for the question.
All in favor?
Aye.
All opposed?
No.
3-5.
Okay, so what's your pleasure?
According to my count, it failed, but if you want to have a roll call.
It failed.
Get right
We've
along.
got the three corner down here. They've got it cornered.
I'll move that the penalty assessed in this situation be identical to the previous case.
Okay, $1,000, Trek meeting, 4 hours ethics, and this time the violation would be 6213, 312, B15, which is failure to supervise. Correct. Okay.
Do I have a second?
Second.
Call for the question.
All in favor?
Aye.
Opposed?
No. Still 3.
All right, still 5-3.
Okay, I'm sorry. 2014006651. Track opened a complaint against Respondent, an affiliate broker, for potential violations relating to advertising. Included in the complaint were printouts from the internet advertising Respondent and Respondent's team, which is named after Respondent and is called by a few different names, all of which contain Respondent's name, and Respondent is occasionally referred to as the CEO. Among information advertised about Respondent's team is that the team is number 1 in GCI for a firm, and the team sold listings at a specified percentage faster and at a specified percentage higher than the average area realtor in 2012. Two different websites state that Respondent is in a specified top percentage of realtors in the area. There are two different percentages on the two websites. Also included are printouts from Respondent's team Facebook page, which contains multiple home listings and has various posts including such topics as team recruiting sales agents, team recruiting a position, advertising salary and benefits, an administrative leader position in the team, announcements of team participation in a program offering a percentage commission on a commission rebate received by the team, which states that it is open to certain classes of individuals and invites interested individuals to call in order to find out more information. Announcement of a bonus to agents bringing in buyers under specified circumstances. Statements such as the team is outpacing the market by a specified number of times. Announcement of a new individual taking over as a team manager in charge of the team, and a statement that the team is a real estate company affiliated with a national firm. Other information printed along with the complaint includes a website advertisement for a buyer specialist for the team, which advertises a specified first-year income, as well as a printout of an apparent advertisement for a sales agent to work with the buyers, which states that having a real estate license is not necessary. Additionally, a printout was included in the complaint, which states that Respondent is planning to move with family from Respondent's current town to a city in another state to work with another real estate team there, but Respondent would be keeping Respondent's local team with a new individual as CEO. Respondent submitted a response through an attorney stating that Respondent is licensed and only sells real estate within Tennessee, but travels extensively to other states to help other agencies in growing business. Respondent states that there was never any intention to misrepresent Respondent's status or relationship in the operation of Respondent's business under the firm where Respondent is affiliated. Respondent acknowledges that the team is referenced to as various names in the websites, which could result in some confusion, but there was no intent of misrepresentation. Respondent states that it was perceived that Respondent's firm encourages agents to build their own brand under the firm name because many customers rely on well-established agents to market their property. Respondent states that a conscious effort is made to include the firm name and phone number on everything within Respondent's control to show that Respondent is functioning under the supervision of the firm's broker and not under Respondent's own brokerage. Respondent further states that social media sites function differently from other websites, and internet searches may pull specific information from social media sites and not carry all information over. In reference to the agent bonus, Respondent believes that pertinent details were disclosed, but Respondent states that it may not have been clear that the firm was sponsoring the bonus. Respondent further states that with regard to the job advertisement of salary and benefits, it should have been made clear that this was for a clerical salaried position and not a sales agent. Regarding the sales agent job advertisement, which states that having a license is not necessary, Respondent now understands that the verbiage may have unintentionally implied that a sales agent did not need a license, but that is not the case. But Respondent prefers new team members who have not been licensed and may be trained and licensed to become a sales agent. Respondent states that one of Respondent's assistants shadowed Respondent and later became licensed but did not participate or engage in sales activities until obtaining full licensure. With regard to the promotional program, Respondent states that it should have been clarified that the rebate comes from the seller via the settlement agent and no money from the rebate is allocated to the agent. Respondent states that no sales were made from that program and Respondent is no longer participating in the program. The internet advertising materials are lengthy and council's made an attempt to summarize relevant content for the purposes of commission discussion. Because there are some references that could be construed as a bit misleading, it appears that legal counsel that Respondent would benefit from a letter of warning regarding the Commission's advertising rule 1260-02-.12. Therefore, the recommendation is a letter of warning regarding that rule, which is the advertising rule. I know that's a lot of information, but it's very hard to present an advertising complaint to you all and give you an idea of what the actual content is.
Accept recommendation.
Do I have a second? Motion fails for lack of a second. So what's your pleasure? Okay.
So the recommendation is a letter of warning to the team players, or is the broker, where's the principal broker in this?
This complaint is just opened against this particular one that you've just heard is a complaint that's opened against a respondent who is a licensed affiliate broker. This respondent appears to be the head or leader of this team, for lack of a better word, because the team is named after this person. I assume this person had been the person in charge. The following two complaints are over principal brokers that were this respondent, this affiliate's principal broker, kind of during the time period. Does that help? I'm
Yes.
sorry, without names, I know it's really confusing.
Can you tell us anything about what was on the social media site? Was it Facebook?
It is it was a lengthy Facebook page for the team, not.
And it told all of these different things on this, and did it?
You know how there's different postings that come down,
Did
and
it-
I
did
tried
it-
to summarize kind of what some of those were. It was about 12 pages of
Did it
stuff,
look
so.
like on that site that it was purely the teams, or did it look like a real estate office was on there with a phone number?
Let me look, because I
Was the
believe that
team the office?
Or was
that
the-
was-
yeah.
Appeared.
Are you through? Thank you.
The first page, where, if you've seen a Facebook page where it's got the name and like the information about it, there is information. It has the firm name and the firm telephone number right underneath that.
Is it the right size?
Well, no, but it's not a sign.
Okay,
The only thing that we
okay.
have with regard to fonts is a sign on property. But the firm is referenced
Okay.
several times throughout. I'm sorry. I just wanted to go ahead and answer that and move on.
All right, ma'am. Is this a out-of-state firm?
No, the firm is located here.
And it's licensed in Tennessee?
Yes, sir. This person is within the state of Tennessee working for a firm, or this person's may have, one of the things was that they may have moved, but they say that this person just travels extensively. But the address we have on file for this person as a home address is still within the state of Tennessee, and the firm address is within the state of Tennessee, so.
Diane, did you have another question?
So, help me without reading back through. So he traveled to assist other licensees?
According to the response, from the respondent's attorney, the only reference with regard to that kind of aspect of the complaint that I summarized was the fact that, I'll just read the sentence, but I'm going to just say firm name instead of reading the firm name to you. While the licensee only sells real estate within Tennessee, she travels extensively to other firm company sites in other cities and states, functioning as a consultant, assisting other firm agencies in growing their agent count and real estate business. That's the exact response that I have to that.
So it could possibly be like a franchise, and they're staying within the franchise and doing this, or is
to help with maybe, it appears to be maybe to help with marketing type issues for the team. They're basically, the response is saying this person isn't going to other states and selling real estate, but is going there to help consult with it. Right. That's the understanding I get from it. You have the benefit of now having heard everything I did about it, but with regard to the allegation, was in some of the advertising materials, it references in May moving from the city in Tennessee to that city. I don't know if it was temporary it doesn't really say. It's, like I said, a piece of advertising that tells me that, so I only have the benefit of that and then what the respondent's attorney said in response to that, so.
Julie? You recommend a letter of warning with a violation of Rule 1260-2.12? So therefore, you're telling me that there is a possibility that there is an infraction there. Is that not right?
I see some things, I feel like in advertising, some of the issues, I feel like there's things that while they could be misconstrued that way, I don't know that there's anything that was egregious enough where I could have pointed to it and said it was worthy of a civil penalty, or that it was a real danger to misleading a consumer or someone of the public. It's kind of one of those things where it didn't really seem to rise to that level, in my opinion. But again, I'm trying to give you as much information as I can. I know that's hard in an advertising complaint.
All right. Thank you,
Commissioner
Madam
Alexander.
Chairman. I move that we have a consent order for a $1,000 fine, 2 days at the commission meeting,
Or a full commission meeting. If it ends in one day, okay.
or whatever, it's 1 or 2 days. That's my motion.
Second.
Is that for a violation of the advertising rule? Same rule referenced, just making sure.
One you gave me reference for.
Okay.
Okay, we have a motion on the floor made by Commissioner Alexander for a consent order with a $1,000 penalty and a full commission meeting, and it was seconded by Commissioner Hill. Do I have any other discussion on the motion?
And if before, and I don't know if this is the appropriate time or after, whatever you decide, if you could give me an idea of what you see that were, I mean, because there's a lot here when I'm drafting this out. If you could tell me what jumped out at you as what you'd really like, because I have to basically specifically outline exactly what warrants the violation, and I'm kind of trying to get.
It's the misrepresentation, I think, is the problem, isn't it?
Yes.
Wendell?
Well, and he says that you can come with me as a sales agent and a real estate license is not necessary.
Okay. And
He's not the one
honestly,
that would be signing on. If he's not the broker, he's not the one signing on any agent.
And he references all these teams, different teams.
And, honestly, the thing that stuck out to me the most of any of it was that there's a statement saying that the team is a real estate company affiliated with a national firm. Now, it does reference the firm, but calling your team a real estate company, that's honestly, I guess if I had to point to one thing, that's what I saw. So I'll reference that specifically. It's just there's so much I want to be
It's
sure
a
that I
shotgun.
reference.
Well, you could probably support our government if you would just get on Facebook in the morning and stay on there all day long, because there's so many violations on Facebook every day. You could probably fund the government with civil penalties on there.
All right, so
Have you got all you need?
But under
Sheila?
advertising, there's no mention of misrepresentation.
there's misleading.
Where's
that?
No licensee shall advertise in a false, misleading, or deceptive manner. It's Rule 1260-02-.12, 2E. Actually, there is under 312 a specific provision relating to misleading or untruthful advertising, including use of the term realtor by a person not authorized to do so, or using any trade name, insignia, or membership in any real estate association or organization which the licensee is not a member. So that's also another reference to it. Sometimes there's a little bit of cross between, but within that advertising rule, that's where that.
Any other discussion? All those in favor of the motion?
Aye.
Opposed?
Oh,
Austin, are you in the no corner this time, or did you vote?
I voted yes.
Okay. So,
Pass.
you're a pass. Okay, so we have,
I'm gonna pass too.
I'll recuse myself.
I'm gonna recuse myself.
okay, Julie, we have 2 that recused themselves and 6 that voted in favor of.
Without explanation. No, it's okay.
I got an explanation.
No. We don't
I want it. We've got an attorney we pay to analyze this stuff, and I don't think it's our duty to find fault with everything she decides. That's my statement.
Okay.
I don't really think we're taking against her when she makes a recommendation that, and quotes me a rule that there's a violation. It's our duty then to decide whether it is or not.
Okay, I'll just I'll go through and reference some of the issues that I outline in here, but I'll make specific note with regard to the company reference and the advertisement for the sales agent, which references not having a real estate license, since those were two things that specifically came up. Is there anything else specific anybody'd like to mention? I mean, I suppose you see it with a lot of these items that were alleged in the facts. So I'll just try to include as much of that as I can in there. The next one is 2014006671. A complaint was opened against respondent broker on a potential failure to supervise issue regarding the previous respondent affiliate broker in complaint 2014006651, hereinafter called affiliate broker. Respondent submitted a response through an attorney stating that respondent served as the acting principal broker for the affiliate broker's firm from January 1, 2014 through March 31st, 2014. Respondent states that upon stepping into the role, respondent immediately acted to ensure compliance with TREC statutes and rules, was available full-time for agents to discuss advertising compliance issues, and proactively instituted a system of frequent compliance education seminars and monthly meetings for the firm's agents. Respondent further states that at the time the complaint was initiated, respondent was no longer principal broker for the firm. Respondent states that the new principal broker, respondent in complaint 2014006691, was only in the role of principal broker for 2 days prior to the date of the commission printed the pages from the complaint's websites. Respondent states that the new principal broker continued training and education of agents, and respondent included topics of the seminars initiated by respondent and the new principal broker. In addition to the seminars, emails were sent regarding certain compliance issues, and respondent attached these emails to the complaint. Respondent states that upon receipt of the complaints, the new principal broker spoke with the affiliate broker regarding advertising issues, and respondent and the new principal broker were in continued communication with the affiliate broker to ensure activities were in compliance, including a meeting on May 14th, 2014. Respondent states that there are certain challenges with advertising on social media websites. For example, people other than agents can post to the websites. Pages theoretically last indefinitely, and these sites are changed so frequently that it becomes an extremely challenging problem to conduct oversight even by personally reviewing the sites. Respondent requests the Commission's guidance and direction for avoiding potential compliance violations with regard to social media. Respondent states that if the affiliate broker is found to be in violation, such violations occurred in spite of proper oversight and supervision of respondent. Respondent states that all duties as principal broker were performed, including doing what was practicable to supervise and ensure compliance of agents. The recommendation was a letter of warning regarding the advertising rule. And that is just in light of the fact that I did believe that in light of the extreme length of all of these social media printouts, that to me the advertisements, it would have been very hard to have to.
This broker had only been there 2 days, right?
No, that's the following person, the next one we're going to hear. This person was the principal broker from January 1st of this year through March 31st, 2014. And from the attorney's response, it appears that maybe the principal broker prior to that time had left. I don't know if it was rather suddenly or what, and this person was kind of an interim broker for that 3-month period between the time of the previous principal broker and when this next respondent was placed in 2 days before the complaint materials were printed.
But when was the complaint filed?
The
Materials printed.
complaint?
Sometime open 5/2014.
That was with the open date is when it was opened up in legal. So much of the complaint materials, it's just anonymously printed advertising materials that I believe Eve might have printed. They're dated. Some of them are dated that they were printed February 10th. The rest of them were printed April 3rd. The actual complaint appears to have been mailed out by Mr. House to at least this particular respondent on April 14th. I can check it as to the others.
So if she was the principal broker January 1st through March 31st, and the complaint wasn't filed until April.
Right, but some of the printouts were for during the time that this person was the principal broker. There is a lot of overlap here because honestly, some of the postings on the Facebook website were from prior to the time that this person was the principal broker, but yet they were still on the Facebook page as of the date they were printed, so the timeline becomes kind of confusing, actually very confusing, I thought. I tried to outline it on a piece of notebook paper, because some of the postings were from prior to this person's tenure as principal broker, but like I said, are still on there, but they're pages back in the printout.
So the
Does this
bottom
make
line,
sense?
the bottom line, if she was there, or he, or whoever it is, January 1st through March 31st, is this when the infractions took place? And you said February 10th and April 3rd, so February 10th would be, right?
February 10th is when some of the advertisement materials were printed.
Are they date stamped?
They have the printout in the bottom right corner from where you printed off the internet. You know, when you can see at the bottom, I can see that that was the date of printing. Then, like I said, the Facebook page, it looks like it was printed earlier and then again on April 3rd. Now, the individual postings on the Facebook timeline, if you will, I guess, go back as far back as 2013. I mean, is when they were put up.
What if
So
the
that-
broker wasn't on Facebook?
They're good on Facebook if
He's
you're a
he's
principal
supposed to be
broker.
supervising, he or she's supposed to be
Oh,
supervising. Madam Chairman, I'd like to make a motion.
Yes, sir,
My
Commissioner.
motion is the
Alexander.
same as the last motion, $1,000 fine in 2 days at the commission meeting.
Or the advertising or for failure to supervise?
Failure to supervise.
Okay. Do I have a second to Commissioner Alexander's motion?
Second.
Or add the other, we'll put another $1,000 with it.
And that's for B15.
Pardon?
For 6213, 312 B15.
Failure.
Failure to supervise. I'm sorry, I know.
Numbers.
6213.
Whatever that number is. Any
Got it.
discussion on the motion? All in favor, say aye.
Aye.
Opposed?
Pass.
Okay, I have 6 ayes, 1 pass, and 1 no. Julie, number 17.
201400669. A complaint was opened against respondent, principal broker, on a potential failure to supervise issue regarding the respondent affiliate broker in complaint 20140006651, affiliate broker. Respondent submitted a response through an attorney stating that respondent took over as principal broker on April 1st, 2014, and is affiliate broker's current principal broker. Respondent became the principal broker of the firm only 2 days prior to the date the websites with the alleged violations were printed. Respondent states that since becoming principal broker, respondent has continued the training and education of agents as requested by the previous broker respondent, and respondent included a list of topics presented and the dates they were presented. Respondent states that respondent consistently emphasized that an agent must substantiate any claim or statement made in any advertisement or publications, particularly if it is quantifiable. Respondent also attached emails that were sent to agents to emphasize certain compliance issues, including advertising. Respondent further states that respondent regularly reviews activities of agents and addresses issues that may be identified. Respondent states that upon receiving the complaint, respondent spoke with affiliate broker and instructed that the affiliate broker could not offer rebates, salaries for licensees, and that advertising must not mislead the public to believe that an agent is a separately licensed company. Respondent further advised affiliate broker to address the issues raised and correct all advertising that does not comply. Respondent states that respondent met with the affiliate broker and the previous broker respondent to discuss compliance and followed up with an email discussing changes, and respondent offered assistance with the process. Respondent further states there are certain challenges with advertising on social media websites. Example, other people other than agents can post to the websites. Pages theoretically last indefinitely, and these sites are changed so frequently, which creates an extremely challenging problem to conduct oversight even by personally reviewing the sites. And respondent requests the Commission's guidance and direction for avoiding potential compliance violations with regards to social media. Respondent further states that respondent has spent numerous hours reviewing agents' advertising for compliance, and if the affiliate broker is found in violation, such violations occurred in spite of proper oversight and supervision by respondent. Respondent states that respondent performed the duties of principal broker, including doing all that was practicable to supervise and ensure compliance of affiliate broker and other agents. And the recommendation is a letter of warning regarding the advertising rule 1260-02-.12.
Okay, what's your pleasure?
So this broker came on site 2 days after the alleged occurrence?
2 days after the Facebook page printout was printed. That was the meat of the complaint file.
Have you looked at that Facebook page? Has it changed? Or is it still the same?
I have not looked through it and compared it word, post by post. This one, like I said, it was 12 pages of postings, and there were a couple other websites as well. I can go back and do that if you want to postpone this one, but I kind of want to know what you all were specifically wanting me to look for, because there's all kinds. I mean, there's listings on there. There's all kinds of content, as typically is listed on anybody's timeline. So if there's something particular you want me to look through for on it, it would be fine, but to go through and line it up.
I'd like to move we accept the recommendation of council.
Okay, we have a motion by Commissioner Bloom to accept recommendation of council and seconded by Commissioner Alexander. Do I hear further discussion on that motion? All in favor, say aye. Aye. Opposed?
Pass.
We have 7 ayes and 1 pass.
Madam Chairman.
Yes, sir, Commissioner. I think a break would be appropriate, too. Let's take a 10-minute break. Let's roll on. Roll on, Alabama.
All right, Julie, are you ready to go? And I think we're on number 18, is that correct?
Ready, yes. 2014006731. Complainants listed their home with respondent, broker, and state that they informed respondent that they wanted a contingency that the home would not sell unless complainants had another home under contract and the purchase was definite. Complainants state that this contingency was listed in the listing agreement. Complainants also wanted their purchase of a home to be contingent upon the sale of their current home. Complainants had a contract to purchase a home which included a written contingency regarding the sale of their current home. However, the sellers received a higher offer and requested that complainants remove their contingency or the sellers would accept the higher offer. Complainants did not remove the contingency and lost the contract on the home purchase. Complainants state that they found out that respondent did not place a contingency in the contract for the sale of complainant's home. The executed contract for the sale of complainant's home listed no contingencies, and complainants state that they believed that this contingency was written in the listing agreement would transfer to a contract. Complainants state that they needed to find a home fast, and so complainants used another agent to purchase property. Further, complainants state that respondent allowed the buyers of their home to do the final walkthrough on the closing day, and complainants' belongings were still in the home, which caused friction. Ultimately, the closing occurred, but complainants feel as though respondent caused the closing problems. Respondent submitted a reply denying the allegations. Respondent states that the complainants knew that the contract for the sale of their home was not contingent upon complainants purchasing the new home. Respondent states that complainants were told they could opt out of the listing agreement prior to accepting a contract. Respondent states that complainants chose to move forward and accept the contract without the contingency since they were asking the full price and not paying any closing costs. Respondent submitted emails where complainants discussed the counteroffer stipulations with respondent, and the email did not discuss including the contingency regarding purchase of the new home. Respondent further states that the complainants had the option to move forward with the purchase of the new home and opted not to do so. Respondent states that respondent attempted to arrange a time for showings when complainants needed to find a new home quickly. Respondent further submitted email correspondence with complainants showing that complainants were aware that buyer was doing their final walkthrough on the closing date, and complainants replied stating that they would be moving out of the house during that time. Respondent states that respondent remained professional, courteous, and respectful, that complainant's home closed, and that complainants got exactly what they chose in the manner in which they chose to proceed. Additional replies were submitted by both parties, further reiterating their standpoints, and respondent submitted polygraph results in an attempt to show that respondent was being truthful. The recommendation is to dismiss.
Move to dismiss.
Motion by Commissioner Franks to dismiss, seconded by Commissioner DeCharo. Is there discussion? Hearing none, let's vote. All in favor, say aye. Aye. Those opposed, no. It's unanimous. Number 19, please.
2014006791. A complaint was opened against respondent principal broker on a potential failure to supervise issue regarding the previous respondent broker in complaint 2014006731, hereinafter called broker. While there does not appear to be a failure to supervise, respondent submitted no response to the complaint, which was sent to the firm address on file with the commission and signed for by an individual at that address. The recommendation is a consent order for $1,000 for failing to respond to a complaint filed with the commission in violation of Tennessee Code Annotated violated sections 6213, 312B14, and 6213, 313A2, plus attendance by respondent at one entire regularly scheduled meeting of the commission within 180 days of respondent's execution of consent order.
Or motion?
So moved.
Motion by Commissioner Bloom to accept council's recommendation. Is there a second to that motion? Second by Commissioner Collins. Discussion. All in favor, vote aye. Aye. Those opposed, no. It's unanimous. Number 20.
20140069001. Complainant states the complainant booked a cabin rental with respondent, vacation lodging service, and paid for a cabin, but due to bad weather could not access the cabin because of a steep, icy driveway. Complainant states that respondent offered a different cabin but would not refund any money despite the price difference of the cabin.
Motion to dismiss.
Second.
You have anything to say about that, Mr. Alexander?
It's VLS.
Do you
We
want
can't do
to?
anything anyway. Call for the question.
That ends discussion. Is there objection to the call? Hearing none, let's vote on the motion, which is to dismiss. Those in favor, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 21.
20140069661. Complainant signed a buyer's representation agreement with respondent, affiliate broker, but states that a copy was not provided. Complainant became unhappy with respondent's representation for the sale of complainant's home due to a delayed closing, and complainant attempted to terminate the buyer's rep agreement. Complainant states that respondent refused and sent a copy of the buyer's representation agreement, which included a termination date that complainant states complainant was unaware of and had not been explained and may have been altered. Complainant states that complainant would drive around and find houses personally, and when respondent found a home complainant wanted to put a contract on, respondent was not, I'm sorry, I think that should say when complainant found a home. I'm sorry, because the point is they drove around. Complainant states that complainant would drive around and find homes personally, and when complainant found a home, complainant wanted to put a contract on. Respondent was not present, and complainant did not think complainant still had to use respondent because several months had passed. Respondent responded stating that there were two sets of original documents, the listing agreement and the buyer's representation agreement, and each document was reviewed with complainant. Both original sets were signed, and complainant retained a set of original copies. Respondent denies altering this document. Respondent submitted a copy of a lot reservation for purchase of a new home. Respondent states that it was requested that respondent draft a contract for the new home purchase, but respondent states the complainant instead signed a contract for the same home drafted by the listing agent, which included an agency disclosure that stated that the listing agent was working as the transaction broker for complainant's purchase. Respondent further states that seller, represented by another licensee, offered respondent a referral fee for the property and forwarded a referral agreement to complainant, which was signed. There does not appear to be a violation of Trex laws and/or rules by respondent, and therefore the recommendation is to dismiss.
Motion to approve.
Motion by Commissioner Charo, seconded by Commissioner Alexander to accept council's recommendation. Is there discussion?
Yes. There was a buyer's agency agreement, correct?
Yes.
Was there a listing agreement?
There was also a listing agreement,
Is
I
there
believe.
something in the file that says that they defaulted from these two positions to become a facilitator?
It was a different person. When I said that somebody else was acting as a transaction broker, the documents state that the listing agent of the new home was the one that was listed as the transaction broker. This respondent was not referenced at all on that form.
Oh, okay. I'm sorry.
Further questions, comments? Let's vote. All in favor of the motion, say aye.
Aye.
Those opposed, no. Motion passes unanimously.
20140069991. A complaint was opened against respondent, principal broker, on a potential failure to supervise issue regarding the previous respondent, affiliate broker, and complaint number 20140069661, hereinafter affiliate broker. Respondent submitted a response stating that respondent spoke with complainant after the sale of complainant's home, who requested to cancel the buyer's representation agreement. Respondent states that respondent advised that the agreement needed to be mutually terminated, and while speaking to the affiliate broker, respondent learned that complainant was upset that the closing had been delayed, and complainant's spouse instructed the affiliate broker to deal directly with the spouse. Respondent states that the affiliate broker did not wish to cancel the buyer's representation because the affiliate broker had already worked showing complainant homes. Respondent states that complainant was on the affiliate broker's automated email list and was notified of homes that came on the market, which is how complainant learned of the home under contract. Respondent states that complainant wrote a contract on a home without the affiliate broker, and complainant's spouse notified affiliate broker that a deposit was placed on a new home, so affiliate broker reminded them of the contract and re-forwarded it. Respondent states that complainant's spouse requested that the affiliate broker prepare an offer, but complainant became upset and refused to work with the affiliate broker. Respondent states that respondent reviewed the transaction file and documents do not appear to have been altered. Respondent states that the affiliate broker would have explained the entire buyer's representation agreement instead of just one section. Respondent states that the builder decided to pay affiliate broker a referral fee since complainant did not want the affiliate broker involved. Respondent states that respondent received the referral agreement and presented it to the affiliate broker. Respondent states that the referral agreement was discussed and signed and complainant is moving forward with the home purchase. Respondent states that respondent has exercised all duties and obligations as principal broker, included emails to corroborate same. The recommendation is to dismiss.
All right, I'll ask, is there a motion?
Move to dismiss.
Second.
Got a motion by Commissioner Frank, seconded by Commissioner Hills, that this commission accept council's recommendation to dismiss. Is there discussion? Let's vote. All in favor of the motion, say aye.
Aye.
Those opposed, no. Ayes have it. Motion passes unanimously. 23.
2014-007061. Complainant is a licensee who states that respondent, principal broker, is actively selling real estate despite the fact that the license for respondent's firm had been expired for quite some time. According to Trek records, it appears that respondent's firm license expired on or about August 24, 2011. Respondent applied for relicensure of the firm, and respondent's firm again obtained an active license on or about June 18, 2014. Respondent submitted no response to the complaint. The Office of Legal Counsel followed up with complainant and received additional information, including a report from Centralized Showing Service indicating that respondent showed a property which was listed by complainant on or about March 2, 2014, while respondent's firm license was expired. Respondent states that respondent showed the property to a family member and requested a fee from complainant, which complainant did not pay because respondent's firm license was not active. Complainant states that respondent is now the tenant of the property. Complainant also submitted copies of MLS listings where respondent is the listing agent and the homes were listed, and several also closed, while respondent's firm license was expired. Complainant also submitted MLS listings where respondent was the sales agent and closings occurred while the respondent's firm license was expired. The recommendation is a consent order for $1,500 for failing to have an active firm license and failing to respond to a complaint filed with the Commission in violation of Tennessee Code annotated sections 6213-312B14, 6213-309A1A, and 6213-313A2, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order.
Is the 1,500 the maximum?
The maximum would be $2,000 because it would be $1,000 for 309, which is the firm license issue, and $1,000 for the failure to respond issue under 313. B14 is just on there because it has a specified range to it, and those two do not.
Is there not a check and balance system that, how many licensees were under this broker, under this firm?
I'm not I don't have that information. The allegation was directly that this particular person, this particular principal broker, not anybody acting for them. The Centralized Showing actually lists this individual's name in all the MLS listings that we followed up to try to get, actually listed this particular person. So there were no documents that we got indicating there was anybody else there. I'm not sure if there were or weren't. I don't even know if I have the clearance to look that up in our licensing program, but all of the documentation I had actually listed this particular person.
I make a motion that we have a consent order for $2,000 for failing to have an active firm license, and that there be a two-day class, full 2-day class here at the Trek Commission meeting.
A full meeting?
Yes.
Okay.
Is there a second?
Second.
Seconded by Commissioner Hills. Discussion. So Julie, here's where I get confused. So the individual himself or herself was practicing real estate. Did that person have an active license?
To my knowledge, from looking back through it, this person's individual license was never not in an active status. It was just the firm lice that had expired.
But he was affiliated.
This person was principal broker.
So in my opinion, it seems to me he should have known better.
He should have known better.
We're not penalized. There's no mention of a penalty to the individual in your recommendation.
This is the respondent is the principal broker.
I'm just trying to put him in a different role as a licensee working at a firm that doesn't have a license. And is there a penalty for that?
I'm not sure who, I don't have the ownership information. 309A1A states each office shall have a real estate firm license, a principal broker in a fixed location without, that's the statute that references each office having a real estate firm license.
For a time period, such as the revoked, or is scale of time period like for a firm?
Not on a firm, there isn't, is there?
I'm sorry, I don't understand.
You can if your license expires and you have 60 days to get it current. There's nothing like that on a firm, is there?
Well, this one would have been past that date, so this
Okay.
person actually reapplied, and the firm is licensed at this point in time. But I believe at the time frame that it was worked out, this person had to reapply and got the same firm license back, but it was a reapplication process for the firm.
And do you know how many agents this principal broker had under them?
I don't know that. I don't even know that I have access to that information.
Okay.
I can try to find out if you want me to. Like I said, that didn't even really cross my mind because all the documentation I had just this person's name on it. I didn't have anything tipping me off to anybody else.
To me, it's a little difference if they are the only person in the firm versus if they have 50 agents.
And like I said, we followed back up with the complainant who is a licensee, and that's how we asked for some of this information off the MLS because I can't get into that. And all that this complainant was able to provide to Jenica was what we were given, and all of those documents did reference just this person. Because we'd asked them to go back and please get us some documentation to see exactly what had gone on, and that was what we were provided in response to our request.
Did you look at their website?
I did not see a firm website, but then again, there's so many of them this month, I'm not positive I checked. Like I said, we followed back up with the complainant to see what they could get us because we don't have access to the MLS, especially expired things. You know, we could only maybe Google it and see what was currently advertised. And I think at the time I reviewed this, the firm was already active, so I was relying on what had happened before. So, yeah.
If this motion passes, the firm is fined $1,000.
No, the complaint was opened against the particular respondent. There was no complaint opened against the firm itself. The complaint, the respondent here, the named person on the complaint file, and the person who this is open against is the principal broker. There's not, I don't have one for the firm.
Even though the violation is failure to have an active firm license, the principal broker is the one who's penalized?
Correct, because that's the person that would be in charge of making sure that
Who's responsible?
Okay.
Correct.
Other questions?
I'm sorry, that might not have been clear. I didn't understand that's what you were asking earlier.
All right, let's vote. The motion is to approve amend council's recommendation, bump it to $2,000. Everything else stays the same. If you're in favor, please vote aye.
Aye.
Opposed? Ayes have it unanimously. Number 24, please.
2014-007101. This is a TREC open complaint based on materials received by the TREC office. Specifically, online advertisements indicate that respondent principal broker was advertising 3 properties located in Tennessee for sale during a time period in which respondent's license was suspended by TREC for failure to maintain errors and omissions insurance. Respondent submitted a response stating that respondent received a letter from TREC and respondent spoke with respondent's insurer in another state. Respondent is located in another state and was informed that coverage was renewed and would continue. Respondent states that respondent requested that the proper notification be sent to TREC and states that respondent followed up and was assured that this was handled. Respondent states that it is likely that confusion arose because respondent has E&O insurance in another state through that insurer as well. Respondent states that respondent would have never attempted to do business without proper coverage. With regard to 2 advertised properties, respondent states that one expired before suspension and the other closed before suspension and had not been removed. With regard to the 3rd property, respondent admits that the advertisement was up during the suspension period and sold in February 2014, but respondent states that had respondent been aware of the suspension, respondent would have immediately resolved the issue. Respondent apologized for the oversight and states that this will not happen again, and all Tennessee properties were removed from the website until the issue was resolved. Respondent states that respondent has never been in noncompliance in respondent's home state, and respondent would never wrongfully do business in Tennessee. It appears that respondent promptly resolved the issue by obtaining valid E&O insurance and paying the substantial penalty fee. The recommendation is a letter of warning regarding Tennessee Code Annotated Section 6213-112 and Rule 1260-01-.16 regarding lapsed E&O insurance.
Motion to approve council's recommendation.
You've heard the motion. Is there a second?
I second it.
All right, the motion has been properly made and second that council's recommendation be adopted. Is there discussion on the motion? Are you ready to vote? Are you not ready to vote? Let's vote. Okay, we're voting on the motion. All in favor, please say aye.
Aye.
Those opposed, no.
No.
Chair counts the votes as 7 ayes and 1 no. Commissioner Franks, the no vote. Next item, please. Numbers 25 and 26.
2014-007121, 2014-007122. Complainant and spouse were unrepresented and were looking to purchase a home and found a property listed by Respondent 1, principal broker, which they liked. Complainant states that Respondent 2, affiliate broker, showed the home and stated that complainant's current home needed to be put on the market before making an offer on the property. Complainant listed complainant's home with another agent and signed an exclusive buyer representation agreement, confirmation of agency status, and purchase and sale agreement with Respondent 2. Complainant provided an email from Respondent 2 stating, if all this falls through on property address and you do not wish me to represent you further, this will end. Complainant states that the sellers countered with a higher price and sellers would not accept a sale of home contingency. Complainant states that they withdrew the offer. Complainant states that Respondent 1 then showed Complainant 3 properties. Complainant states that a friend was selling their house and Complainant went to see it without an agent present, then informed Respondent 2 that they no longer needed representation, and Respondent 2 agreed to shred the agreement, and Complainant proceeded without representation. Complainant then contacted Respondent 2 to confirm that the buyer representation agreement was terminated and received a response stating that Respondent 2 did not have authority to do so, and the request was sent to Respondent 1, who denied terminating representation. Complainant states that the buyer representation agreement states that if a fee is not offered or paid to broker, as could occur, for example, in the purchase of an unlisted property, client agrees to pay broker a total of, and it has a blank or 0% commission based on the total sale price. And if they purchase the friend's home, they would not owe respondents according to the contract. Complainant states that Respondent 1, by refusing to sign a release, is intentionally trying to interfere with the purchase of the new home, and the buyer representation agreement was rightly terminated by Respondent 2's statements, and Respondent 2 was authorized to do so on the firm's behalf. Respondent 1 responded stating that it was evident that Complainant was working with the firm due to continued conversations with the firm and additional requests to show properties even after the purchase of the first property fell through. Respondent 1 states that Complainant was in contact with Respondent 1 until they found the new home and then contacted Respondent 2 about no longer needing representation. Respondent 1 states that Respondent 2 contacted Respondent 1 when Complainant requested to end representation and states that the firm does not shred documents or contracts. Respondent 1 further states that the contract language regarding 0% compensation is referring to unlisted property and Complainant is taking it out of context. Respondent 1 states that the firm represented Complainant diligently and to the best of their ability. Respondent 2 stated that upon showing Complainant the first property, Complainant stated they needed to sell their home first, and Respondent 2 advised that they should put their home on the market if a purchase was going to include that contingency. Respondent 2 states that Respondent 2 told Complainant that if Respondent 2's representation did not live up to their expectations, they could terminate the buyer representation agreement. Respondent 2 also states that once Complainant's home was under contract to sell, they contacted Respondent 2 to submit another offer to purchase the first property, but ultimately decided to not go through with it. Respondent 2 states that Respondent 2 received a call from Complainant stating that they wished to purchase a home from a friend and did not need representation, and Respondent 2 stated that their agreement was over, though Respondent 2 wanted to warn them about buying a home without representation and did not say the agreement would be shredded. Respondent 2 states that Respondent 2 later found out what was going on, and that the seller's agent had told Complainant to get a written release and proceeded to work with Complainant knowing they were under contract with Respondent's firm. It does not appear that there's a violation of Trex laws and/or rules by Respondents, and therefore the recommendation is to dismiss.
So move.
Second.
Motion by Commissioner Bloom, seconded by Commissioner Franks to accept.
Recommendation.
All right, Commissioner Charo seconded the motion. And the motion is to accept council's recommendation and dismiss. Any discussion? Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. 27 and 28.
2014-007241, 2014-007261. Complainants were sellers, and Respondent 1, affiliate broker, represented a potential buyer. A complaint was opened against Respondent 2 on a potential failure to supervise issue. Complainants state that the purchase and sale agreement was submitted and stated that $500 in earnest money had already been collected, stating, buyer has paid or will pay within, field left blank, days after the binding agreement date to seller's agent's firm located at, field left blank, an earnest money deposit of $500 by check. Complainants state that they accepted the offer on the following day. Complainants state the complainant's agent requested the earnest money check, but Respondent 1 called complainant's agent later that day rescinding the offer. The agents disagreed whether there was a binding agreement, and complainant's agent again requested that the earnest money be delivered. Complainants alleged that the buyer is in breach of contract and the earnest money should be delivered. Complainant submitted a contract copy, which is marked accepted and signed by seller, but there is no binding agreement date. A letter from the buyer stating that the buyer wishes to rescind offer was sent via email to complainants through their agent a few days later. Copies of an earnest money disbursement form requesting earnest money to complainants and a notification stating the seller is terminating the agreement for failure to deliver earnest money and failure to deliver good funds were also submitted. Respondent submitted a joint response to the complaint stating that complainants did not in fact accept the contract, but instead counter-offered by adding terms to the buyer's offer. Respondents state that complainants claim that the contract stated that the earnest money had already been collected in the form of a check was not accurate. Respondents point out that the buyer presented an offer, the complainants counter-offered on the following day, and complainants filed their check complaint on the day after that. Respondents further state that the property was currently occupied by tenants and there was uncertainty with the status of the lease, which might create a problem with the occupancy date of the subject property due to when the lease ended. Respondents state that due to this situation, the offer intentionally checked a box indicating that possession would be a different time than with delivery of warranty deed and payment of purchase price, but the blank indicating the date was purposely left blank in anticipation of the seller's counteroffer proposal regarding the possession date and time for the buyer's consideration. Respondents state that complainant's agent emailed the counteroffer, which was claimed to have been an acceptance, which contained the additional term written on the line specifying possession date and time. Respondents state that the counteroffer with this possession date was not acceptable to the buyer, and the buyer rejected the seller's counteroffer and considered the offer dead. Respondents further state that the buyer has obtained legal counsel pertaining to the matter. Respondents further state respondents understand and adhere to TREC statutes and rules, and Respondent 2 is devoted full time to the management of licensees and provides supervision and daily training. Respondents submitted a copy of the offer, which appears to contain a blank possession date, and the copy signed by the seller does appear to have a date filled in on that blank. The recommendation is to dismiss for the reasons outlined in the response. If you want me to recount it, it appears that there were terms added in, and although it was marked acceptance, there were additional terms added, and
Both sides is guilty to me.
Is it your position there was never a contract?
well, the documents appear to support what the respondent's version of the events were. There is an offer that was transmitted where the blank regarding possession was blank. Then when it was returned with accepted marked on it, there are terms added in that were not in that same blank when the offer was transmitted. It appears reasonable in theory to me that if that date was put in as a proposal, it might not have been acceptable to the buyer, and therefore there might not have ever been a meeting of the minds. Again, I'm not in the business, but that appears plausible to me based on the response and the documents. So they had not collected the earnest money, I don't believe.
Even though they said they had.
Well, they did not say they had the contract had the provision in it that's in typical, I believe it was a TAR form that said buyer has paid or will pay within, it has blank, after the binding agreement date to the seller's agent located at the blank was date an earnest money deposit of $500 by check. So I think what they were stating is because there was never any contract, that earnest money check was never delivered.
Okay, but they sent an original contract over.
Offer.
With blank, an original offer over with blanks left on the form. The seller accepted that offer, but went back and filled in those blanks?
Filled in the possession date.
So it becomes a counter.
Yeah, that's what the respondent's argument is, and that's what appears to be the case to me. However, I mean,
So they didn't use a counteroffer form,
No, but
and they really didn't accept, they really countered.
Both need education.
Yeah, definitely needs education here.
I'd like to
Well, that's
move to
not this
accept the
respondent that
recommendation.
submitted the acceptance. This respondent was the buyer's agent. These people represented the potential buyer that sent over the form with the offer.
And left, that agent then left that blank as to the
Oh, okay, I was
binder.
just making sure that you knew that this wasn't the
Yeah.
person that had returned it and
No.
filled it in.
And there was never a binding agreement date.
The binding agreement date was not filled in because I think it was the respondent's position that there was never a binding agreement, that what was marked as an acceptance was really a counter.
I would agree.
there was no meeting of minds.
In the
I would agree with
meantime,
that.
Yep.
in the meantime, Commissioner Bloom has made a motion to accept council's recommendation, and the chair would entertain a second to that
I
motion.
will second that.
Seconded by Commissioner DeChara. Now is there discussion on the motion? If,
I
Ms.
would
Hills.
think that both of them need education.
you have every right to make a motion, a substitute motion that will replace the motion on the floor, if you'd like to do that.
Right.
If we're going to have a consent order that requires education, though, just so you know, because we'd have to outline what the violation was and why we were giving them the consent order. We can't just give them a consent order saying that. So, and that's fine if you want to do that. I'm just letting you know. And also, we would need to then open a complaint against the other individuals because I can't send a consent order on a complaint that I don't have open.
Okay.
And I know that that's kind of complicated and technical, but just to let you know, in your decision moving forward.
But it's another reason why principal brokers need continuing education.
Well, the chair, I can make the argument that there are people using one-page contracts still in the state and don't use FAR
Right.
forms.
They're not
and
required
It's
to
still
use
not a contract until all parties have agreed. So
Right.
regardless of your thoughts on how it was written, we don't have a contract.
Okay.
I'm
ready to vote.
Not there.
A little education too. The broker may have been, grandfather.
He probably was.
All right, is there any
I'm
other?
ready to vote.
Is there any other pertinent discussion before we vote? All right, hearing none, let's vote. The motion is to accept council's recommendation. All in favor of that motion, please vote aye.
Aye.
Those opposed, no. Motion passes unanimously, 29 and 30.
2014-007601, 2014-007602. Complainants purchased a property in state that Respondent 1, affiliate broker, fraudulently concealed known adverse material facts and building code violations. Respondent 2 is Respondent 1's principal broker. Complainants state that Respondent 1 was listed as owner, selling agent, and builder on the sales contract. Complainants state that the primary septic tank system failed within 6 months of purchasing the new home, and investigations reveal violations of state and building codes that deem the property uninhabitable with no use of water facilities and required purchase of another home. Copies of expert statements and testimony, third-party witness statements, and pictures were attached with the complaint. Respondent 1 states that Respondent 1 does not contest that the septic system failed, but states that it was not complete, states that it was completed properly and passed inspection. Respondent 1 states that the house is not a total loss and the problem can be fixed, and an expert's deposition corroborates the same. Respondent 1 states that Respondent 1 is offered to make repairs according to the contract, but Respondent 1 has received numerous letters from complainants and their attorneys instructing Respondent 1 not to attempt anything. Respondent attached documentation, including the purchase and sale agreement, where Respondent 1 signed his owner agent, and special stipulations include that the seller is to provide a 1-year written builder warranty. Respondent 2 responded through an attorney stating that the complaint stems from a lawsuit filed in civil court. Respondent 2 states that complainants retained another licensee with Respondent 2's firm to help them find a home, and complainants decided to purchase a new construction property owned by Respondent 1. Respondent 2 states that shortly after complainants moved in, there were problems with the septic tank, but that expert testimony verifies that the problem should be fixable. Respondent 2 states that after the expert deposition, the parties agreed that Respondent 1 could make repairs, but complainants changed their mind, hired a new attorney, and Respondent 1 was advised not to make repairs. Respondent 2 states that there is a builder warranty, and Respondent 2 and firm did not build the house or create the problem, and no allegations of misrepresentation have been made against Respondent 2 or the firm. Respondent 2 states that Respondent 2 had no knowledge of septic system problems prior to complainants purchasing the home, and there were no defects or problems known that could have been disclosed. Complainants state additionally that Respondent 1 did not disclose adverse material facts, and complainants contend that a deposition from an expert reveals that Respondent 1 chose to ignore state regulations. Complainants state that they requested Respondent 1 fix the problems in February 2013 and April 2013. Respondent 1 states additionally that Respondent 1 did nothing wrong, that it is not possible to know if a septic tank is working properly without someone living in the home, and that the septic tank was installed correctly to state specifications. Respondent 1 states that it is unclear if the problems arose from defects in installation or misuse by complainants because complainants refused to allow Respondent 1 to inspect the tank. Office of Legal Counsel confirmed that litigation in this matter is ongoing, and Respondent 1 and Respondent 2's firm are parties to the lawsuit regarding the subject property. It is likely that further information will be uncovered through the course of the civil litigation, which could be pertinent to the Commission's determination regarding this matter, and therefore the recommendation is for each respondent a consent order for litigation monitoring.
Motion by Commissioner
Second.
Alexander, seconded by Commissioner Franks to accept council's recommendation. Is there discussion? Let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. Motion passes unanimously. Next item.
201400761. This is an anonymous complaint against Respondent, affiliate broker, and the 4 subsequent respondents. The complainant states that a real estate closing occurred. In the HUD statement, a copy was provided, shows that a real estate firm was paid a commission. The purchase and sale agreement, a copy was provided, was written on a contract with a letterhead for the firm referenced on the HUD. Respondent is affiliated with the referral firm, which is not the same firm that received the commission and is listed on the contract letterhead. Complainant states that Respondent misrepresented that Respondent was an independent licensee with that firm. The last page of the contract includes Respondent's name as the independent licensee and the name of the firm where Respondent is not affiliated as the selling company. Complainant also states the complainant searched the other firm's website and noticed several licensees who are affiliated with the referral firm, including Respondent, listed as realtors, and complainant states that the site does not reference the referral firm at all, and the contact information incorrectly indicates that the licensees are affiliated with the other firm. Additionally, the printout states above the heading for Respondent's picture with contact information, realtor info, and Respondent is not a realtor based on a check with the local association. Respondent submitted a response saying that a couple was looking at the home across the street from Respondent's home, and Respondent approached them and identified himself as a licensee and offered to contact the listing agent on their behalf. When Respondent learned they were unrepresented, Respondent showed the home and spoke with the couple about making an offer. Respondent states that Respondent contacted the company owner, who is also principal broker of the other real estate firm, and received the okay to proceed. Respondent states that his wife picked up a sales contract, and Respondent assisted the couple with writing an offer. Respondent states that Respondent should have put the referral firm on the contract instead of the other firm, but believed this was an administrative issue. Respondent denies misleading anyone and states that Respondent never represented that Respondent was a realtor. Respondent additionally states that Respondent is not aware of ever being included on the other firm's website or benefiting from it, and Respondent has another full-time job outside of real estate. When examining the responses relating to the website issue, it appears the consensus is Respondent was not aware of Respondent's presence on the website. However, Respondent's listing of himself as an independent licensee with a company where Respondent is not affiliated appears to be a misrepresentation, as Respondent cannot hold 2 licenses at once, as referenced in Section 6213-309E. The recommendation is a consent order with civil penalty of $500 for violations of Sections Tennessee Code Annotated Sections 6213, 312B1 and 14, and 6213-309E, plus attendance by Respondent at one entire regularly scheduled meeting of the Commission within 180 days of Respondent's execution of the consent order.
Maximum amount.
The maximum amount for B1, which is the misrepresentation issue, is $1,000. 6213-309E just simply states no more than one license shall be issued to any broker or affiliate broker to be in effect at one time. And it's basically just referencing that this person couldn't have been working at 2 places at once. Technically, 14 attaches a $1,000 civil penalty to violation of anything, but I'm not sure if you would consider that. That was more to be guidance in the consent order, that you can't be working at both. So obviously stating you're an affiliate at the one where you are at the firm where you're not affiliated is a misrepresentation. I'm listing that basically to clarify why it was a misrepresentation.
Move to take council's recommendation, except raise the fine from $500 to $1,000.
Second.
All right, the motion on the floor made by Commissioner Alexander and seconded by Commissioner Hills accepts council's recommendation with one amendment, and that is the civil penalty is $1,000 instead of $500. Is there discussion on the motion? All right, let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. Motion carries unanimously. 32.
20140076691. The same complaint as the previous matter states that the anonymous complainant searched through a firm's website and noticed several licensees who are affiliated with another referral firm, including Respondent, who is an affiliate broker listed as realtors, and complainant states that the site does not reference the referral firm at all, and the contact information incorrectly indicates that the licensees are affiliated with the other firm. Additionally, the printout provided states above the heading for Respondent's picture and contact information, realtor info, and Respondent is not a realtor based on a check with the local association. Respondent submitted a response stating that Respondent was unaware of any presence on the firm website reference since moving Respondent's license to the referral firm. Respondent states that Respondent has not benefited from said presence, nor is Respondent advertised in any other manner. Respondent states that Respondent's license is current, but Respondent is not active in promotion or sales for the firm where Respondent's information was listed. When examining the responses relating to the website issue, it appears that the consensus is that Respondent was not aware of Respondent's presence on the website, and therefore the recommendation is to dismiss.
Move to take council's recommendation.
Motion by Commissioner Alexander, seconded by Commissioner Collins, that council's recommendation be adopted. Is there a discussion on the motion? Let's vote. All in favor say aye. Those opposed, no. It's unanimous. It passes. Number 33.
20140077701. The same complaint as the previous two matters states that the anonymous complainant searched a firm's website and noticed several licensees who are affiliated with another referral firm, including Respondent, who is a broker, listed as realtors, and complainant states that the site does not reference the referral firm at all, and the contact information incorrectly indicates that the licensees are affiliated with the other firm. Additionally, the printout provided states above the heading for Respondent's picture and contact information, realtor info, and Respondent is not a realtor based on a check with the local association. Respondent submitted, it just should be one Respondent. Respondent submitted a response stating that Respondent put Respondent's license with the referral firm in 2013, and Respondent does not advertise properties for sale or solicit any property to advertise for sale. Respondent states that Respondent was formerly a principal broker for a larger firm and is aware that all advertising is to be under the principal broker's supervision and include the firm name and telephone number. When examining the responses relating to the website issue, it appears that the consensus is that Respondent was not aware of Respondent's presence on the website, and therefore the recommendation is to dismiss.
Move to adopt council's recommendation.
Motion by
Second.
Commissioner Frank, seconded by Commissioner DeChara, that council's recommendation be adopted. Is there discussion?
How does Miss Anonymous know so much about this firm?
She probably used to work there.
Probably still does.
Maybe.
If they get to work, they wouldn't have to be complaining about everybody.
Thank you for your editorial, Mr. Collins, but we're ready to vote.
We all agree.
All right, the motion is to accept council's recommendation. Let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 34.
20140077711. The same complaint as the previous three matters states that a real estate closing occurred, and the HUD statement shows that a real estate firm was paid a commission. The purchase and sale agreement was written on a contract with a letterhead for the firm referenced on the HUD. Respondent is the principal broker of the firm. Complainant states that the affiliate broker respondent of complaint 201400768, affiliate broker affiliated with another referral firm, misrepresented that he was a licensee with that firm, and the contract included the affiliate broker's name as independent licensee and respondent's firm, where the affiliate broker is not affiliated, as the selling company. Complainant also states that complainant searched respondent's firm website and noticed that 3 licensees, respondents of the previous 3 complaints, who were affiliated with another referral firm listed as realtors, and complainant states that the site does not reference the referral firm and the contact information incorrectly indicates that the licensees are affiliated with respondent's firm. Additionally, the printout provided states above the heading for the 3 licensees' photos and contact information, realtor info, and those licensees are not realtors, based on a check with the local association. Respondent submitted a response stating that Respondent is the owner-broker of the real estate firm. Regarding the sale transaction, Respondent states that Respondent was on duty when the affiliate broker called requesting help. Respondent states that the principal broker for the referral firm was out, and Respondent gave the go-ahead for the affiliate broker to write the offer. Respondent states that the referral firm's principal broker was advised the following morning upon returning. Respondent states that it is unusual for referral agents to write offers, but Respondent did not feel anyone was being misled. Respondent states that Respondent can see now where it should have been made clear with the correct firm name and firm number, and the contract should not have had Respondent's firm heading, nor should Respondent's firm have been referenced elsewhere, and it should have referenced the referral firm. Respondent states that regarding the website, Respondent contracted with a company for design and it was never intended to promote the referral firm or any of its agents. Respondent states that when they were notified that some agents who were not with the firm were on the website, Respondent immediately went to work attempting to remove them, which took some time due to difficulties encountered. Respondent attached emails to this effect, and based on a check at the review of this matter, none of the 3 licensees referenced in the complaint were included on Respondent's firm website. Respondent states that all agents and brokers involved in the complaints were not aware of their presence on the website. The recommendation is a consent order with a civil penalty of $1,000 for violations of Tennessee Code Annotated Section 6213-312B4 and 15, plus attendance by Respondent at one entire regularly scheduled meeting of the Commission within 180 days of Respondent's execution of the consent order.
It's your pleasure. Go home.
We're mad at Miss Anonymous.
The referral firm category is the referral firm category a category by the MLS and not us?
It's just a firm as far as we're concerned. It's just was easier being anonymous for me to try to delineate between the two firms, just for your clarity. It's a licensed
That's
firm.
a licensee they can do whatever any licensee could do.
I believe so. They might have restrictions through the association, but they're as fully licensed as anyone else. It was really just for purposes of, instead of calling them Firm A and Firm B, trying to help you understand.
The other thing is that the place to look to see if someone is licensed is not with the local association. You can have a license at different WCAR, GNAR, you can have them different, you can have in the same office two affiliations.
The reason I checked with the local association was because it said Realtor info, and it appeared that this complainant was alleging that was misleading because these people were not realtors. So I checked with the association to see if they were members. That was the reason for checking with the association, if that makes sense, to see if that was incorrect information, and it appears it was.
I think if I understand, I think when they have the referral companies like that, then they're trying to avoid the MLS and things like that. And it will be licensees and may not be realtors.
You don't have to be a realtor. That's simply a trademark, trade name.
Yes.
Has nothing to do with TREC or your license.
No, the issue for the only reason this realtor issue even comes up for us is because under 6213-312B4, it states that it's a violation to use misleading or untruthful advertising, including use of the term realtor by a person not authorized to do so or using any other trade name. And here it appears these people were listed on the firm website saying they were realtors when they were not. So that's how it kind of crosses over to us in this particular set of circumstances.
Julie, to get this moving, so you're recommending a $1,000 civil penalty for violation of 6213-312B4, which is, again,
misleading or untruthful advertising, because this person claims that they were the one that was basically responsible for the website issue. Then there's also 15, which technically I guess could be, if you went with the maximum, $1,000, and that's failure to supervise because of the contract issue and the wrong firm being on there, because it was this person's firm listed as the selling firm when apparently that was not the correct case. Or
Got a motion?
No, sir, I don't.
You have one now. I move to take council's recommendation.
Second.
All right, we have a motion now on the floor made by Commissioner Alexander, seconded by Commissioner Chara, that this commission accept council's recommendation. Is there discussion on the motion? All right, let's vote. All in favor of the motion, say aye.
Aye.
Those opposed, no. I've got a 7-1 vote, Ms. Maxwell, with Commissioner Collins voting no. Number 35.
201-400-7731. The same complaint as the previous 4 matters states that a real estate closing occurred, and the HUD statement shows that a real estate firm was paid a commission. The purchase and sale agreement was written on a contract with a letterhead for the firm referenced on the HUD. Complainant states that the affiliate broker respondent of complaint 201-400-768, affiliate broker, misrepresented that he was a licensee with that firm, and the contract included the affiliate broker's name as the independent licensee and the firm from the HUD and the contract letterhead as the selling company. The affiliate broker is not affiliated with the firm referenced on the documents, but is affiliated with another firm, a referral firm where respondent is principal broker. Complainant also states that complainant searched the other firm's website and noticed there were 3 licensees who are affiliated with respondent's referral firm listed as realtors, and complainant states that the contact information incorrectly states that the licensees are affiliated with another firm. Respondent submitted a response stating that on a day when respondent was not present in the office, the affiliate broker called for permission to write a contract, and the company owner, the previous respondent, who is also a principal broker, stepped in and assisted. The following morning, respondent states that respondent was apprised of this, and respondent states that respondent was not aware of any issues with the transaction until the complaints were filed. Respondent states that the affiliate broker's use of the other firm's contract and writing the other firm's name on the contract instead of respondent's firm was a mistake and should have been corrected. Respondent states that respondent was not aware of the advertising issue on the other firm's website. When examining the responses relating to the website issue, it appears the consensus is that respondent was not aware of the website. However, it appears that there is a supervision issue relating to the affiliate broker's misuse of firm names on the contract. The recommendation is a civil consent order with a civil penalty of $500 for violations of 62-13, 312B15 plus attendance at one regularly scheduled meeting of the commission within 180 days of execution of the order.
Are any of these overlapping? Are any of these 4 or 5, whatever it was, are they overlapping?
You mean the same
As
people?
I don't want to find somebody for the same thing that's in another,
These are 5 different people, so
Okay.
you don't have repeat people. The
Okay.
first 3 were the 3 affiliates.
Okay.
The last one you heard was the principal broker of the I guess we'll call it the regular firm, the firm that was not a referral firm. This is the principal broker of the referral firm, where the first 3 are affiliated. Does that make sense?
Same firm?
It's 2 firms. There's a
Mr. Chairman.
I've got your motion, Mr. Alexander. Mr. Alexander moves to accept council's recommendation with one amendment, and that is the civil penalty moves from $500 to $1,000.
Second.
Mr. Bloom seconded that motion, so it's on the floor for discussion. Is there discussion? All right, let's vote. All in favor of the motion as amended? No, I'm sorry. All in favor of the motion, please vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 36.
20140093881. This is a TREC open complaint based on respondent's advertising materials. Respondent is a broker received in the TREC office. Specifically, the print advertisement states that respondent will sell a home without a commission if the owner uses respondent to buy his or her next home. Respondent submitted a response stating that for several years, respondent has been offering individuals, I'm sorry, it should be just one respondent. Respondent submitted a response stating that for several years, respondent has been offering to individuals wanting to buy a home but also having a home to sell an opportunity to save the listing portion of the real estate commission. Respondent states that respondent does not charge any fees for listing a home if someone is buying and will promise to purchase the next home with respondent's assistance. Respondent states that respondent explains that they will pay the buyer's agent the typical 3%, but respondent is not paid for the listing. Respondent states that the advertisement explains this, as well as all of respondent's other advertising materials, and there is nothing false, misleading, or deceptive about it. Respondent states that respondent has sold numerous homes and not charged any fees for doing so. Respondent states that respondent attempts to make respondent's business model very clear, and respondent has assisted many distressed homeowners by helping them avoid short sales by lowering their costs to sell. It does not appear that there's a violation by respondent, and therefore the recommendation is to dismiss.
Move to dismiss.
Motion by Ms. Franks, second by Mr. McMullen. So it's on the floor now, Ms. Hill. Discussion.
So, did it say what the commission would be if you don't buy from me?
No, it just says if you do this, then it's free. And there appear to be no further, from the response, there appear to be no further stipulations that weren't disclosed. I'm assuming this person loses out because it doesn't appear that there is a contingency in place for that.
Mr. Chairman, I wonder if we could change the council's recommendation to say that the buyer's agent will be paid 3% instead of typical 3%.
You want to adjust the narrative slightly?
Well, and
Take typical out?
Yeah,
Typical's
I think I was summarizing what that person said exactly, but
I'm sorry, would you say that?
well, I think antitrust people would really like to see that.
wait a minute, I'm not.
In your narrative?
There could be no typical commission.
We really, not that, I think we're endorsing that fact that there's a typical commission, but from our position and licensees across the state, there is no typical commission, even if somebody calls it that.
Okay.
So if you could just strike, this is just a strike the word typical from your narrative.
Sorry.
That's-
That was
that's-
just a summary of the actual response.
That's perfect.
so-
It's just overabundance of caution.
Okay, got it.
Have we
I
voted?
understand.
Question.
Question's been called for. Is there any objection to the call? Hearing none, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. 37.
014009421, a complaint was opened against respondent principal broker on a failure to supervise issue regarding the advertisement of the previous respondent broker in complaint 201400938 broker. Respondent submitted a response stating that the broker moved to respondent's firm earlier this year and was welcome because the broker has consumers' best interest in mind in this advertising campaign. Respondent states that respondent has spoken with the broker numerous times about real estate and advertising, and respondent has monitored advertising. Respondent states that it is respondent's understanding that TREC is in place to protect the consumer, and respondent does not feel that this ad harms the consumer. Respondent states that respondent took the ad to 5 different consumers and asked them to describe what was being advertised, and respondent included the consumers' written responses. Respondent does not believe that the ad is misleading or deceptive. Respondent states that respondent understands that some agents have advertised just to make phones ring, but states that that's not the case with this ad and this broker. Respondent states there is no fine print or bait and switch. Respondent attached documentation including positive feedback forms from clients who utilize the program and MLS listings and HUD statements from multiple properties showing that the broker received no commission. It does not appear that there's a violation by respondent. Therefore, the recommendation is to dismiss.
Move to dismiss.
Second.
Let's see, who wants credit for that motion?
Doesn't matter.
Okay, just checking. Ms. Franks made the motion, Mr. Chara seconded. Doesn't matter, right? It doesn't
I
matter.
seconded, but I don't know.
It doesn't matter. You said it didn't matter.
Question.
All right, let's vote. All in favor of the motion, say aye. Aye. Those opposed, no. Motion passes unanimously. 38, 39, 40, 41, 42.
2014013-481, 2014013-482, 2014013-483, 2014013-484, 2014013-485. Complaint opened by staff based on an advertisement submitted anonymously. The ad references a cashback program they're utilizing a relocation services program for certain individuals. The complaint references contacting respondents 1 and 4, affiliate brokers, for additional information. Respondent 2 is their principal broker, and respondent 3 is the firm. Respondent 5 is an unlicensed individual whose contact information as part of the relocation department is listed. Respondent 2 submitted a response on behalf of respondent stating that the program flyer provides general details regarding programs offered for certain individuals who are part of certain groups which provide those individuals with benefits. Respondent 2 states that the company helps those members in the home sale and purchase aspects. Respondent 2 states that the program offers a cashback program which is paid directly from the group's administrator, not the real estate firm or an agent. Further, Respondent 2 points out that the ad states, in Tennessee, the cashback bonus is paid in the form of a gift card. Finally, Respondent 2 states that Respondent 5 is the relocation manager of that division, and Respondent 5 does not sell or list property, negotiate contracts, or counsel buyers or sellers about real estate. It does not appear that there's a violation by respondents, and therefore the recommendation is to dismiss.
How can you, as an affiliate, issue a check unless it's your personal check?
Check, I'm sorry. Well,
Or rebate or give back?
they're listed as the contact people in there. They said it is not, it was a firm advertisement. It had the firm name on it as well.
But the firm is uninsured?
No, the
Number 40?
I don't believe the firm has E&O insurance, but
Uninsured.
they don't have
Firms
to.
don't have to. Okay.
Let's get a motion on the floor.
Move to accept.
Second.
Got a motion by Commissioner McMullen, seconded by Commissioner Collins, that this commission accept council's recommendation. Further discussion. We'll vote. All in favor of the motion, say aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 43.
2014013-631, complainant alleges that respondent, unlicensed individual, is renting mobile homes, and respondent is not the owner and does not have a license. Complainant states that respondent negotiates the deposit and collects rents. Respondent did not submit a response to the complaint, and the complaint which was sent to respondent was returned unclaimed. There does not appear to be documentation showing that respondent is performing the activities alleged. Furthermore, it does not appear to legal counsel that the definition of broker within TCA section 6213-102 includes mobile homes. So the recommendation is to dismiss.
Motion by Commissioner Alexander, seconded by Commissioner McMullen, that council's recommendation be accepted. Question's been called for without objection. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. 44.
20140137191. Complainant, a licensee, filed this complaint based on information from a former client. Complainant states that respondent principal broker arrived to show complainant's client's property per an appointment through the showing system, and the client observed from next door and saw respondent arrive alone, put on gloves, and enter the home. The client apparently contacted police regarding an investigation of missing property and computer hacking. Complainant had no other knowledge other than what was told to complainant by the client, and there was no other information provided. The homeowner client did not wish to discuss the matter with staff, did not want a complaint filed, and only wanted police involved in the investigation. Respondent submitted a response stating that respondent was previewing the property for a client who had hired respondent because respondent is also a general contractor. Prior to the preview, the area had experienced hailstorms, and respondent states that respondent was doing a hail damage check. Respondent states that respondent put on gloves as usual, then observed that the lowest gutter was too high to reach, and the homeowner apparently saw this and drew wild conclusions. Respondent states that the police report showed that nothing was missing from the home and mentions nothing of computer hacking. Respondent states that there was no wrongdoing and no violation.
Second.
Mr. Alexander moves that we accept council's recommendation, and Commissioner DeCharo seconds that motion.
Call for the question.
Question's been called for. Is there any objection to the call? Hearing none, let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Next item.
201401451. This complaint was opened by staff based on information filed anonymously, which consisted of a screenshot from a sheriff's office warrant search website. The screenshot indicated that respondent, affiliate broker, had warrants for 2 criminal charges. A legal counsel recommends a dismissal of this complaint. In a previous complaint against the same respondent, as part of the complaint allegations, that complainant had already provided information indicating these same criminal charges. At that time, the Office of Legal Counsel researched the issue and found that the charges had been dismissed. Therefore, this appears to be not only duplicative to the...
Motion by Commissioner Alexander, seconded by Commissioner Franks to accept council's recommendation. The question has been called. Is there an objection to the call? Hearing no objection, let's vote on the motion. All in favor say aye. Those opposed, no. It passes unanimously. Next item.
201401471. Track open complaint based on information received by staff from respondent's unlicensed company website. Respondent's website printout appeared to advertise a home located in Tennessee for absolute auction. It appears that respondent obtained a license as an auction firm but did not have licensure with Trek. Respondent submitted a response through its CEO stating respondent performs no brokerage activities or work which requires real estate licensure, and respondent works merely as the marketing arm of the seller and broker and works solely under their direction. Respondent provided the names and license numbers of a real estate firm and real estate licensee who respondent states are performing all licensed activity work. When it came to respondent's attention that the person auctioning real property must be licensed as both an auctioneer or an apprentice, both as an auctioneer or an apprentice auctioneer and as a broker or an affiliate broker, respondent contacted all advertisers to immediately cease promotion of the property. Respondent states that the auction has been canceled and respondent will no longer promote the property or auction until the respondent is in compliance with Tennessee law. The recommendation is a letter of warning regarding definition of broker, which is 6213-102 4A and B, and 6213-103 and 301.
Is there a motion?
Move to take council's recommendation.
Mr. Alexander moves that we accept council's recommendation. Commissioner DeCharo seconds that motion. Is there discussion? Let's vote. All in favor of the motion, please vote aye.
Aye.
Those opposed, no. Motion passes unanimously. That ends this portion of Ms. Kropp's report. Once again, kudos for putting first that together and second reading it to us over the last 3 or 4 hours. It's spectacular work. Thank you. Council, do you have anything for us today, or are you just dropping by?
Dropping by.
Well, we're glad to have you, for sure.
I think Julie has a second career as a TV and spokesperson, auctioneer.
It's good work. Julie, you also have a consent order log that you want to just mention?
That is on your iPads for your review. This is my tracking mechanism for complaints which have been presented to you all, authorized for a consent order, and then either the page that you have represents the ones that are outstanding and that have been moved over to litigation for folks that haven't accepted it. It doesn't have any names or anything on it, but it's just basically so that you know that I'm keeping track of these and moving them along. And if you have any questions, you're more than welcome to ask, but it's really just more for your information to let you know that the things you authorized last month were sent out and kind of how they're moving.
Do you have any other items to report?
No, just that those rules should be getting put up on the website anytime now, and anybody that signed up for Notify should receive those. The link will be on our website. Check the Secretary of State. It should be up soon, so.
But we're expecting rulemaking hearing in November.
November 5th, beginning at 9:30 is what I put on the
Will
time.
we then have our regular meeting on the 6th?
Probably after we finish the rulemaking hearing on the 5th, assuming it doesn't take all day.
I think we probably need to plan on carrying part of that over to the next day.
And I'm not sure if Robin has a hearing scheduled the second day, so we might be short on regular business that month, depending upon that. I'll check with her and let her know if she doesn't have anything calendared that's.
Rearranging.
Ms. Maxwell, do you have anything else today that you'd like to bring before commission?
This is, I don't know if they've met you. No, they're probably not. This is the chief, I'll let you introduce
I'm the general counsel.
You don't need to stand for us, I promise you.
It's all right.
Please hit.
My name is Nancy Jones. I'm the general counsel of the Department of Commerce and Insurance. Julie does a great job for us, and we
Don't be
appreciate it
think-
very much. And I know that you have a new member today, and there was a question that she escapes.
Yeah. Well, thanks for coming down. We appreciate you,
Thank you. It's
your
nice to meet you
attendance.
all.
Commission, so I'm assuming staff is done. Commissioner
all I have.
Alexander, do you have any final words of wisdom on our way out? Okay, would you give them to us?
It is so nice to have a pleasant new commissioner on board.
As opposed to that old bear?
Yeah, thank goodness he's gone after 10 years, and I'll be
Thank
next
you.
to go. And that and Grover and I.
Commissioner Bloom, anything?
Well, Bear did a great job, and we're just teasing him because everybody knows and loves him. But we do welcome Diane. She's just an excellent addition to our commission.
Commissioner DeChara?
Well, I would also like to say welcome to Diane. We're glad to be working with you and look forward to serving with you for a long time to come, so.
Ms.
And we
Franks?
will miss Bear.
Yes, we will miss Bear. He's done a great job. And Diane, we're so glad to have you with us, too. It's been a long day for your first day. Yeah.
Austin? Diane, do you want to say anything?
Be nice if Bear was sitting here.
All right.
Just so proud to be here.
Two items, please. First of all, if you were paying close attention today, you notice that principal brokers are cited almost as much as individual licensees because this commission firmly believes in supervision by principal brokers. Second of all, on your way out, you're going to have to sign out, and I hope are those papers back there, Travis? Okay, on your way out, sign out. Don't trample each other doing it. Are there certificates back there too? Oh, Kimberly's got the certificates. You need to pick one of those up as well. Thanks for attending. Be safe going home. Don't come back for a while.
Yes. Are we adjourned?
We're done. We're adjourned.
Thank you for coming down to talk.